Okay, good morning. Please be seated. All right, Mr. Ng, you may cross.
Morning, Sergeant Peterson.
Morning.
My name is Paul Eng. We met once before. I have some questions for you on behalf of former Officer Potter.
Okay.
You started your testimony yesterday by discussing why you became a trainer.
Yes.
And one of the reasons you mentioned yesterday was that you wanted to be safe.
Correct.
Safe meaning your own safety, correct?
Mine and that of my partners.
And you wanted your fellow officers on the street to be safe.
Yes.
And you also wanted to be wanted the community to be safe that you serve.
Yes.
Okay. And specifically, you've trained officers so that you can trust what they do in times of need, your need, the needs of other officers as well. Is that correct?
Correct.
You're training them to make a split-second decision
Yes.
in what can be very dangerous circumstances.
Yes.
Okay? And you're training them to, if you were at risk, that you would want them to be making an instant decision on your behalf. Is that correct?
Can you repeat?
You'd want them to make the right decision for you if you were in harm's way, right?
Correct.
Which is a key motivation for you.
Yes.
And the purpose of training is many things, but one of the reasons you train is that police work is risky.
Correct.
You're dealing with a public that sometimes can be very dangerous,
Yes.
can be armed,
Yes.
and can be unpredictable in their behaviors.
Yes.
And there is a need then to react quickly to what an officer sees. Is that correct?
Correct.
And what you train in an omnibus way is for them to be to have the tools they need to respond. Is that correct?
Correct.
To respond quickly,
Yes.
and then you leave them with a certain amount of discretion to make that decision depending on individual circumstances. Okay?
Absolutely.
Now, Officer Potter attended your classes that you've described. Is that correct?
She has.
She was an attentive student, right?
Yes.
She fully participated in all your scenarios. Is that correct?
Yes.
Okay. She didn't miss any of your classes or skip out.
If she missed them, she wouldn't have been on a roster,
But-
and then she would have had to make up that training.
Yeah, but if she's on your roster, she attended.
Correct.
And you knew that she was an FTO, is that correct?
I did.
And an FTO is a field training officer,
Yes.
and the field training officer on the street has a number of duties, is that correct?
Yes.
And there are a lot of things. There are a lot more things going on for a field training officer than just an officer on the street ordinarily. Is that correct?
Yes.
I mean, you have this is obvious to you, but you have supervisory capacities, right?
As a field training officer, you certainly do.
You have the evaluation capacities, right?
Yes.
And all of a sudden, you have two officers on the street thinking perhaps different things.
Correct.
Now, this Taser 7 that we've talked about, this was a new product, was it not?
For our department, yes.
And it just came out. You just bought some, right?
Yeah, we had just purchased them in the beginning of 2020.
And,
I'm sorry, 2021.
2021. You have no evidence that she ever used the Taser in the field, do you? You certainly know about it if she did.
I would know about it if she did, yes.
And you have no evidence that she did, right?
No.
But these new Tasers were in working order.
They were?
And I assume they're like every other new product. There are certain advancements or improvements compared to the old product, right?
That's the reason we would have gone to a new product.
And would it be fair to say that the battery capacity of the new Taser would be at least similar or better than the older Taser in play? Is that correct?
Better.
And the battery capacity lasts a while, does it not?
Yes.
I mean, it doesn't need to be charged every day,
It does not have to be, no.
especially if it's not used. Is that correct?
Correct.
And the last training that she received on the Taser 7 was on March 2nd.
I believe so. That was the date that she was there.
But she didn't get her gun until later in March, like the 26th, according to the records.
Do you mean a taser?
Yeah, the taser, I'm sorry.
Yeah. It wasn't until a little bit later that month that we were actually able to deploy the tasers to the field.
She was the first one to get it, right?
One of a group, I believe.
And by contrast to the new taser, the firearm that she had was a semi-automatic,
Correct?
a Glock.
Yes.
And that Glock has been around the police world in which you have it for decades now. Is that correct?
The product has been around for a really long time. That specific one, we had changed out to a new fleet of handguns in 2012, I think it was.
Okay. So she'd had that gun for almost 10 years.
Around that, yeah.
And it was the same kind of gun.
Similar
I
in
mean,
function.
it's not
yes.
an electronic gun. It's just a handgun. I don't say just a handgun. It's a handgun that's built similarly for the last decades, 20, 30 years ago.
Yes.
I mean, they used this kind of mechanism in World War II.
Yes.
And that was the Glock, or a similar gun to the Glock, that she had been trained on repeatedly by you and by the department. Is that correct?
Yes.
It's the Glock that she had on this person that she went to the firing range on a regular basis. Is that correct?
Yes.
And did all the other trainings that you had with her. Is that correct?
Yes.
Now, the training that you have in tasers is such that you try to get close to what it's like in real life to use them and what the officers face. Is that correct?
As close as we can in the training session, yes.
But you never can quite reach that level, of course, right?
Never will be able to.
Okay. So you do the best you can do.
Correct.
Okay. I mean, you can't, for example, replicate a car taking off.
That would not be safe in a training environment.
You can't replicate an officer who is inside a car that might take off. Is that correct?
Not practically. In talking about it, we do, but
Yeah,
not.
but you'd never put someone in harm's way during training, obviously, right?
No.
Okay. And you know from your training, you tell the officers that every response by the individual officer will be unique, right?
Can you say that again?
Every officer will respond in a unique way to the training. Is that right?
Correct.
I mean, everyone has different blood pressures that go up, right?
Yes.
Everyone has different reactions to adrenaline.
Correct.
And officers see different things at different times during your training exercises, right?
Absolutely.
And even during all your training, you recognize that certain officers take different routes and exercise discretion differently. Is that right?
Correct.
And there may not be any one right answer.
Correct.
In fact, some of your training exercises are designed so there may not be a right answer.
Yes.
And lately with COVID, it's been difficult to have in-person trainings. I think you mentioned that yesterday.
It has been extremely difficult.
I mean, you used to use volunteers, as I understand it, strangers, so that the officers wouldn't know who they are, right?
Not strangers, but civilians in our department.
Okay. But that's not really possible nowadays.
We're getting a little more back to normal, but still not where we were 2 years ago.
But even earlier this year, it wasn't advisable.
No.
Okay. And that's why you had a training session on March 2nd involving you as a
Correct.
subject, because it was the safest thing to do in light of COVID and the restrictions you were under. Is that correct?
Yes.
And you talked about scenario training yesterday.
Yes.
Scenario training would be where the officers are required to react to a certain situation where there's a person. Isn't that right?
Yes.
And you yourself on March 2nd created 2 scenarios where the officers would react. Is that right?
I did.
And it's the only training on a scenario that was given for the TASER 7. Am I right about that?
Can you rephrase?
Was March 2nd the only training given on the TASER 7?
Yes.
Okay. So you were the person who was acting in such a way that would provoke a police officer to decide to do something, right?
During the scenarios, yes.
And I think one of them was you came out of a closet or some doorway with a club in your hand. Am I right about that?
It was a bat.
It was a bat. And then you motioned the bat towards the officer and they had to decide what to do, right?
Correct.
Whether it be a taser or a gun, right?
Or any of their other tools that they had on their person.
Okay. And some of the officers shot you with a taser,
Some did.
some shot you with a gun.
None shot me with a gun.
Okay. But in any event, the exercise was the best you could do, but the officers knew who you were,
They did.
and a lot of them are friends of yours.
Yes.
It's a tight-knit department,
Very.
and they knew that you weren't going to try to kill them.
Yeah.
They knew you weren't going to take flight.
Yes.
They knew you weren't high.
Correct.
They knew you didn't have a bench warrant.
Correct.
They knew you didn't have a gun.
A real gun, yes.
And they knew you didn't have an access to the gun around your person.
Correct.
And they knew that you weren't going to use a gun. Real gun.
Yes. Okay.
And they knew you weren't going to hurt them.
Correct.
Now, one of the things you do in training is talk about the policies of your department. Is that right?
Some of the policies, not all.
And yesterday we talked about the taser policy, which is number 304.
Yes.
Okay. And I don't think I need to show it on the screen, but I do want to ask you some questions about it. That was Exhibit 334.
Okay.
Okay. And you've almost memorized this, haven't you, over the years?
Not verbatim, but I have a general idea how to put it in practice.
I mean, you've talked about this hundreds of times.
Yes.
And the early part of the policy is at 304.3, and it says the officer shall, the verb is shall, only use a taser device that has been issued by the department, right?
Correct.
So you want to control what they use. They can't buy their own.
Correct.
And then also in that section it says the officer shall carry the taser device on the reaction side. Is that right?
Correct.
And then in the middle, we've had a discussion here. It said members, quote, members carrying the taser should perform a spark test on the unit prior to every shift. Is that correct?
Correct.
Okay. A should is the verb, and it differs from shall as a verb, right?
Yes.
Okay. And should is an aspirational verb. And in other words, you encourage the officers to test and do a spark test before every shift, right?
Correct.
It doesn't always happen.
It does not.
And there are a lot of things going on. In fact, we have testimony that on 4 of 6 shifts it didn't happen with Officer Potter, right?
Correct.
And it hasn't happened with other officers, too.
Correct.
And you're not, she was never reprimanded, or you never talked to her, for example, about, well, do a spark test. You missed a couple, I assume.
The objection is overruled. You may answer.
Can you repeat the question?
Well, I mean, did you ever talk to her about missing a couple spark tests?
No.
I mean, that's not something you usually talk to the officers about.
No.
Okay. And the fact of the matter is the machine worked. I mean, the gun worked. The taser worked, right?
Yes.
Okay. And also in this section 304, you talk about verbal warnings that must be given to the subject who may be tased. Is that correct?
Yes.
And the idea here in the policy is the individual should be warned, if possible, that a taser may be employed. Is that correct?
Correct.
In fact, it says a verbal warning of the intended use should precede its application, right?
Correct.
It doesn't say shall, it doesn't say required, right?
Correct.
And the reason you do a warning, you teach everyone, including former Officer Potter, is that you want to provide the individual with notice that something may be happening, right?
Yes.
I mean, you've been tased, it's painful.
It is.
You don't want to repeat it.
Correct.
It's designed to disable you.
Yes.
And even a big guy like you were disabled temporarily.
Yes.
So the reason you give a warning is to provide the individual with an opportunity to comply, right?
Correct.
I mean, the hope is that they will.
Always is the hope.
And then you want to provide a warning that it may indeed be deployed. Isn't that correct?
Yes.
So a typical warning that you teach is "I'll tase you." I'll tase you.
Correct.
And it's said in a vocal, loud way, so the subject will understand what you're talking about, right?
In plain English, yes.
So it's consistent when someone's going to use a taser to say, "I'll tase you, I'll tase you."
Yes.
That's what the department wants someone to do.
It's one of the many things that we teach them to say.
And then there's a section on application of the taser, 304.5.1, that permits the use of the taser or suggests the taser can be used, right?
Yes.
Under certain circumstances.
Yes.
And one of the circumstances is if the subject is violent
Yes.
or is physically resisting.
Yes.
I mean, if someone is resisting a cuffing and attempts to get back into a car, for example, that person can be tased.
Yes.
Or you can also tase, according to your policy, not you, but an officer that you train, if the subject has demonstrated by words or action an intention to be violent. Correct?
Correct.
Or to physically resist. Right?
Yes.
Or if that person is a potential harm to others.
Yes.
So all those factors can be considered
Yes.
in employing the taser.
In a very short amount of time.
In fact, the decision. I'm glad you mentioned that the decision to use a taser is really quick.
The decision to use any.
The objection. Well, I'll let the answer stand. You can finish what you were going to say.
Any use of force has to be made in a very short amount of time.
But what you don't want to use a taser if someone's physically running away from you necessarily.
Necessarily, but it's not an absolute no.
Okay. And you don't want to use a taser if a car is moving.
Correct, moving.
But if a car, on the other hand, is stationary.
We've used it many times on people inside vehicles that are stationary.
And one of the things you teach is whether the individual has, quote unquote, control over the motor vehicle, right?
Yes.
And the rule that you teach, I think, and you tell me if I'm wrong, is that if the individual doesn't have control over the car, the taser would be appropriate.
It certainly could be depending on the circumstances.
And again, you rely on the officer's discretion to make that decision.
Yes.
Now, we also heard a lot of testimony about taser warnings. One of the warnings was in Exhibit 270. You recognize this kind of thing, don't you?
Yes.
Okay, you've seen this dozens of times.
Yes.
And this is a warning that's issued by the taser manufacturer, as I understand it.
Correct.
It's made by Axon, is that right?
Yeah, that is the company that distributes the taser products.
And they warn about all sorts of things that can go wrong when you're using a taser.
Lots of things.
And this purpose of this warning that you showed us yesterday is to have the person undergoing training release the taser company from liability in case something goes wrong during training using the taser.
That specific document?
Not this specific one, but in general, that's why they sign these releases, right?
That's why they sign the training form that I then sign later certifying that they can carry a taser.
So the training form not only recognizes their completion of treatment, but releases the taser company from liability during the training.
Correct.
And one of the warnings of this document, 270, that we saw is that there can be a confusion between a taser and a handgun.
Yes.
And there is a recognition, thus, by the company that makes these things that there can indeed be a confusion between the two.
Yes.
Otherwise, why warn you, right?
Right.
And there have been confusions between tasers and guns
Several.
across the country.
Yes.
And in fact, the taser is shaped, at least on a handle basis, like a gun, right?
It is.
It has a trigger, right?
Yes.
The handle may be smaller, but it's
Yes.
still a gun handle,
To fit into a hand, correct.
especially a smaller hand.
Any hand.
And one of the reasons the taser manufacturer releases or wants all these releases is that they know, and you know from training, that mistakes can happen.
Correct.
Mistakes can happen during training when someone is trying to use a taser.
Yes.
And mistakes can happen when someone confuses a taser with a gun.
Correct.
And it can be an innocent mistake.
Certainly can be.
The objection is sustained. And the answer, the jury will disregard that asked question and answer.
And in every training exercise you do, there are these release and warning requirements. This is Exhibit 369 from yesterday. Do you see this? You recognize this, don't you?
I recognize it, yes.
I mean, this is by it's a training and warning requirement that is insisted upon by Taser, the Axum Enterprises that makes it, right?
Correct.
In fact, you are constrained during training to do exactly what Taser wants you to do.
Exactly what they want us to do.
And that's a precondition of even owning or using the Taser itself, right?
I'm not sure if it's a requirement of owning it, but it is a requirement of us going through instructor training.
Okay, got it. Now, you also teach in use of tasers and use of force of the various statutes from Minnesota, do you not?
I do.
And I've looked at your training materials, and one of the statutes referenced is Minnesota Statute 609.06. Is that correct?
Yes.
Okay, that's the statute that permits reasonable force to be used in making towards an individual under certain circumstances. Isn't that right?
Of an officer and other people in the state of Minnesota, yes.
But it's designed to give some clarity to what an officer can do vis-a-vis a reasonable force.
Correct.
And it gives criteria or examples of what can be used in reasonable force by the officer, right?
Yes.
And you teach this,
Yes.
almost with your eyes closed,
Depending on the day.
after all these years.
Yeah.
And the statute says that reasonable force may be used towards a person without the other's consent when the following circumstances exist or the actor reasonably believes them to exist. And the circumstances include, for a police officer at least, in effectuating a lawful arrest. Correct?
Yes.
In the execution of legal process.
Yes.
In the enforcement of the order of an order for the court. Is that correct?
Correct.
Such as a bench warrant.
Yes.
Or in executing any other duty imposed by the public officer by law. Is that correct?
Correct.
So you can use reasonable force to make an arrest if
Yes.
the circumstances permit, correct?
Yes.
Objection has to be answered.
The objection is overruled. I'll let the answer stand.
And you can use reasonable force to enforce an order of the court.
Yes.
A bench warrant is an order of the court, right?
Yes.
Directing you as a police officer to make an arrest of the individual.
Correct.
I mean, a judge has directed you to do that.
Yes.
And as a part of your obligations as a police officer, you're to honor that bench warrant.
Yes.
You just can't close your eyes to it.
No.
And then there are criteria according to your outlines, which I've read too, on the factors to be considered when you judge what a reasonable force should be used. And one of the factors is the threat, the possible threat of the arrestee, right?
Correct.
How fast it occurs.
Yes.
Whether the arrestee is high or impaired.
Yes.
The seriousness of the offense.
Yes.
By the way, is fleeing a police officer a felony in Minnesota
It depends how they're fleeing.
in a car?
That is a felony.
Is it in Minnesota a dangerous offense in your view?
Objection, Your Honor, foundation.
The objection is sustained.
Well, does fleeing a police officer at a high rate of speed suggest to you a certain amount of dangerousness?
Objection, Your Honor, relevance and foundation.
Well, the objection is overruled. You may answer that.
Can you repeat?
Well, does fleeing an officer in a car at a high rate of speed suggest to you a certain amount of dangerousness?
Yes.
And why is that?
It puts the person driving that car, the officer, and the general public at risk in their attempts to evade the officer.
And the public's at risk because, as you've seen in your career, the individual fleeing a police officer can crash.
Yes.
Often does.
Frequently.
Kill somebody.
Can.
And that's why it's so dangerous.
Yes.
And it's important in making an arrest to prevent that sort of thing from happening.
Yes.
That's your obligation as a police officer, right?
Correct.
Now, you also teach another statute on the use of deadly force. I know you're here for taser, but I want to ask you a couple questions about it, all right?
Sure.
And that's statute 609.066, is that right?
Correct.
And that permits the officer to use deadly force under certain circumstances. Yeah?
Correct.
And you teach this.
We do.
And the circumstances involve an apparent risk of if there's an apparent risk of great bodily harm or death
Yes.
to the officer herself or
Yes.
himself, right?
Yes.
To the other officers on the scene
Correct.
or the community nearby.
Correct.
And if there is an apparent threat of death or great bodily harm, deadly force can be used to prevent an escape or facilitate the capture.
Can you repeat?
If there is an apparent risk of great bodily harm, can deadly force under this statute be used to effectuate an arrest or prevent an escape?
Yes.
And when you evaluate the use of a deadly force, you teach that it's a decision that's made right there and then.
Correct.
It's not the subject of hindsight.
Correct.
It's not whether someone would have done something differently after the fact.
Correct.
It's not the subject of a 20/20 vision.
Correct.
And it's a decision that's made under rapidly evolving circumstance, right?
Yes.
That's right out of Graham versus Connor, which you teach too.
Correct.
And finally, the decision is made at the very moment the force is used. Is that correct?
Yes.
And it's what was known to the officer at that moment.
Correct.
You also teach that the stressors involved in critical incidents, as you mentioned, vary from officer to officer, right?
Could you repeat that?
The stressors vary from officer to officer.
Correct.
One officer may freeze, for example.
Hopefully not.
You train not to, right?
Correct.
You train action.
Yes.
You train make a decision
Yes.
at the spur of the moment.
Yes.
Even if it's the wrong one, you make a decision.
Yes.
Because if you wait, that can be deathly too.
For multiple people.
Now, you have not in your capacity as a witness, seen any of the videos in this case, I think, right?
Only small snippets months ago.
All right. So, in fact, you haven't wanted to because you knew you were going to testify as a trainer.
Correct.
Okay. So you didn't want that to be in your brain, so to speak.
Correct.
And you knew it, once you saw it, it wouldn't leave you
Yes.
because you knew everybody here. You knew everybody in the video.
Very well.
Now, but you do teach officers that, you know, where there's a warrant for a gun charge, they should make the arrest. Am I correct? If there's a bench warrant?
Can you say that again?
Where the suspect has a bench warrant for a gun charge, they should make an arrest.
Yes.
They can't let him go.
No.
You also teach that when a gun is involved on a bench warrant, that the officer should be vigilant about another gun being in the car at issue,
Absolutely.
or a gun being on the person. Is that correct?
Yes.
And you train this over and over again, right?
Yes.
Because stopping someone in a car is one of the most dangerous things you can do.
Yes.
And police officers who aren't vigilant and are not aware of the dangers can be shot.
Yes.
Have been
Yes.
in Minnesota.
Yes.
Just because a gun isn't found later in the car at issue doesn't mean the officer's interest in or belief a gun is there is invalid, though.
Objection, Your Honor. Relevance?
The objection is overruled. You may answer.
You want me to repeat that?
Please do.
Just because a gun isn't found doesn't mean to you that the officer's interest or belief a gun may be in the car is invalid.
It would not be invalid.
And just because the arrestee doesn't have a gun on his person, the officer is still reasonable in his belief or her belief that a gun may be there, or a gun would have been there, or could have been there.
They'd be reasonable in that belief. Yes.
And you also teach during all these lessons that you have is that there are certain community interests in play in making arrests.
Yes.
And one of the interests in the community is the safety of all the innocent citizens, right?
Correct.
Of course, it is to prevent harm to the officers.
Yes.
That's a community interest.
Yes.
It's to ensure public safety.
Yes.
It's to ensure a driver who's not supposed to drive doesn't drive anymore.
Yes.
I mean, you got to have a license to drive.
In the state of Minnesota, yes.
It's unsafe to drive without one.
Yes.
It's unsafe to drive without insurance,
Yes.
because that's a requirement too, right?
Of the state, yes.
And another community interest is to validate court orders, right?
Yes.
If a guy's not supposed to be on the street, he's got to get off the street.
If that's what the court said, yes.
Is the use of a taser a form of de-escalation, in your view?
Yes.
Meaning that instead of, it can de-escalate the situation by incapacitating the defendant or the suspect, right?
Or other ways, yes.
So you're taught to use the taser to de-escalate a situation, fair?
Yes.
You're also taught, you also teach that you can't always predict the arrestee's behavior.
Correct.
Now I want you to, I know you haven't seen the video, but I want to give you a hypothetical and ask whether the use of the taser would have been appropriate, okay?
Okay.
Let's suppose that an individual's driving a car. He is stopped for legitimate reason. Let us further suppose that when asked for a license, the individual doesn't have a license. He doesn't have any identification. There's no insurance current on the car. Let's further assume that the individual has a bench warrant for a gun charge, and let's assume further that there's an order for protection against him, and then there's a female in the car, and a female is listed on the order for protection. Okay? And let's assume further that when the individual police officer in my scenario tells the individual to get out of the car and tells him further that he's under arrest, and the individual resists arrest. And the individual is told by another officer on the scene, I'll tase you, I'll tase you. The individual climbs back in the car that's stationary, but attempts to engage the car. It is not moving. Under those circumstances that I've outlined for you, would it be reasonable for an officer to fire a taser to stop this individual?
Your Honor, I'm going to object on calls for speculation, foundation.
The objection is overruled, and you may answer.
If that
You also teach, I've got a couple more questions for you. I appreciate your answers. You also teach that mistakes can happen in police work.
Objection, Your Honor.
The objection is overruled. You may answer.
mistakes can happen in every part of our world.
Accidents can happen.
Yes.
They're part and no matter how hard you train, no matter how hours you put into it, policing and living is a human endeavor.
There are too many variables to have planned out in advance to be able to eliminate that forever.
And we're all engaging in the endeavor of living imperfectly.
Correct.
But when someone, like a police officer, yells out taser, 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 and shouts at a suspect, does that indicate to you that a taser is about to be used?
Yes.
You've known Officer Potter for 15 years.
If not longer.
And you're familiar with her character and reputation in the community.
Yes.
I mean, you've watched her, worked with her. It's a close-knit community, right?
Yes.
Does she have a reputation in your community for being peaceful?
Objection, Your Honor.
The objection is overruled.
Can you repeat?
Pardon me?
Can you repeat?
Does she have a reputation in your community for being peaceful or having the trait of being peaceful?
Yes.
Peacefulness. Does she have a reputation in your community for having the character trait of being law-abiding?
Yes.
Yes, she does. May I have a moment?
Yes.
Thanks a lot.
All right, redirect, Mr. Frank.
Thank you, Your Honor. Thank you, Sergeant Peterson, for coming back again this morning. You were
It's not part of the curriculum, but when officers do things in training that may not be what they wanted, we retrain that. So I would classify that as being an accident. It's not something that they wanted to have happen.
and then you would correct that, you would address that?
Yep. We during our debrief, we would talk about what they didn't like about it, and then give them an opportunity to put a positive training scenario conclusion into their brain.
During this training on March 2nd of this year, you did this scenario and with the bat, correct?
Correct.
And you said nobody shot you with a gun, right?
Not for that specific part of the training.
And did anybody draw their gun, saying that they actually meant to draw their taser?
I do not recall.
And I think, well, in that scenario, as with all scenarios, they know they're being assessed, correct?
Yes.
And they're being assessed on whether their behavior is in accordance with reasonable expectations of the department about how an officer should react in situations.
Based on state law and policy and court cases, yes.
You were asked about driving without a license and driving without insurance. You have any idea of how many times you've stopped people on duty in Minnesota that did not have a license?
Objection beyond the scope.
The objection is overruled.
You may answer.
How many times I've stopped somebody without a license while working as a police officer?
Correct.
That's the question. Hundreds.
And how many times have you stopped people and found out they did not have insurance?
Hundreds.
Do you recall, how many times in those hundreds and hundreds of those stops they were driving unsafely?
I didn't hear the last word.
That the drivers that you stopped had been driving unsafely.
That'd be really hard for me to put a number on over a 16-year career.
I'm trying to figure out. So I'm trying to figure out, what it is about not having insurance that means they're an unsafe driver.
Would depend on the driver, I guess. I mean, there'd be specific circumstances for that stop, but generally, I have seen that people who don't have a license and insurance don't follow the rules of the road the way people who do have a license and have insurance do.
So when you're stopping somebody, you don't know if they have the fact of insurance alone doesn't make them unsafe.
No, and that's not something I know before the stop.
You were asked about de-escalation, correct?
Yes.
And de-escalation is, in fact, something you teach as part of the training of officers in Brooklyn Center.
It's something we teach and our profession has done for decades.
And, in fact, it's mandated by post, isn't it?
Recently, yes.
And part of that A through F that we looked at the other day, part of the post mandates.
Yes.
And so using a taser, you indicated, is one way of de-escalating a situation, correct?
It can be.
And it can also, however, could it increase the risk to others in the area? The risk of harm, I should say.
That's a really general statement for me to be able to answer.
Well, you answered, that it can be used to de-escalate,
Yes.
and that's by incapacitating the person, correct?
Yes.
And so that then brings down the activity, shall we say, of the subject,
Okay.
right? Is that what you meant by incapacitating?
Yes.
And by incapacitating that person, that could have foreseeable effects as well for others.
Again, it could depending on those specific circumstances.
Yeah. So incapacitating, a driver you don't want to do if they're operating the vehicle.
If the vehicle is in motion, correct.
And a vehicle that can be put into motion at that moment, is that really any less, in your opinion, is it less of a risk?
It would very much depend on the circumstances.
And you are not familiar with the exact circumstances of this incident, correct?
I am not.
You have not done any interviews of witnesses
No,
and not gone out and viewed anything more than just the couple of snippets that you referenced.
not intentionally.
And by not intentionally, you mean
Those snippets.
you saw those just,
The news was on, and by the time I turned the channel, I had seen part of it.
okay. And you talked about, or you were asked about stopping the car. Stopping a car is a dangerous situation, correct?
Correct.
Not all stops are dangerous, but it is a dangerous situation for officers, right?
One of the higher dangers, yes.
And is that one reason why officers will often stop when another officer already has a vehicle stopped to provide backup?
Yes.
Does the presence of more than one officer help with ensuring the safety of the officer and others?
It should, yes.
And that's the whole point of backup, right?
Correct.
You were asked a couple times about well, let me back up to the situation involving the vehicle. When whether a vehicle is moving or stationary, an officer has to consider, when using force, the presence of other occupants in that vehicle, right?
Yes.
And you were asked this hypothetical, and what I want to ask you about is when assessing whether to pursue somebody that you have stopped and is trying to get away, is one factor for the officer to consider when using force whether that person has been identified and could probably be found later.
That is one of many factors.
You were asked about the term hindsight, correct?
Yes.
And that's in your training materials?
Over the years, yes.
And what does that mean to you?
It means that the incident will not be judged by anybody with information that was collected after that incident.
And so that determination of the reasonableness of the officer's force, if I understand what you're saying, is not based on things the officer didn't know at the time.
Correct.
You also talked about the language about 20/20 vision. What do you mean by that? What is your understanding of that term?
It's similar to that hindsight, that information not known at the time of the incident to the officers on scene cannot be used to determine the reasonableness of that force.
Do you know if those terms are actually in the statute about force, authorized use of force?
In statute?
Correct.
They're not in statute, but they're in case law.
And you accept the proposition that here in court the judge will give the jurors instructions on what the law is to apply here.
Yes.
You were asked several times about a warrant authorizing an officer to make an arrest, correct?
Correct.
And you were asked, that means they have to arrest them, correct? You recall being asked that?
Yes, depending on the warrant.
And does it, in fact, in all circumstances, require that officer to make a custodial arrest at that moment because of the warrant?
A custodial arrest where the person is placed into jail, not all warrants require that.
Okay, fair enough. In executing a warrant, making an arrest, as you were asked about earlier, officers still have to determine the amount of force that they will use to make that arrest.
Correct.
And a warrant still requires that an officer use reasonable force to make the arrest, correct?
Yes.
And if an officer determines that they cannot safely make that arrest, safety for themselves or others, that's a decision they can make, correct?
That being only one of many criteria.
Sure. So they have, while there is a court order, they have some discretion on how they make that arrest on that warrant.
Some. In determining whether an officer can use force on an occupant of a vehicle, you've drawn a distinction between the vehicle moving and not moving, correct? Correct.
Does the officer have to take into consideration the ability of a person to put that vehicle in motion?
I'm not sure I understand.
Okay. So if you have an occupant of a vehicle, stationary, but the occupant is in the driver's seat, the engine running, foot in the floorboards, does an officer have to decide, take into consideration at least, whether that person has the ability to then move that vehicle?
In fractions of a second, yes.
Why do you say that?
Because life happens really fast in force incidents.
So it would depend on the circumstances of that situation.
Correct.
But it is something to take into consideration.
Yes.
Because if the person, if an officer used force on that individual and they were able to put the vehicle in motion, would you have the same kind of concerns in that situation as your other scenario where the vehicle is already in motion?
It would depend on the type of force that was applied at that time.
Okay,
And then-
to the person driving the vehicle.
Correct.
Is it dangerous to incapacitate a person who's operating a vehicle when it's moving?
It can be in short durations.
And, okay. Incidentally, you were asked about confusions. You indicated there have been cases of confusions of a taser and a handgun.
Correct.
Do you know how many there have been?
I do not.
When you testified yesterday about proficiency, remember I asked you how you define that. And does proficiency include training to know the feel of a taser?
It's not something that we specifically discuss.
And in your training, your policy requires that officers perform draws of the taser so that they become proficient at doing so.
Yes.
And so that is done as part of the training?
Yes.
Have you ever drawn your handgun when you meant to draw your taser?
Not that I recall, no.
You testified during cross-examination that the use of force often has to be arrived at the decision in a short amount of time, correct?
Yes.
And the scenarios that you have been running with your officers for 8, 9, 10 years, that's an aspect of those scenario trainings as well, making them happen quickly.
Yes.
You're familiar with this, well, let me ask you this. The TASER 7, you were asked about the transition course. Did the previous model of the TASER 7, or the TASER that you used was X26P, correct?
Correct.
And was that also yellow?
Ours were yes.
And did it have a safety switch?
Yes.
Did it have the CID display in the back of it?
It did?
Did it have at least one laser and a flashlight?
Yes.
Was there anything different about the basic function of the TASER 7 from the XP26 in terms of drawing it and deploying it?
The basic function, no.
The spark test that was in policy existed, or that requirement was in policy as well with regard to the X26P, the previous model.
Yes.
And Mr. Eng told you what should means, but is it expected that officers will follow that part of the policy to perform a spark function test?
As much as possible, yes.
Well, what would make it impossible to do?
If as soon as we got into roll call, a shooting came out and we had to run out to go render aid.
And so it would be that kind of circumstance that would excuse an officer from doing the spark test?
The immediate call for service, yes.
What is the purpose of the spark function test?
It depends on the model.
Well, for purposes of the TASER 7, what is the purpose?
To ensure that there are no major faults with it and that it's going to operate when the officer needs to use it on the street.
And so to assure that somebody who's working with you and is going to deploy their TASER for a good reason, you want to make sure that that happens, correct?
Yes.
You want to make sure their TASER is working,
Correct?
and if you're going to deploy your TASER at that moment when you have to, you want to make sure it's going to work.
Yes.
And so would a good officer do that every shift?
Yes.
Have you done scenario-based training where the scenarios involve the stop of a motor vehicle?
Yes.
In fact, I think some of them refer to high-risk stops, correct?
That's a different type of vehicular stop, yes.
Okay, why? What makes it that?
Circumstances of that stop would have us not approach the vehicle. We'd wait until there's additional squads there, more than just two, and we would call the people out of the vehicle back towards us rather than us going up towards the vehicle.
So a much different structured or approach to the vehicle.
Correct.
But you have done regular vehicle stops in your scenario training?
Yes.
And in some of those have the role players that are the driver of the vehicle attempted to flee.
I don't recall.
Is that a possibility that was done in scenarios?
Certainly is a possibility.
Is something officers would need to be, well, is that something officers would need to be prepared to handle out on the road?
Yeah. Yes.
And when you're doing those scenarios, do officers have on them gun, taser, baton, every tool that they can use when they're out in the street?
Inert training devices, as many as we can and that we're allowed to afford. That's what we employ during our training sessions.
When you are training on firearms and qualification for firearms, do you have to train, or do you train that officers must consider backdrop?
Yes.
And what does that mean?
That means that you are paying attention to the things that would be beyond your target in case a round did not strike your intended target, so that we would not inflict collateral damage.
And is that something officers have to take into consideration when using their firearm?
Yes.
Do they have to take that into consideration when using a taser?
Yes.
If I could just have a moment, Your Honor.
Yes.
No, that's all I have. Thank you.
Right. Lee Cross, Mr. Ing, you may proceed.
A couple more questions. You were asked whether a good officer would do a spark test.
I was asked that.
Well, a good officer might miss a spark test too.
They certainly
You
could.
can be a good officer and miss this occasionally.
Correct.
It's not the criteria you would use to judge a good officer.
Not in and of itself, no.
And the question of insurance, I mean, well, you'd look at the bulk of a career, for example, wouldn't you?
Can you say that
To
again?
judge whether an officer's good or not, you'd look at the bulk of a career too, wouldn't you?
Yes.
The body of her work, right?
Yes.
A person who drives with insurance, you indicated, has a little more difficulty with the law. Would you explain that?
The objection is overruled. You may answer if you can.
Do you remember the question?
Can you repeat it?
Sure. Well, you were asked on direct about insurance, and you indicated that when an individual has insurance, there is more of a proclivity to have problems, so to speak. I'm paraphrasing your answer.
When they do not have insurance,
Yeah.
they're more unsafe on the roads.
Yeah. Why'd you say that?
One of the primary duties of a police officer is to ensure traffic safety, to prevent crashes, to prevent people from driving under the influence. In my career, I have stopped people that have been not safe in their driving to meet those goals, and during those investigations, many times I have led to those people not having insurance.
And the lack of insurance harms the community.
Yes.
Because if there's a crash, there's no recovery by the automobile that doesn't have insurance,
Correct.
which is the function of insurance to begin with.
Correct.
And in fact, when you apply for a license on a car, you have to indicate the insurance company that covers the car, right?
I'm not aware what the requirements are to get a driver's license.
Now, when you apply for tabs, for example, do you have to say that you're insured?
Currently, the state has put that requirement in, yes.
And that's to ensure public safety, right?
I would believe so.
Now, you were asked some questions about cars and if a car is about to drive away. What the criteria you use is a control of the car. Control is the operative word you use in your training. Is that right?
Yes.
And you draw a distinction between a stationary car and one car that's in movement. Is that right?
Correct.
Because that's all an officer can see.
Yes.
And you've had instances in your career where you attempt to make sure that the individual doesn't drive away from you. Is that right?
In my career?
Yeah.
Yes.
So that the individual is prevented from taking control over the car.
Yes.
The issue of a warrant, you were asked about speeding tickets and arresting people on speeding tickets. Do you draw a distinction between an arrest warrant for a gun charge and a speeding ticket?
Yes.
And when you make an arrest on a warrant, the first thing you do is cuff. Is that correct?
When I make an arrest?
Yeah.
After telling them they're under arrest, yes, that would be to cuff them.
And then once you cuff them, you put them in your car.
Correct.
And then you figure out what you're going to do.
Correct.
Now, in the scenario that I gave you on the use of tasers, one more fact that I want you to consider, one more hypothetical fact. Suppose further that a police officer is inside the car and the driver is attempting to leave, and the officer is, the door to the passenger side is open, and the officer is seen inside the car. Would a taser be appropriate to be used to stop the individual from leaving?
Where is the officer?
The passenger side, the passenger seat.
In an open door or a closed
Open
door?
door.
And they're in the interior of the vehicle.
Yes.
And your question about that scenario for this is?
Should that individual be stopped?
Yes.
Redirect, Mr. Green.
Thank you, Your Honor. I will try to be brief. The additional facts added to the hypothetical, is it part of training that it is dangerous for officers to put themselves inside of a vehicle when a suspect is trying to flee?
It's something that we want to try and avoid, but it's not always avoidable.
And if an officer determines that they can do that and stop the fleeing by rendering the vehicle inoperable, shutting it off, putting it in park, that would be a decision for an officer to make. Could be one decision they could make.
Yes.
So just because, well, let me ask it this way. If an officer, there is a danger that an officer could get dragged by a fleeing person, correct?
It is a danger.
And officers are trained on that danger.
Yes.
And but the mere presence of the officer to some extent into the vehicle is a determination an officer has to, is a fact an officer has to consider when deciding whether that officer is in danger of being dragged.
In any rapidly unfolding incident, there are many factors that officers have to make, and they have to make those decisions in a very short amount of time.
And so the answer is that is a consideration for them.
Of many.
And the officers that you have trained for Brooklyn Center would know that it's dangerous to place themselves in a position where they would be in a vehicle that could be.
Objection foundation.
The objection is sustained.
Well, I asked, well, is it part of your training then that officers should not put them in a position like that in a vehicle?
We do not deal in absolutes because no incident in this world is ever forecasted. We give recommendations. We give officers as many hypotheticals as we can, but the world is constantly moving and evolving. It's something that we warn on, but it's that officer's determination at that time in that specific incident that is different than any other incident that they have probably been in to make that decision.
Fair enough. And so what you're saying is it all would depend on where that officer is, where their feet are, where they're located physically, if they're outside the door. It's going to depend on a lot of considerations.
It would depend on their actions, the actions of officers, and the actions of any suspects or any other people inside that vehicle.
But in terms of reasonable force by that officer, it's from that officer's perspective.
That specific officer's perspective, what their actions are.
That's all I have here.
Okay, Mr. Ing?
During one of these critical incidences, all the officers are expected to help each other.
Can you,
During these incidences where there's a decision that has to be made quickly, all the officers are there to help each other.
so you're not speaking about a specific incident, but the
No.
things that we do on a daily basis.
You're there to help your other officers.
Correct.
Anything further from the stage?
Oh, yeah, thank you.
All right. Thank you. You may step down. Okay, members of the jury, we're going to take our morning break. Okay? Uh, 20 minutes, counsel.
Put your hands up! Put your hands up! Put your hands up! Put them up! Put your hands up! 3.
Officer Salvosa, I'd like to now play for the jury a third video. Do you recall that your body-worn camera continues on past that point, beyond the point, and actually captures your interaction with the vehicle and ultimately the response by the group of officers?
Yes, sir.
And you've had an opportunity to review that prior to trial, correct?
Yes, sir.
At this time, the state offers Exhibit 39. That's a portion of Officer Salvosa's body-worn camera.
Any objection?
39. There being no objection, 39 will be admitted and you may publish.
Thank you, Your Honor. This video is a bit longer, Officer Salvosa, correct? It's about 16 minutes long?
Yes, sir.
Okay. You will be given an opportunity to discuss issues if they come up. Could we please play that, Mr. Miller?
Saying that she's tired of being a Democrat because of the African-American that she's
3219, PI accident, 63rd and Catherine Drive, fled from 38 stop, start north on the Reds.
Did you recognize the voice on this video?
Yes, sir.
And whose voice was that?
My voice, sir.
Did you hear yourself say, start north on the Reds?
Yes, sir.
Could you tell the jury what that means?
North Memorial Ambulance is the ambulance company that provides services to Brooklyn Center. So when we refer to them as North, so that would basically refer to an ambulance. On the Reds means the fastest response possible.
Okay. Lights and sirens.
Yes, sir.
You can continue.
Put your hands up! 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 Put them up! Put your hands up! 3219, several at gunpoint, 63rd and Catherine Drive. Start north on the Reds and start 2 rigs. We've got a civilian car injured as well. As soon as we get additional cars, I'll check for injuries. Suspects are not compliant. They're moving around. Put your hands up! Hey, sir, stay there. Stay there.
You directed someone to stay there. Do you know who you were talking to at that time?
I believe it was the person in the injured vehicle.
In which injured vehicle?
The Subaru that was hit head-on in front of me, sir.
Okay, and can you actually see the other vehicle on your screen now?
It's just in the corner by my door frame. You can kind of see it right outside my door frame.
Okay. Right outside your door frame in the way left side of this image?
Yes, sir.
Okay. You can continue, Mr. Miller.
Put your hands up! Lower the window! Lower the window! Ma'am, are you okay? Stay there. Stay there. 3219. We'll take 2 rigs, stage them a couple blocks out. What's that? 3219. The driver is not breathing. I'll take an additional squad and we'll yank him out. But get him here on the Reds. I'm by myself, holding him at gunpoint. $3,219, make it 3 rigs. I got 1 male not breathing, 1 female with facial lacerations, and then I've got another civilian car that I have not been able to check on yet. Incoming squad, come to me at 63rd and Catherine so we can get the driver out and the passenger, and then we'll have to check on anyone else after, but the driver is not breathing according to the passenger. Passenger's moving around. I can't see him, but we're going to need to extricate him if he's not breathing. So I'll wait for additional. Let's come up with the plan. Okay, so female passenger, driver.
I just wanted to pause quickly. 2:06 and right on the dot. Would you agree that that's the timestamp that the video is paused at this time?
Yes, sir.
And in your leftmost view on this screen, do you see the number 1683?
Yes, sir.
Could you tell the jury what you're seeing at this time?
I'm seeing one of the first officers to arrive, which would be a Brooklyn Park squad.
Okay. And I won't interrupt at this time. You're going to begin to explain the situation to him, I assume?
Yes, sir.
Okay.
He's not breathing. Flee from the traffic stop. And then they crashed. 3219, the suspect I'm at gunpoint at is a flee from 38 stop. Ma'am, get out of the car! Passenger, get out of the car! Get out of the car! Get out of the car so we can take care of him! Get out of the car! Yes, you! Get out of the car so we can help him! Get out of the car!
Let's grab a bunker if you got one. You got a bunker?
Copy that. Ma'am, put your hands up.
I'm behind you.
Okay, he's not. Yep, I see him. He's not breathing.
Okay.
Hey,
How
Jeff,
many other people are in it?
just two.
Two more in
That-
it. You got a 40? All right. Let's have you guys come up from behind then. There's one still.
He's not breathing.
We'll deal with that when we deal with it.
Copy that. I can't see the back seat.
So the back seat possibly has a passenger still moving around. Do we have anybody who has a bunker? My sergeant's coming with me. Okay. Let's wait till we have one then.
Yep. I'm in no rush. Someone go check on that car, see if they're okay. So he hit that car and crashed through.
3207, if we can still get a bunker to 63rd and Catherine.
300, we've got a bunker. If that one in the squad here is clear bunker.
63rd, oh, that's too far down. I copy. We got one out of the car, still got two in there. Can't see what the one in the back seat's doing.
Fire 16, I'll be arriving.
You want to bring your 40 up here? Oh, you got it there? Don't. That's fine. That'll work. Take back!
Washington and Robbie.
63rd and Catherine with the, if you have the bunker. Okay. That's it? Okay. Oh, we see one in the front passenger seat.
Can you guys make sure no one else is in that vehicle?
You guys want to come up from behind? Would it? You think so? All right, bring it around then. We can do it. We can bring it around. You stay here. I'm gonna
Copy that.
go back.
White, Buick.
Plate status expired. 1. State records hit.
Hey, Al, is there another person in the back or no?
No.
It's just the driver right now?
Yeah, that's all I can see.
She didn't say there's anyone else?
She doesn't say there's anyone else. I couldn't really see because she was moving around so much.
Your incident is inundated.
You bunker up, just cover the rifle over your shoulder, hold the gun, and then get on that back.
Yeah, so you, whoever's Hater, you're going to cover through that front window. Okay? And then whoever's on my left, whoever leaves on my left, I want you to see that back.
Plate status expired.
Ready? So block that window. We're coming up, we're moving up.
Copy that.
Officer Savosa, in the last 2 seconds of this video, first of all, can you identify the timestamp on this video at this time?
It says 2:10 and 55 seconds, sir.
Okay, and some individuals just walked across the screen, correct?
Yes, sir.
Who are those individuals?
Officers from other agencies.
Okay, and what is going on at this time in the video?
They have stacked up and looks like they had a bunker and a rifle, and they're approaching the vehicle to clear it.
Okay. Push play.
Jesus fucking Christ. Yeah, he's probably not going to make it. What's it? Not shots fired. What's that? Oh, he did? Oh, I didn't yell shots fired.
I got your keys.
Back.
We don't have exits. Where's he got the shots?
Chest. Does anybody have? Do you have your?
I got nothing on the back.
Those kits that we just got?
You want to start putting some tape up there?
Yep. Hey, folks, you're going to have to back up. Back up. Back up, folks. Back up to the end of the block, please. By the white car. What's that? No, I'm okay. Thank you. Yep.
Could you pause at this time? Officer Salvosa, at this time, 2:14 to 21 seconds, would you agree that the audio cut out?
Yes, sir.
And why did the audio cut out?
Me and Officer Fricky had a private conversation.
And in that private conversation, you're able to mute your camera?
Yes, sir.
Okay.
Okay.
Who can I talk to about more patients? I don't know. Nobody knows anything.
So,
Female patient in here, that's the...
do you recognize the individual you're addressing at this time?
That's a North paramedic.
Okay. So is this the first time that you've encountered the paramedics on the scene?
No, an ambulance drew by earlier in the video, and a bunch of them were walking around.
Okay.
Female patient, there was someone in this car. $219. Does anyone know the patient, where the patient of the Subaru is? Is she okay? We have North here. What's that? Yeah, let's.
All the way down the path here.
So by the school, I guess. Furthest is the school.
So there were shots fired down there?
I don't know. I didn't hear that. It was a traffic stop. They had one with the warrant. As I'm pulling up this way, the car takes off, hits this Subaru and crashes here. He's got a gunshot wound. I didn't fire him, so I have no idea about that. But obviously he's got shot somewhere between there and here. That's all I
Do we
know.
have anybody else?
No.
You don't know?
So there's a guy that they took into custody, driver, and then the female passenger.
Okay.
So I'm guessing somewhere between there was where the shot was fired. I don't know anything else. Yes, if you would. Start from the school west.
Old people?
Officer Salvosa, do you know who you were addressing at the video at this time, about 2:16?
That's a Brooklyn Park officer.
Okay, and the information you conveyed, is that at the time that you conveyed that information, what you believed occurred?
Yes.
And subsequent to that, you have learned that some of the information you conveyed to that officer was inaccurate, correct?
Yes.
Okay.
They're over here. So North guy's already on them over there. So
Are we still on the main?
we're still on the main.
I don't know if we need to move it to attack channel, but
Hey, you guys are.
Jesus.
Yeah.
I'm okay.
Sure.
Yeah, thank you guys for coming.
You'd agree again, I hear at 2:17, you've put it on mute?
Yes, sir.
By this time, at 2:17 and 30 seconds, have you ascertained the status of Mr. Wright?
I believe so.
And what was that? That he was deceased by this time, correct?
Yes, sir.
In fact, when you look at the view here at 2:17 and 50 seconds, do you see something different with where Mr. Wright's body was located?
Yes, sir.
And what's that?
His body's been covered up with a sheet.
Okay, please be seated. The state may call its next witness.
Thank you, Your Honor. The state would call Professor Seth Stoughton.
Professor, good morning. Will you please come forward and then stand behind the witness chair, which is right next to me. Raise your right hand. Do you swear under penalty of perjury that you will truthfully testify in connection with this case?
I do.
Please have a seat. And would you please remove your mask? And state your full name and spell it.
My name is Seth Wayne Stoughton, SETHWAYNE,
Okay, thank you. A couple of things to keep in mind when you're testifying. The court reporter that's sitting right in front of you is taking down everything that's being said. Therefore, you have to answer with a yes or a no instead of shaking your head, and don't say uh-huh or uh-uh.
I understand.
All right. Only one person can talk at a time. Wait until the question's finished before you answer. If an objection is made, you've got to stop talking immediately and don't answer the question unless I tell you to. If you don't understand the question, please let the questioning lawyer know. Okay?
Thank you.
Counsel?
Thank you, Your Honor. Professor Stoughton, can you tell the jurors how you are currently employed?
I am an associate professor at the University of South Carolina School of Law and an affiliate with the Department of Criminology and Criminal Justice.
And that department, is that also at the University of South Carolina?
It is, yes.
So the law school plus like an undergrad department?
Yes, my primary appointment is at the law school. I have an affiliate or courtesy appointment with the Department of Criminology and Criminal Justice because of the nature of my work.
And how long have you been serving in those roles?
The affiliate appointment is relatively new, the last year or so, I would say. I've been a law professor at the University of South Carolina since 2014, summer of 2014.
And so do you teach classes at the law school?
I do, yes.
Do you teach classes at the undergraduate part of it as well?
I have taught a course at the university's Honors College, but it's not part of my normal teaching rotation.
So what classes do you teach at the law school?
I teach criminal law, criminal procedure, police law and policy class, a regulation of vice seminar. I have taught a class called Advanced Topics in Criminal Law, but only once, and I don't think I'll go back to it.
Do you also conduct research in that position?
I do, yes.
And what kind of research do you do?
I study policing, police culture, police regulation, policies, behaviors, essentially the rules and regulations, both formal and informal, that we use to get officers to do what we want them to do and to not do what we don't want them to do.
I'm going to back up a little bit and go into your educational background.
Sure.
And did you obtain an undergraduate degree?
I did, yes.
And where was that at?
Florida State University in Tallahassee.
Do you recall when you completed that degree?
I do. I started that degree in 1998, and because I'm a little slower than the average bear, I finished it in 2008.
And so most people don't spend 10 years completing their undergraduate degree?
It's a long time to get a 4-year degree in.
Was there something in the middle that interrupted or slowed down your progress?
Yes, in the first semester of my junior year, I went to the police academy and served as an officer, later switched jobs to become an investigator for a state agency. And the regular working hours as a state investigator allowed me to finish that 4-year degree.
So did you work as a police officer?
I did, yes.
And where did you work? What department?
The Tallahassee Police Department.
So that's Tallahassee, Florida?
Yes.
Is that where Florida State is?
It is.
And so when did you start working there?
I started there. I began the employment process in late 2000 and was employed there in March 2001.
So can you describe for the jurors what you went through training and education-wise to become a police officer?
Sure. I attended the Pat Thomas Law Enforcement Academy, which is our pre-service basic academy training. That was 5.5 or 6 months. When we finished, the academy that I attended was not agency specific. There were officers from a number of different agencies, including my own, who went there. So when we finished the academy training, my cohort and I had 4 to 6 weeks of additional classroom training at my particular agency, then a 3.5 or 4 month field training program before I was what they called solo and on my own as an officer in, that would be November of 2001.
And what were you assigned, what duties were you assigned when you started for the Tallahassee Police Department?
I was with the Uniform Patrol Division. It's our uniformed beat cops.
So what did you do as a patrol officer?
Over the 5 years I was with the agency, I worked in 2 of our 3 districts. We broke the city into 3 different districts, Alpha, Bravo, and Charlie. I worked in primarily in our Charlie district and our Bravo district. The primary jobs of a patrol officer are responding to calls for service, self-initiating activity like initiating traffic stops, conducting field investigations, making arrests, writing up information where you can't complete an investigation so that an investigator can pick it up and conduct additional investigation. I also had some additional duties not specific to my patrol function. I trained officers on report writing. I spent 2 years on our special response team, served on some committees doing policy writing for new technologies, among other things that the agency was adopting.
Did you have any other special assignments during those 5 years?
I taught for the city community self-defense classes, child molestation and abduction prevention classes. There would have been a bunch of things that came up on sort of an ad hoc basis, but in terms of repeat assignments, it was basically those around my core patrol officer function.
Were you licensed as a peace officer during that time?
Yes.
And did you receive training as a police officer?
Yes, both pre-service, that is before I was in a real uniform and in a car, field training, and then as an officer, annual in-service training.
And was that required to keep your license in Florida?
Yes, there were a certain number of hours that you had to complete every 4 years to keep your certification, and then by policy, my agency had additional training that it required us to go through annually.
And I think how long did you work there then as a police officer?
I left full-time at the end of October 2005. I stayed on as a reservist, which is a part-time officer, for about another 6 months until mid-2006.
During that time that you were working as a police officer, did you have occasions where you had to use force on individuals?
Yes.
Did you have incidents where you had to arrest somebody and take them into custody?
Yes, quite a few.
Did you have occasions when you had to handcuff individuals?
Sure. Yes.
And did you have to write reports?
Lots of reports. Yes.
Were those reports reviewed by others in your department?
Yes. Either a sergeant or acting sergeant, and then for some reports, our lieutenant or watch commander would review reports and approve them.
So you told the jurors that at one point you left that job. Where did you go?
I left the city police department for a position as an investigator with Florida Department of Education's Office of Inspector General, sort of like the internal affairs for the Department of Education.
And what did you do for that agency?
I was an investigator assigned to a mix of criminal and administrative investigations. The administrative investigations would be violation of department policy, anything from sexual harassment to there were a ton. Someone who was running a real estate business out of their state office, for example. The criminal investigations, we had some that were in-house, involving criminal investigations of department employees, someone who had stolen a check, for example, as well as investigating criminal violations of Florida's private school tuition voucher program, which was associated or run through the Department of Education rather than local school districts.
Do you recall how long you had that job?
I was there from November of 2005 until June or July of 2008.
So while you were working there, did you then resume your education?
I did, yes.
Why is that?
Because I thought it was sort of sad that I was going on 7, 8, 9 years of not finishing a 4-year degree. Finishing my education was something that was important to me, something that was important to my parents, something that was important to my career trajectory. So definitely something that I'd always intended on finishing. I just didn't have the luxury of it doing shift work with the department.
And so you told, I think, the jurors earlier, you completed that degree in 2008, is that right?
Yes.
And what was that degree?
It was a bachelor's degree in English with a focus on literature.
And so then what did you do after obtaining that degree?
I matriculated, which is a fancy academic term of I went to law school.
And where did you go to law school at?
The University of Virginia School of Law.
And did you graduate from law school?
I did,
What
on
year?
time even.
And how many, or when did you graduate from law school then?
2011.
And so did you go to work in the legal field then after graduating?
I clerked for a year, which is working for a judge, and then had the opportunity to pursue an academic fellowship, which I did prior to taking my tenure track position at the University of South Carolina.
And what is an academic fellowship? What kind of stuff do you do?
In the legal field, you can think of an academic fellowship as a little bit like what a postdoc would be in other fields. It gives an aspiring academic time to research, to write, to develop the body of written work that you need to get an entry-level tenure track job.
How did you get interested in doing that?
When I was in law school, I initially had no intention of staying in the criminal law field or doing anything with policing, but taking criminal law, taking a criminal investigations class, which is now the class I teach under the title Criminal Procedure, really got me interested in studying the rules that I had used as an officer from an academic and particularly a legal academic perspective.
And so what did you focus your research on during that fellowship?
On policing.
And after that fellowship, what did you do in your career?
In the second year of the fellowship, I went on the academic entry-level hiring market, got my tenure track job at the University of South Carolina, and ultimately accepted that and have been there ever since.
Now, have you authored any scholarly publications?
Yes, quite a few.
Can you generally describe for the jurors what they are?
I would love to. I've written a number of academic articles on policing, everything from how the Supreme Court develops Fourth Amendment rules that regulate policing to issues of police culture and the effect of police culture on the regulation of officer behavior, some aspects of history of policing. Over the last few years, my focus has been much more on tactics and the use of force. I've written articles on tactics. I've written book chapters on reviewing use of force. I have, with a couple of co-authors, a book on evaluating police uses of force. So that's been my primary focus over the last few years.
So this is going to seem really redundant, but what is the title of the book you've authored?
It is creatively titled Evaluating Police Uses of Force.
And when did you publish that book?
That was published in April of 2020.
And are there other authors involved in that book?
There are, yes.
Two other authors, correct?
Yes, Jeff Albert and Jeff Noble.
Professor Stoughton, are you a member of any professional organizations or associations?
I am, yes.
Can you describe those to the jury, please?
Sure. I'm a member of the American Society of Evidence-Based Policing, which endeavors to take empirical work and bring it into policing as a predicate for good policy and decision-making. I'm a member of the International Association of Chiefs of Police in the Legal Officers section. I'm a member of the American Law Institute. I'm a member of the I'm a fellow of the American Bar Foundation. There are probably some others, but I don't remember them offhand.
So are you a lawyer?
I am a lawyer. I do not practice as a lawyer, but yes, I'm barred in the state of Virginia. Thank you. I'm also a member of the Virginia Bar.
Do you also consult with or are consulted by law enforcement agencies?
Yes.
Can you describe that for the jury, please?
Sure. So I have done training for law enforcement agencies on a range of different topics, from doing presentations at the Federal Law Enforcement Training Center or the command staff at the Bureau of Alcohol, Tobacco, Firearms, and Explosives, Federal Inspectors General, training for the command staff of the Kansas City, Missouri Police Department. The trainings or focus of what I come in and talk about can vary. Sometimes it's on setting up a robust body-worn camera program for an agency that's considering that, putting together a use of force review process. I serve. This might be an association membership. I'm not sure how to categorize this one, but I'm one of the members of the Civilian Advisory Council for the Columbia Police Department. In that capacity, I provide some consulting to that agency, or at least input to that agency, as well as doing a range of talks for other law enforcement actors, not traditional police agencies. For example, last week I was giving some talks and training to the state attorney's office in Jacksonville, Florida.
That's my next question, is have you done some speeches or presentations to groups in this area?
I have, yes, quite a few.
And can you just tell us what kinds of groups you've given presentations to?
Sure. I've spoken before the Fourth Circuit Judicial Conference, a conference of judges and prominent lawyers in the Fourth Judicial Circuit, Federal Circuit, to the American Judicial Association, to judicial conferences in half a dozen or more states. South Carolina is the easiest one, but Ohio, North Dakota, kind of all over the place. To professional organizations like the South Carolina Bar, for example, to community groups or other non-legal professional organizations. All of the talks or training have been on or about policing and various topics within that.
And Professor Stoughton, have you been retained to offer expert opinions in this case?
I have, yes.
And have you been retained as an expert before this case?
Yes.
And that is an expert in the area of policing and law enforcement?
Yes, police procedure, investigations, tactics, and the use of force primarily.
And how many times have you been retained as an expert?
I believe my current retentions are in the mid-80s. I think 84, but I may be off one or two.
Have you testified in court as an expert?
I have, yes.
And can you describe what courts you've done that in?
Yes, I've testified in both federal courts and state courts in the context of both civil matters, civil lawsuits, and in criminal proceedings.
And when you are retained, you were retained by the state in this case, correct?
Yes.
when you are retained, do you charge a fee for your services?
I do.
And what are your fees?
It will depend a little bit on the nature of the entity that that retains me. In this case, I have a $290 an hour fee, and on days when I'm expected to testify, a 10-hour flat rate.
And to date, have you been compensated for your work in this case?
Yes, I've been compensated for hours worked, I think, through November.
And approximately how much have you billed so far?
I would have billed, I believe, 34 or 35 hours, and I would have to do that math somewhere in the area of $9,000, I believe.
When you have been retained, have you always reached an opinion favorable to the party that hired you?
No, certainly not.
Why is that?
Your Honor, this is irrelevant.
The objection is overruled. You may answer.
Can you repeat the question, please?
Why is it that the opinion you reach is not always favorable to the party that hired you?
It depends on the facts of the particular case. When a party hires me, when a litigator in civil or a criminal proceeding hires me, they're hiring me to apply a professional standard, that is to compare what an officer or officers or an agency did and to contrast that with the standard that you would expect an officer, or rather that I suppose would expect an officer to meet, whether they've satisfied the professional standard of care, as the term sometimes is used. And in some cases, some number of cases, my review simply has not been helpful to the attorney who's hired me. Sometimes that's a plaintiff's attorney who is suing an officer, and my opinion is that the officer acted reasonably and appropriately. Sometimes that's a defense attorney who's defending an officer in a civil or criminal lawsuit, and my opinion is that the officer acted inconsistently with generally accepted police practices. The exact reasons, of course, would depend on a particular case, but in essence, I'm not being retained to give an opinion that is favorable. I'm being retained to review and give as objective an opinion as can be managed.
Did you seek out the state to work on this case?
No.
And have you, in fact, arrived at some opinions regarding the conduct involved in this case?
I have, yes.
I ask you about the process you go through to arrive at those opinions. Can you first explain how you start when you're retained in a case?
Sure. So the first thing that I need to do is really understand the body of evidence or information that that applies. I need to get all of the information, either all of the information in the case or all of the information that I or the attorneys who hired me agree is relevant to the opinions that I would be forming. So the first step is really gather all the information and start looking through it.
And did you gather some information in this case? Were you provided information in this case for that purpose?
Yes, I was provided with a great deal of information in this case.
Can you just generally describe for the jury what kinds of information you did receive?
Sure. So in this case, there were several thousand pages of written documentation, training records, personnel records, among others. There were videos from officers' body-worn cameras. There were videos from squads, from police vehicles, or in-car camera systems. There were interviews that had been conducted of some of the parties involved in the incident. There were still images, crime scene photos. There were cell phone records. There was additional information about the crime scene using sort of a three-dimensional laser modeling technique. I believe I received all of the file in this case.
Was that information, in your opinion, adequate to arrive at opinions in this matter?
Yes, it was.
In your work in this field, do you commonly review body-worn camera videos?
Yes, quite often, both as a consultant in the context of specific cases and also as a trainer and educator, one of the trainings that I have done most frequently is educating investigators, prosecuting attorneys, other parties on how to review and interpret video footage, particularly body-worn camera footage, and especially in the context of use of force investigations.
Have you done any research or publication in the use of body-worn cameras?
I have, yes.
Can you just briefly describe that for the jurors?
Sure. I have, I believe it's a 2018 article on police body-worn cameras that identifies the potential benefits of the technology, the limitations, both the limitations of the technology itself and the limitations that we have as humans viewing video footage. I have a chapter insert in a book by Eli Malm and Michael White, two criminologists, on body-worn camera footage, specifically on the review procedures of watching body-worn camera footage.
I think you just mentioned two authors.
I did, yes.
Can you spell that first author?
Yes, Michael White, both common spelling, and Eli is A-I-L-I, last name M-A-L-M, I'm pretty sure.
And is it helpful to have body-worn camera videos of the incident?
It is, yes. Body-worn camera footage can provide information that you simply would not get from another source. You have to be a little bit careful in relying too heavily on it, because body-worn camera footage, like anything else, is just one more piece of evidence to compare and contrast against other pieces of evidence. But it can be extremely valuable in the right case.
Is it also helpful to have multiple different body-worn camera videos of an incident?
Absolutely. The more video you have, the more insight you have into what happened in a particular case. Information that may not be clear on one video because of an obstruction, for example, or because an officer is moving, may be clearer on another video. Just like having multiple statements is often more helpful than having a single statement, having multiple videos allows you to draw firmer and sometimes more conclusions than just having a single video.
So in reviewing all that information that you obtained, did you rely on your training and experience when reviewing and interpreting those materials?
I did, yes.
Now, when you begin working on a case, you told us you review the materials. When you get around to analyzing the case itself, what is the first step that you undertake when working on a case?
Sure. So in a use of force case or in a tactics case, the frame that I have to use for analyzing it is the perspective of the reasonable officer in the position of the actual officer. So if you sort of imagine pulling the actual officer who is there out of the picture and putting in this idea or this construct of the reasonable officer, I have to identify what information would have been known to the reasonable officer on the scene. It wouldn't really be fair to anyone involved to assess an officer's actions using information that was not available to them or someone in their position.
And then what is the next step that you do in the process of analyzing the case?
After identifying the information that's available to the officer, the reasonable officer on the scene in the officer's position, the next step is identifying whether there was some threat that could justify a use of force. And I'm using a use of force a little bit carefully here. The question isn't yet whether a particular use of force was justified. It's just whether there is some threat that justifies some use of force in response.
And then what is the next step that you do?
So after identifying the foreseeable effects of the threat, then the question turns to the officer's response. It requires looking at the officer's actions and identifying what are the foreseeable effects of the officer's actions. An officer's use of force can have different effects in different circumstances. So what could be a relatively low-level use of force in one case might be a relatively high-level use of force in another case. I have to look at the facts and circumstances, again, through that framework of a reasonable officer on the scene, and identify what the reasonable officer would have thought the likely effect of their actions would be.
And for that last step in the analysis, what standards do you apply in making that determination?
The ultimate standard that I'm using is the professional standard within policing. Policing draws on, as an industry, a bunch of different standards. It draws on some Fourth Amendment law, it draws on state law, it draws on some research, it draws on historical practices within policing. So what I'm looking to determine what the foreseeable effects of force are, it's really what would the professional officer in this situation have perceived, what would the reasonable officer in this situation have thought the foreseeable effects are going to be. That would include the training that officers get, that would include agency policies, anything that helps inform that expectation on the officer's position.
If an agency has policies, how does that contribute to the standard you've just talked about?
Sure. So policies are effectively rules or guidelines that help provide guidance to officers in the performance of their duties. If officers did everything perfectly all the time, you wouldn't need policies to tell them what to do or what not to do, right? You could just send them loose and everything would be fine. So when you're analyzing, or when I'm analyzing, what the foreseeable effect of a particular use of force is, for example, one of the inputs, one of the factors to consider is what the officer has learned at their agency about that particular use of force. Sometimes there are things that I would describe as generally accepted in policing, that is, policing as an industry knows about something, but the officers in this case may have been badly educated. I say this case to refer, of course, to the hypothetical that I'm talking about, not any case in particular. If officers just simply don't know, in fact, I had a small role working on a case like this out of South Carolina, if officers simply don't know about this risk because it's outside the scope of their policy and training, then although there might be a violation of generally accepted police practices, that would fall more on the agency than on the officer. On the other hand, when there are risks that have been identified in policy or in an agency's training, then it should be clearer that the officer has some awareness, or certainly should have some awareness, of what those foreseeable effects or those risks are.
Are you familiar with an organization called Lexipol?
I am, yes.
What is Lexipol?
Lexipol is, until relatively recently, Lexipol was primarily involved in creating and marketing policy manuals for police agencies. An agency could go to Lexipol and purchase off the shelf a set of policies that it could then take and append and revise as the agency saw fit. A little more recently, Lexipol has gotten into the training and commentary space. They've purchased a media publication website that used to be Police One and is now called Police One by Lexipol, as a way of publishing op-eds or information to a police-oriented audience.
So is obtaining policies, foreign policies from Lexipol, a reasonable thing for agencies to do?
It certainly can be, yes. Lexipol refers to case law in the specific state where the agency is located. It refers to Supreme Court or Federal Circuit case law. Lexipol tries to take some of the work of creating policies, well, out of the process of creating policies. It tries to provide a more standardized basis for agency policies, both in terms of content and formatting. Although I think there are reasons that agencies might want to particularize some policies much more closely than sometimes they do with Lexipol, as a way of sort of setting a fundamental baseline I think the Lexipol policies are generally consistent with accepted police practices.
Now, you mentioned earlier the constitutional standard for police uses of force, correct?
Yes, one of the factors or one of the inputs that informs the professional standard within policing is certainly the constitutional law and the Fourth Amendment.
And what is that standard? Can you describe that? Give the jurors a brief primer about that, please.
Sure. So in 1985, the Supreme Court decided a case called Tennessee v. Garner, which was a deadly force case. And in that case, the court held that for officers to use deadly force without violating the Fourth Amendment, officers had to have probable cause that the subject against whom force was used presented an imminent threat of death or great bodily harm to the officer or someone else. 5 years later, in 1989, 4 years later, in 1989, the Supreme Court decided a case called Graham v. Connor. In that case, the court held that with regard to other uses of force, what are referred to generally as less lethal uses of force as opposed to deadly force, although the court didn't use that language, that in order to comply with the Fourth Amendment, those uses of force must be objectively reasonable. It provided some guidance on how to make that assessment, as well as the framework that I mentioned before, the question of whether an officer acted in an objectively reasonable manner is a determination that's made from the perspective of the reasonable officer on the scene.
And were there some particular factors the court drew out in Graham that informs the determination of the reasonableness of force?
Yes, the Supreme Court identified a series of three non-exhaustive factors that are now referred to often as the Graham factors. That's the severity of the underlying crime, whether the individual is attempting to flee or evade arrest by flight. Whether the individual is actively resisting or attempting to evade arrest by flight, and whether the individual presents a threat of harm to the officers or others.
Now, in this, from both of those cases comes the word threat, correct?
Yes.
And based on your training and experience in this field, when you use the term threat, how would you define threat?
Sure. So a threat, or particularly the concept of imminent threat, can be distinguished from another concept that I'll refer to as risk. A threat exists, or a threat is imminent, when the reasonable officer on the scene would perceive the individual in question as having the ability, opportunity, and intention to cause a particular type of harm. And I want to focus on that particular type of harm for just a second. In policing, there really should never be such thing as a threat generically. It's always a threat of something, a threat of escape, a threat of harm, a threat of death or great bodily harm. And that's because figuring out, under the second prong of that analysis that I talked about before, figuring out the foreseeable effects of the threat presented, whether there's an imminent threat, my train of thought got completely derailed. Figuring out whether there is an imminent threat of a particular type of harm becomes important when you try and figure out whether the officer's response, the use of force, was proportional to that threat or not. So just because someone presents some kind of threat does not give officers, obviously, carte blanche to do anything. Their response has to be proportional and appropriate.
And how does that different than the term risk?
Sure. So with an imminent threat, we have ability and opportunity and apparent intention to cause a particular type of harm. Ability is when someone has the physical capability of causing this particular type of harm, right? Someone who's physically running away has the ability to threat, right? The ability to flee. Someone who is holding a baseball bat has the physical ability to hit someone with the baseball bat in a way that someone without a baseball bat obviously does not have the physical ability to hit someone with a bat. Opportunity really refers to whether someone is vulnerable to that particular type of harm. Sometimes it's referred to as jeopardy. Someone who has a baseball bat may have the ability to hit someone with that bat, but if they're 50 feet away from the nearest person, they don't yet have the opportunity to hit someone with that bat. Now, as they close distance and come closer, then sure, they could develop the opportunity, but at that moment, while they're 50 feet away, they do not. And apparent intention is really behaviors indicating that the person wants to cause that particular type of harm. Someone who has a bat and is standing very close to someone else, but they're in a batting cage and he's practicing batting practice, really has no intention to strike someone with that bat. So you need all three to have an imminent threat. When you don't have one of those three things, when you have one or two but not all three, we would refer to that as risk. And officers can use a range of tools to manage risk, but they can't use force to address risk. So if an officer wanted to talk to someone with a bat in that batting cage, the officer might ask the person to put the bat down. The officer might stand on the other side of a fence where they can't be hit with the bat, but they couldn't use force because that person happened to be holding a bat in that circumstance.
You've been discussing this, the standards that sort of apply here to the reasonable use of force. Did you look at Minnesota statutes that deal with the use of force?
I did, yes.
And are they consistent with the legal standards you've been describing?
Yes, there are certainly no inconsistencies. The language used in the state statutes are obviously a little different than language used in the Fourth Amendment case law, but they are broadly consistent, yes.
And did you review Brooklyn Center Police Department policy on the use of force?
Yes, I did.
And is that also consistent with these standards?
Yes, it is.
You mentioned earlier a third step in the process of considering the foreseeable effects of the officer's use of force. Can you explain why that's part of the analysis?
Yes, absolutely. So that gets us into really the fourth step in the analysis. The second step is looking at the threat that the subject presents, if any. The third step, looking at the officer's response. And the fourth step is sort of weighing one against the other, determining whether the officer's response is proportional to the threat being offered. The concept of excessive force, for example, is a way of describing when an officer's use of force is disproportionately high compared to the threat presented by the subject. There are some other factors that go in, but that's essentially the nutshell. You need to figure out what the foreseeable effects of an officer's actions are and weigh them against the foreseeable effects of the threat presented, if any, again, by the subject.
And when you talk about using force and deadly force, is shooting a gun at somebody considered deadly force?
It is, yes.
Why?
The foreseeable effect of discharging a firearm at someone is that it will cause great bodily harm or death. And one of the important things to keep in mind about that is we're talking about the foreseeable effects of the officer's actions, not the effects that actually occur. For example, if an officer shoots at someone but misses, or shoots at someone but causes only a superficial wound, just scratches their shoulder or something like that, we would still consider that a use of deadly force because the foreseeable effect of discharging a firearm at someone is death or great bodily harm. And the definition in policing of deadly force is force that has a substantial likelihood of causing death or great bodily harm.
In the cases that you've been talking about, is there language about hindsight?
Yes. In Graham v. Connor specifically, the court counsels against using what it calls the 20/20 vision of hindsight. That's in the same portion of the opinion where it's reminding courts that are reviewing uses of force that an officer's use of force has to be evaluated from the perspective of the reasonable officer on the scene at the time that force is used, and without adopting the 20/20 vision of hindsight.
In other words, the analysis has to be limited to what set of facts?
The analysis has to be limited to the facts that were available to the officer at the time. You can't bring in facts that are later determined to be true if the officer was not aware of them. So, by way of example, if someone is stabbing at an officer with a rigid, shiny object, and the reasonable officer on scene would think that's a knife, then for purposes of analyzing the use of force, you look at that threat as if it was a knife, even if, after the incident, it's determined that it was really a harmless plastic toy. And in the same vein, if someone, if an officer, for example, tells someone to put their hands behind their head, and the person puts their hands behind their head, and it turns out that they have a sword tucked into the back of their shirt, and they're going to whip it out and cut the officer with it, if the officer doesn't know that at the time, then the use of force would be inappropriate, because so far as the reasonable officer and the officer's position is concerned, the person is just complying with exactly what the officer told them to do. So that concept of not using the 20/20 vision of hindsight is really a stern reminder to not bring in information that the officer was not aware of at the time.
All right, now I want to turn to the opinions that you've reached in this case, okay?
Sure.
The first thing I want to go over with you is Officer Potter's use of deadly force. Is her conduct in firing her Glock at Mr. Wright a use of deadly force?
It is, yes.
Why?
Again, firing a firearm, discharging a firearm is substantially likely to cause great bodily harm or death. That is the definition of deadly force.
And in your review of all the materials in this case, did you see any evidence that Officer Potter decided to use a gun in this case instead of a taser?
Did I see evidence that she decided to use a gun? I think the evidence that I've reviewed suggested that she intended to use the taser and not the firearm.
When you're reviewing, then, the use of deadly force, are you reviewing that act or a decision? Does that make sense?
I think so. If I understand your question, it's really what's the nature of the actions that I'm evaluating.
Right.
I am evaluating the use of deadly force because that is, in fact, the force that was used. I separately have an opinion related to the use of a taser, which is what I understand Officer Potter intended to use in this case.
Earlier, when you were describing the standard, in this hindsight 2020 thing, you talked about what known by the officer at the time. And I meant to follow up on that. At the time of what?
So known to the officer at the time that force is used. For example, just because a person does something at point A does not mean that officers can use the amount of force that would have been justified at point B. The circumstances may have changed. We are talking about dynamic situations. So the question is whether the particular use of force was proportional, and separately whether it was appropriate at the time that force was used.
In this case, have you reached an opinion to a reasonable degree of professional certainty whether Officer Potter's conduct in using deadly force was reasonable and justified?
I have, yes.
And what is that opinion?
The use of deadly force was not appropriate, and the evidence suggests that a reasonable officer in Officer Potter's position could not have believed that it was proportional to the threat at the time. In other words, the use of force was apparently excessive and inappropriate.
And specifically, the use of deadly force.
I'm sorry, yes, the use of deadly force.
In your review of all the materials, is there evidence that Officer Potter herself did not believe that there was an imminent threat of death or great bodily harm?
I apologize. Would you ask that question again?
Sure.
I almost knocked over the monitor.
In your review of all the materials, is there evidence that Officer Potter herself did not believe there was an imminent threat of death or great bodily harm at the time she shot her gun?
Before you answer, excuse me, Your Honor, that I object to that. Answer to that is giving an opinion on a client's.
Okay, counsel, that's enough. No speaking objections, please.
All right.
The objection is sustained.
In formulating your opinion that you just told us, did you consider whether there was evidence about whether Officer Potter believed there was an imminent threat of death or great bodily harm?
Same objection, Your Honor.
The objection is sustained.
In formulating your opinion in this case, Professor Stoughton, is it necessary for you to determine whether there was an objective, whether a reasonable officer would have objectively believed there was an imminent threat of death or great bodily harm?
Yes.
And would evidence of the officer's actual conduct be indicative of or relevant to an objective standard of whether there was an imminent threat of harm, death or great bodily harm?
It would, yes. The phrase that...
Object, Your Honor. It's asked and answered.
The objection is overruled. You may finish your answer.
Thank you, Your Honor. The phrasing that is used in some of the literature as well as our book is referred to as, confusingly, as subjective objectivity. We're evaluating whether use of force is objectively reasonable, for example, but we do so by taking into consideration the subjective impressions of the officer. Again, that's part of the framework of the reasonable officer on the scene.
And so in arriving at your opinion, was it necessary for you to consider the subjective knowledge of the officer on the scene, Officer Potter?
Yes, it was.
And then in arriving at your opinion that it was not a reasonable use of force, of deadly force, did you see any evidence that would lead you to believe that Officer Potter had knowledge of circumstances that would create an imminent or support an imminent threat of death or great bodily harm?
Objection, Your Honor. Improper opinion of the witness.
Okay, the objection is overruled. I'll allow that. Yes. Okay. excuse us. We're going to take a 10-minute break, okay? So thank you. Okay, you may step down, Professor. Okay, I didn't want the jury waiting, and I do think we need to discuss this a little further on what I'm going to allow this expert to testify to. First of all, initially, I'm not going to let him express opinions that were not previously disclosed. Okay? So, Mr. Frank, right now, can you show me where his opinions are concerning the subject that you were on, particularly with respect to his opinions regarding subjective considerations?
Yes, Your Honor. If you would look at Professor Stoughton's report, starting on page 37, the heading itself expresses the opinion that he just gave here in court about the use of deadly force. In that, he goes on to explain that that Officer Potter drew her firearm, even though it appeared that she meant to draw her taser. She drew her firearm, and that opinion, that it was an unreasonable use of force, is informed by a number of factors. One of them is the question of whether a reasonable officer in her position would have believed that an officer, specifically Officer Johnson, could have been harmed, whether there is an imminent threat of harm. And it goes on, page 39, I'm sorry, did I? Yes, through page 38, on to page 39, and into whether that opinion, or whether a reasonable officer in that position would have believed that there was an imminent threat of death or great bodily harm. And he points out the available evidence, and this is the bottom paragraph on page 38, suggests that Potter intended to use her taser. And he explains her subjective conduct. He doesn't use the word subjective, but it explains her conduct. This is all, and then what happens after. What the officers were doing, the other officers, making a decision to go into a vehicle, which is generally not what officers are supposed to do. We heard that testimony earlier. This is all conduct that is corroborative of what she knew at the time. A reasonable officer in her position would have known. It's corroboration, and that's why it's in here. It's all presented here through page 39 and then the page 40. So the court has allowed defense counsel to ask several witnesses if she could have used deadly force to shoot him, and that's obviously going to be an argument they're going to make. Professor Stoughton specifically addressed that in his report that was disclosed to counsel months ago. And that's what I'm trying to address right now, because the allegation is going to be that Officer Johnson was in a position where there was an imminent threat of death or great bodily harm. So would a reasonable officer in her position have known that, justifying deadly force? Well, what did Officer Potter know? What information did she have? Okay? So we have to look for evidence of that. The evidence of that is her conduct before, during, and after, as well as some other things. That's all discussed here. So it's corroborative of what a reasonable officer in the position would have known, what information she had. And so that's because that's what we have to do, right? We can't ask her. And so we are proving it by evidence from the case. That's why I asked him, is there evidence? And so that's why I did it that way. It's to support his opinion.
Okay.
Well, I don't see anything about subjective memory, Your Honor. Plus that, he's making this opinion based on the fact that Johnson wasn't in the vehicle. So, come on, include Johnson in the vehicle and be fair as to the testimony. In this case, two officers, Johnson, who was there, said he was in imminent danger, and Commander Westland said the same when I gave him a hypothetical. And he's never seen this, that he would be in imminent danger. So now we have an expert in here, and the prosecution is asking him a question without including the fact that the witness in this case, the man who was there, said I was in the vehicle, and yes, I was in imminent danger. I could have been dragged. We have more witnesses coming, Your Honor, but for him just to give an opinion without including Mr. Johnson and trying to use my client's subjective, what she said when she doesn't even know she said it, it's not fair.
Okay, Mr. Gray, you can bring that out in cross, and I'm sure that you will.
Oh, I'm sure I will too, but is he allowed to give an opinion without all the facts?
Well, that's what cross is for. And I think the problem that we're having is the word subjective, because he can't really testify as to, he can testify as to what a reasonable officer would have done under the circumstances. And I think in his opinion, he also states deadly force is limited to those situations in which there is probable cause to believe that the subject presents an imminent threat of death or great bodily harm. So I think the state can bring out facts and have him testify as to the facts that would justify a police officer thinking that this that the situation presented a serious threat.
And Your Honor, I'm sorry.
Go ahead.
You're absolutely right. The question is not really whether Officer Johnson was in the car. The question is whether a reasonable officer in Officer Potter's position perceived him as being in the car such that it would present an imminent threat of death or great bodily harm. That's what we're trying to explore. So her subjective conduct, not her subjective state of mind, but the actual conduct that she does is corroborative and explorative of that, and that's why we're going to it. It's part of his opinion. So.
Okay. Well, if he bases his opinions on the facts and not speculate as to what she was thinking.
I'm quite confident that Professor Stoughton knows not to talk about her state of mind.
Okay.
He is going to talk about her conduct.
Okay. I think that's fine.
Doesn't the witness have to base his opinion on the evidence in the case, Judge, and not his vision of something in a video or what he thinks? It would seem to me that the opinion would be unfair even before I cross-examine him, unless he includes that.
You know, I think that's subject again of cross-examination. Okay, so are we clear on where we're going?
I am, Your Honor, and I believe, and I will just take a moment to instruct the witness not to talk about her subjective state of mind. But to be clear, I guess, wanting to clarify this, his discussion of the conduct leads to evidence about knowledge of a reasonable officer at that time. Not about what she's thinking or intending, but what that says about knowledge of an officer in that position.
Right. Okay. I think that's fine. Because he's basically going to be restricted to testifying concerning if a reasonable officer in that position would have probable cause to believe that the subject presented an imminent threat of death or great bodily harm based on the facts. And then Mr. Gray, of course, can bring out the fact that, this professor didn't have all the facts when he rendered that opinion. Okay, let's bring the witness back on. Thanks, Deputy. Okay, please be seated. Mr. Frank, you may continue.
Thank you, Your Honor. Professor Stoughton, let me start out this way. In assessing or arriving at your opinion about whether the use of deadly force was reasonable, proportional in this case, did you attempt to identify any threat of imminent great bodily harm or death?
Yes.
And were you able to identify any potential such threats?
Certainly risk, yes.
Explain.
So from my review of the evidence, Sergeant Johnson entered or leaned his torso into Mr. Wright's vehicle and stayed in that position for approximately 8 seconds. An officer who overextends themselves by putting themselves into someone's vehicle certainly has the potential, if the vehicle begins moving, to be dragged, ejected, seriously injured, killed, run over by the vehicle, or the like. That's always a risk. As I talked about earlier, it doesn't become a threat until there's ability, opportunity, and intention, but it's always a risk of reaching into a vehicle.
And so in determining whether that risk was an actual threat from a reasonable officer in Officer Potter's position, did you look at evidence from the case itself?
Yes, of course.
And in doing that, is evidence of conduct, actual conduct of the officer, corroborative? Does it corroborate what a reasonable officer in that officer's position would have known?
Yes, absolutely. So, for example,
Excuse me, Your Honor, can you answer the question?
Okay. All right.
Not responsive.
All right. The objection is sustained.
Would an example help explain your testimony?
I think so.
Okay. Tell us what the example is then, please.
So, for example, if there are the sound of gunshots on a video, like an officer's body-worn camera video, and the question is whether the reasonable officer in that situation would have perceived that those gunshots were actual gunshots or a car backfiring or a nearby television or something like that, you look at the actions of the people around, including the actions of the officer, to help figure out what conclusions the reasonable officer on the scene would have drawn. If, for an example, with that same example, if the officer remains standing casually leaned against a wall with their arms crossed and really doesn't react, it would tend to suggest that the reasonable officer in that situation would not draw the conclusion that those were actual gunshots that merited an immediate response, for example.
So in evaluating whether this risk created by Officer Johnson's conduct had become an imminent threat, did you consider the conduct of Officer Potter?
I did, and particularly the question as to whether it would have been perceived as by the reasonable officer in Officer Potter's position as an imminent threat. Yes.
And what conduct did you consider, and explain how that affected your opinion?
Sure. In summary, the conduct that is relevant is conduct immediately before and during the shooting itself, and then immediately after the shooting. So with a little bit more particularity, the conduct before the shooting is Officer Potter's apparent decision to use the taser. She threatens twice, "I'll tase you, I'll tase you." She draws a weapon that is her sidearm, her firearm. She gives taser warnings, which is taser, taser, taser. That's in small part a warning to the subject, but it's really a warning to other officers that there's about to be a taser discharge. And then she pulled the trigger of the firearm, aiming it in the area of Mr. Wright's chest. Immediately after the shooting, Officer Potter indicates that was not what she meant to do. She says something to the equivalent of, "Oh shit, I shot him, I drew the wrong gun, or I pulled the wrong gun, I shot him." And then in the next few minutes...
Any more of his narrative regarding what you said after that as indicating something?
The objection is overruled. You may continue.
Thank you, Your Honor. In the next few minutes, there are additional indications that Officer Potter at least, or rather, there are additional behaviors that would indicate that a reasonable officer in her position at the time would not have perceived that there was an imminent threat of death or great bodily harm, most especially her statements about going to prison, indicative that there was a lack of justification for the use of deadly force.
And is there additional indications there at the scene involving what I would like to call backdrop when she actually fired?
Yes. So immediately before the time she pulled the trigger and shot, Officer Lucky was standing immediately to her right and extending over, sort of reaching into the open driver's side door. There was obviously a passenger in the car. And until the time Officer Potter began saying taser, 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 we have that 8-second period of Sergeant Johnson leaning his torso into the vehicle as well. In other words, we're talking about a number of potential targets that could be struck with a bullet in very close proximity. It's generally accepted in policing that officers actually miss their target more often than they hit. So they have to be very aware of what's immediately around their target. It's also well known that bullets can overpenetrate, so officers have to be very aware of what's immediately behind their target. Putting that together, the indication of the putting together the behavior indicating the intention to use a taser, and the rationale that would militate against firearms use, reasonable officer in that situation would not have believed that there was an imminent threat of death or great bodily harm, or maybe a little bit more precisely, those actions are certainly not consistent with the actions of a reasonable officer who perceived an imminent threat of death or great bodily harm.
Now, we've been talking about, well, let me back up just a bit. We've heard some testimony about hollow point bullets. Are you familiar with them?
Yes, I am.
And what is at least one of the purposes of a hollow point type bullet?
A hollow point bullet has a small indentation, on the front that causes the head of the bullet to expand, or it's sometimes called to mushroom, when it penetrates especially soft target, like bodily tissue. There are a couple of different reasons for that. One is to increase the stopping power, the actual kinetic power of the bullet. To the more surface area it takes up, the more kinetic energy it transfers from the bullet that's moving into the body of the person, as opposed to what's called a fully jacketed bullet, which has a shell around the lead of the bullet that just might pierce through someone. So one reason for a hollow point bullet is to have more what's referred to as stopping power. Another reason is to reduce the likelihood of overpenetration. When the bullet expands, the idea is it will stop sooner than a different round, a non-hollow point round.
And you talked about one of the concerns of firing the weapon, the gun, in this case. Would the fact that Officer Potter fired a hollow point bullet have ensured that it would not have presented a danger to others in that immediate area?
No, absolutely not. Hollow point bullets are a pretty standard issue in policing. There are still overpenetration issues in police shootings. And of course, if a hollow point bullet hits a relatively small target, like the muscles of the upper arm, for example, it's probably not going to stop. In fact, it's almost certainly not going to stop there. It's going to overpenetrate. And of course, if it misses the intended target and hits another target, well, then the fact that it's a hollow point doesn't help you at all.
All right, so I want to explore this issue about Sergeant Johnson being in the vehicle a little further. And I want to have you assume, for purposes of this part of the analysis, that a reasonable officer in Officer Potter's position was aware that Sergeant Johnson was in the vehicle to some extent, okay?
Okay.
All right. And I'm going to put up on the screen what's been received as Exhibit 63. And I'm going to ask you just to pause it for a minute, Mr. Miller, and could you freeze this video at the timestamp of 2:01:52, please? And if you want to just go right to it, that's fine. Go a little further, please. All right, so that's fine. Are you familiar with this video?
I am, yes.
Does this appear to be Sergeant Johnson's body-worn camera video?
Yes, it does.
And we've stopped it at 201:52. Are you able to determine what Sergeant Johnson is doing with his right hand at this time?
Yes, Sergeant Johnson appears to be reaching for the shifter with his right hand.
And you've watched the video. Does he eventually succeed at putting his hand on that video?
Yes, he does.
And then if you could, Mr. Miller, just let this run to 201:54, please.
Excuse me, Your Honor, I object to his narration of an exhibit and what he perceives it to be.
All right. The objection is overruled. I'll let you answer.
So again, if you could just run that through 201:54, please. Do you see Mr. Wright's hands there?
Yes, I do. Or at least what appears to be his right hand.
And he is trying to move the shift knob?
Yes.
And does Officer or Sergeant Johnson prohibit that, to keep it from happening?
Yes, he does.
And then if you could run this to 20200, please.
Just stay back.
And if you can just click it a little bit further, please. Now at this point, can you see what Sergeant Johnson is doing?
Yes, I can.
And are you able to see Sergeant Johnson's, well, what do you perceive him as doing in this situation, Sergeant Johnson?
As Officer Potter says, taser, 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 Sergeant Johnson's torso is coming back and out of the front passenger side door. His feet are on the ground there. Both of his hands are on the passenger, or at least in the direction of the passenger. I can't make out from this frame exactly what he's holding.
And does he appear to have hold of Mr. Wright?
I don't. I'd have to watch the video. I'm not sure whether he's holding Mr. Wright's hand there as the fingers, or I believe that is. I believe those are Mr. Wright's fingers, but I'd have to watch it to make completely sure.
So during this course of events, was Mr. Wright able to drive the vehicle?
Not with Sergeant Johnson preventing the vehicle from driving, as evidenced by the fact that the vehicle didn't move until later.
And so in your opinion, if a reasonable officer in Officer Potter's position had been aware of these facts that we've just seen regarding Officer Johnson, would it have been reasonable and proportional for an officer to use deadly force on Mr. Wright there?
No, not at this point. There was certainly some risk while Mr. Wright was scrambling for the shifter to put the car in gear. Once Sergeant Johnson has backed out of the vehicle and is no longer at risk of being dragged or carried away or anything like that, then there is no threat to him of the vehicle moving at that point.
And if you could let this run to 20201, please. At this point, can you see Sergeant Johnson's position?
Yes.
And where is he located at that time?
Sergeant Johnson is physically outside of the vehicle except for his hands, which are still maybe slightly inside the vehicle. His feet are outside the vehicle. It would appear from the frame his shoulders are outside of the vehicle.
In your opinion, if a reasonable officer in Officer Potter's position and was aware that the warnings about the taser caused Sergeant Johnson to back out of the vehicle, would it have been reasonable and proportional for an officer at that time to use deadly force?
No, it would not have been proportional because there is no longer an imminent threat of death or great bodily harm to Sergeant Johnson. He's at no threat of being dragged by the vehicle once he's out of the vehicle.
So in order to have used deadly force when the shot was fired, a reasonable officer in Officer Potter's position would have had to know that Sergeant Johnson was in the car, correct?
Yes.
That and a reasonable officer in officer's position would have not been able to perceive that Sergeant Johnson had prevented Mr. Wright from moving the car?
That's correct. The reasonable officer would have had to mistakenly believe that Sergeant Johnson was, that there was still a threat that the vehicle could move at that point.
And the reasonable officer in Officer Potter's position would have had to fail to perceive that Sergeant Johnson had actually backed out of the vehicle.
That's correct. A reasonable officer in Officer Potter's position would have had to mistake that Sergeant Johnson was still in the vehicle and not in the position that he was shortly before and at the time the shot was fired.
Is there information in this case regarding whether a reasonable officer in Officer Potter's position would have had some awareness of Sergeant Johnson's position or not?
There is evidence that leads me to conclude that a reasonable officer in Officer Potter's position would not have been aware of that.
And what is that evidence?
There are a combination of factors. First, officers, the reasonable officer would not assume that another officer had physically entered a vehicle to that extent. There's a great deal of training and guidance to officers to not reach for shifters or keys or the like. So a reasonable officer certainly wouldn't expect another officer to do so. Second, if a reasonable officer did perceive that there was some imminent threat of death or great bodily harm as by being dragged, in other words, that deadly force was justified, what you would expect to see is an officer preparing to deploy a deadly force option, that is to, for example, potentially use a firearm there. Officers are generally trained that they should draw their firearms in anticipation of having to use them if you see an imminent threat of death or great bodily harm coming. That is, if there's a risk that could manifest or could evolve into an imminent threat of death or great bodily harm, you generally draw your firearm because lesser force options may not be sufficient to actually address that threat. And then on the back end, Officer Potter's behavior would indicate that the reasonable officer in her position would not have perceived that deadly force had been justified. If you perceive that deadly force is justified, well, then using deadly force is always some cause for concern and deliberation, but not consistent with the behavior that we see.
And had anybody indicated, verbalized that they were going to enter the car?
No, there was no verbal statement from Sergeant Johnson that he was in the car. There was no verbalization from Officer Lucky or from Officer Potter that Sergeant Johnson was in the car. Nothing from Mr. Wright or the passenger in his car.
Is there information regarding a reasonable officer in Officer Potter's position to have seen Sergeant Johnson?
Yes. So although you shouldn't mistake the perspective of a body-worn camera for being exactly the perspective of an officer. There can be differences. That is, a body-worn camera will see more than an officer sees, mostly because an officer's vision, like all human vision, is somewhat limited in focus, and on a body-worn camera, everything's in focus. But for the vast majority of the approximately 8 seconds that Sergeant Johnson was in the car, you can't really make that out at all on Officer Potter's body-worn camera footage. It's not at all uncommon. In fact, it's pretty typical in dynamic situations like this for officers to not keep as close track of each other as they might ideally like to. In this case, for example, Sergeant Potter didn't know what Officer Lucky was doing right on the other side of the car.
The objection is sustained on that, and the jury will disregard that last statement.
Your Honor, may I be heard on that, please?
Yes.
To the jury, I'm going to let you go to lunch right now, and we'll get started up again at 1:30. Okay? Okay, the reason I sustain the objection is that this witness cannot testify as to what Officer Potter was aware of. He just can't do that. He can't say she wouldn't have been aware, she wouldn't have been aware that he was in danger or something, because he doesn't have any foundation for that. What he can testify to is whether a reasonable officer in Officer Potter's position would have done, but not testify as to what she was aware of. Okay?
And Your Honor, I have to admit I didn't hear exactly what Professor Stoughton was saying that drew the objection. So, but what I was trying to elicit from him is that Sergeant Johnson testified that he was not aware of what Lucky was doing. And I think the witness may have misspoke and used Officer Potter's name instead.
Okay.
But what I'm asking here, and experts are not sequestered for this very purpose, Johnson testified to that, so it's relevant to what the other side of the car would have. That's the point.
Okay. Yeah, I haven't. His opinions are fine if he's looking at the evidence and drawing conclusions based upon what a reasonable officer would have done under the circumstances. Okay. So, all right. I think that takes care of that. Why don't we break for lunch and start up again at 1:30, okay? Unless Mr. Gray wants to be heard further. Did you want to be heard further?
63rd Avenue North, I believe, at the corner of Catherine Drive.
And you indicated that you responded with someone else from your office. Who was that?
That was Stephanie Erickson, one of our investigators.
And approximately what time of day was it when you arrived on scene?
So we got the call after 5. The placard, which we fill out when we arrive at the site of the body, was the time on that was 6:11 p.m. I believe.
And you indicated that photos are typically taken by your office. Does that include also photos of your arrival on scene and observations on scene?
Yes, part of our field examination includes photography of the scenes of the body and things around the body.
In addition to the photographs during the autopsy process?
Correct, and separate from.
Your Honor, at this time, the state would offer exhibits 99, 102, 103, 105, 107, 108, 110, 114, 116, 118, 119 through 125, 127, 141, 143, 145, 146 for demonstrative purposes, 147 through 149, 152, 155, 157, 158, and 160.
Is there any objection to those exhibits?
Objections were noted.
Yes, okay. And I ruled on those objections. Those exhibits will be admitted.
Thank you, Your Honor.
I'm going to read the instruction on demonstrative evidence. The state is about to introduce a computer-generated animation. This does not serve as proof of any facts in itself. It is presented only to aid your understanding of a witness's testimony or other evidence here in court. If the animation is not consistent with your evaluation of the testimony or other evidence, you should disregard the animation and determine the facts from the underlying testimony or other evidence.
Thank you, Your Honor. And just to be clear for the record, all of the exhibits are offered substantively with the exception of 146, which is offered for demonstrative purposes. At this time, I would ask that we put Exhibit 99 on screen, please. All right, Dr. Jackson, do you see a photograph in front of you?
I do.
And looking at that photograph, could you describe what you observed when you arrived on scene on April 11th?
Yes, we came in from the west. This is a view looking east, and what we see here as we approach the scene were 2 damaged vehicles, some debris in the middle of the roadway, a number of squad cars. Off in the distance there are police tape markers there. We did notice media present and a large crowd gathered beyond the barrier.
And then if we could put Exhibit 102 on the screen, please. You described observing vehicles. Was there also a tent location that was set up behind one of those vehicles?
Yes, adjacent to this white vehicle, which was reportedly the decedent's vehicle, is a greenish colored tent that was erected over the body for privacy purposes.
And did you ultimately enter the tent?
We did.
And what information did you have at that time when you arrived on scene and went into the tent to look at the body?
We were briefed by a special agent from the Minnesota Bureau of Criminal Apprehension and got a little bit more information, namely that a short distance down the road from here, the decedent had been pulled over at a traffic stop and was injured, shot, and managed to drive his vehicle a short distance, and it crashed here at this point where you see it. The individual was unresponsive in the car, removed from the car by law enforcement, if I recall, and pulled a short distance to the grassy yard where the tent was erected over him sometime later.
And did you learn the identity of the individual who had passed away?
We had a tentative identity of Dante Wright.
And was that identity later confirmed?
It was later by fingerprints.
If we could put Exhibit 103 on the screen, please. You indicated that you entered the tent. What was the condition of Dante Wright's body at that time?
This is the view we saw, less the placard that we put on the body, but the body was lying in the grass, covered by a sheet, as depicted here. We could see some clothing emerging from the sheet, and there were some medical interventions and other wrappers on the ground.
If we could put Exhibit 105 on the screen, please. Could you describe what you did after observing the body with the sheet?
Yes, after this is the field examination portion of our work, and we removed the sheet, exposed the body as you see it here. Again, looking at different medical interventions that are present, the clothing that is somewhat disturbed, likely due to medical intervention, the process of medical intervention there. And we've placed our placard with pertinent information known at the time over the body for this identification photo.
And then you indicated that the placard had a time. Is that the 1811 that's noted there?
Yes.
And would that be 6:11 p.m.?
Correct.
And the ME staff noted there S. Erickson. Is that Stephanie Erickson from your office?
That is correct.
Could we put Exhibit 107 on the screen, please? Did you make some closer observations of the body on the scene?
Yes, we did. We've taken a number of photos. This particular photo is a close-up of the left side of the decedent's body, and what's depicted here are a number of medical interventions. The one centered in the photo is a clear adhesive patch and occlusive dressing that's placed over a gunshot wound. There's some dark discoloration that you can see there in this image, and that is dried blood, essentially.
And after observing the body on scene, what did you do next? If we could put up Exhibit 108 so you could describe.
So after we complete our field examination, which entails, again, looking at the body and the items surrounding it and on it, we'll gently roll the body and examine the back, again, searching for potential injury. Once we have completed our field exam, we will bag the hands, which means putting paper bags over the hands to potentially preserve any trace evidence that might be there. Then we'll carefully put the body in a body pouch and seal it with a zip-locking tag, which is pictured here. This is the yellow tag going through the zipper pulls, and that's labeled with the decedent's medical, or the decedent's ME number, which we've established, the date and time of the bag seal, and initialed by the witnesses.
And when you describe the date and time of this seal and initialed by the witnesses, is this here that seal that you're describing?
Yes, it is.
And it indicates 4/11/21/1835. Would that be 6:35 p.m.?
Yes.
And what does that time indicate?
That is the time that I filled out that bag tag and sealed it on the pouch.
So would that have been the approximate time you had bagged the body?
Yes, directly. It would be 1 minute before that we put the body in the bag.
And then the initials noted there, whose initials are those?
Those are Stephanie Erickson, the investigator, and LJ, my initials.
And after you sealed up the body, what was done with the body?
So in the field, this is a picture of the bag as we saw it the following morning, but after we seal the bag in the field, the body is transported to our office, and we have a transport company that actually effected this move, and they arrived shortly after we did at the scene.
And was it the next day, on April 12th, when you began the autopsy process?
Yes.
Did you start with x-rays on the morning of April 12th?
Yes, in cases of gunshot wounds, we identify potential sites of injury and get x-rays of those so we can identify potential locations of bullets to make recovery easier the following day. So that did occur the morning of the 12th.
And if we could put Exhibit 110 on the screen, please. Could you describe for the jury what's shown here?
Yes, these are side-by-side images of Dante Wright's chest, and you can see there's a number of things going on here. On the left-hand image, which is an anterior, posterior, or front-facing view, you can see a number of wires of medical interventions. On the decedent's right side, which is the left side in this view, we're looking at the images. If we're looking at the patient, you can see a bright white object, and that is a retained projectile.
And if you could use, there's either a stylus like this or your finger to circle the item that you're describing on that image, please.
Yes, there I've circled the retained projectile.
And then after taking these x-rays, did you, slightly later in the morning, start the full autopsy exam process?
Yes.
And did that include, as you described earlier, examining the body as it was before cleaning and doing additional further examination?
Yes, that's standard procedure.
Could we put Exhibit 114 on the screen, please? Could you describe what's shown here, please, in Exhibit 114?
Yes, we take pictures of the body as is. So this is after I have broken the seal on the body bag, and without disturbing the body or any of the contents, we take the as-is photograph. So this is a view of the lower half of the decedent's body. You can see jeans there. There's a single shoe on the left foot, a sock on the right.
And the condition of the clothing and body as it is depicted here, was that as it was on scene when you had observed the body the day before?
Yes.
Could we put Exhibit 116 on the screen, please? And what's shown here?
So this is a photograph that is one image more superior or towards the head relative to the picture we just saw. I've placed a privacy towel over the decedent's privates, and what we're seeing here again is a view of the body similar to that as we saw in the field. You can see medical interventions, clothing as we saw it in the field, and particularly medical interventions overlying gunshot wounds of the chest here.
So at this point, all of those medical interventions are still attached to the body, is that right?
Yes, this is the very as-is photograph, so we haven't manipulated those interventions in any way.
If we could put Exhibit 118 on the screen, please. Did you do some further examination of those seals that you had described and sort of continue to look in those areas?
Yeah, so as I alluded to earlier, we take photographs and document what we see initially, and then we remove in a stepwise fashion the various clothing articles and interventions. What we're looking at here is the injury on the lower left side of the chest, and I've peeled away the occlusive dressing that was placed in the field.
And could you please, for the jury, just describe the difference between an entrance wound and an exit wound?
In general?
In general, and then as applied to the images that we see.
Yes. In general, entrance gunshot wounds have a circular or oval appearance. There's usually some missing tissue in the center of the wound. There can be abrasions around the edge of the wound. This particular image that we're looking at here does show a wound that has those features. We will see a cleaned up version of this in subsequent images.
And when you say those features, is what you observe here consistent with an entrance wound?
They are, yes.
And then if we could put Exhibit 119 on the screen, please. Could you describe what's shown here, please?
So this is the picture of the right side of the chest, again with the occlusive dressing peeled back, showing an area of injury. It's difficult to see here due to the presence of blood, but this is the opposite injury.
And when you say opposite injury, would you characterize that as, how would you characterize that?
Yes, we will see that the injury on the left side of the chest is an entrance wound, and this will be shown to show features of an exit gunshot wound. It happened when we peeled back this dressing that you could actually palpate or feel the bullet directly below the skin adjacent to this wound. So that was a definite clue that this was the exit side.
And then after removing the item, removing the medical interventions, removing the seals, documenting that process as you went along, did you ultimately clean the body and then continue to do further investigation or examination.
Yes.
If we could put Exhibit 120 on the screen, please. Could you describe what's shown here, please?
So this is a view of Mr. Wright's chest from the front, and pictured here are the entrance and exit wounds. May I mark
Yes, you may.
these areas? So again, on the left side here and on the right side here are the gunshot wounds in question that we've looked at initially.
And what, if anything, is significant to you about the positioning of these two injuries?
Other than the fact that they are on the front side of the chest, the anterior side of the chest, and there's a little swelling around these wounds beneath the skin, suggestive of hemorrhage. Those are the major findings.
And I'll ask you some more about this as we go on to your internal examination, but looking at the body externally, did this give you any indication with respect to trajectory or a bullet path?
Yes, again, given the fact that there was a bullet present on the right side of the decedent's body and an entrance defect on the left side, it suggested a rightward progression of the bullet through the body.
And if you could just indicate with your finger the direction of travel that you're describing.
Yes, so a bullet entering approximately near this red dot, but below it, would have traveled in this general direction here, as I've indicated.
And then if we could put exhibits 121 and 122 on the screen next to each other. If Your Honor, if you could clear the screen, please. Thank you. Could you please describe for the jury what's shown in exhibits 121 and 122?
Yes, so this is a left side view of the body in the left-hand photograph. We've looked at this from the front and with the occlusive dressing peeled partly off. What we're seeing here is the cleaned version. On the right-hand side is a zoomed-in image of the wound on that left side of the body.
And as part of your autopsy process, when it comes to gunshot wounds, do you typically look for things like soot or stippling on the body?
Absolutely. In addition to trying to assess what an entrance or an exit wound might be, we try to assess for clues as to range of fire. And sometimes these are present, sometimes they are not. When we have, for instance, evidence of a muzzle abrasion, so markings on the skin suggestive of contact with a gun, then we know it's a contact range of fire. If we find evidence of soot or gunpowder deposition or gunpowder stippling, which is a punctate or dot-like abrasions on the skin that occur based on the impact of gunpowder, we can say that it was a intermediate range of fire, so between contact and 2 or 3 feet at most. In this case, we found none of those identifiers, not on the skin and not on the clothing, so we settled on indeterminate range of fire, given the lack of specific evidence.
And just to clarify, when you say you saw none of those, you did not see soot or stippling, is that correct?
Correct.
And when you say indeterminate, maybe you could just describe to the jury, what does it mean to have an indeterminate range of fire?
So indeterminate range of fire simply means that we don't have specific clues as to a definite range of fire, so it leaves it open to the possibility of interpretation.
If we could put exhibits 123 and 124 on the screen, please, next to each other. Dr. Jackson, exhibits 123 and 124 are on the screen. Could you please describe what's shown here?
Yes, the image on the left shows a gunshot-related defect, on the right side of the body, and the image on the right is a close-up photograph of that same injury.
And how would you describe this? I know you had initially used the term maybe partial exit wound. Do you have another way of describing this injury as well?
Yes, let me just explain what a partial exit wound is. If the bullet goes in and out of the body, you have a classic exit wound. In this instance, because the bullet made a defect, made a hole in the skin, but did not leave the body. We call this a partial exit, and this occurs when there's not enough velocity for the bullet to escape the body. We see this on occasion. Other features of this injury that we see are areas of red-brown abrasion and that are present on the edges of the wound, and this is something that is consistent with what we call a shored exit. And this can occur when the skin is pinched between the bullet, which is pushing outward on the skin, and rubbing against some other object. In this case, it's likely the clothing, the decedent's clothing, such that the skin gets pinched there and a rub spot occurs or an abrasion is formed.
Now, Dr. Jackson, before we get to your internal exam, I'd like to ask about the rest of the body. Did you also examine the rest of the body for injury?
Yes.
And if we could put Exhibit 125 on the screen, please. Could you describe what's shown in Exhibit 125, please?
Yes, this exhibit shows a close-up of the decedent's face and neck area. And on this image, which is a cleaned image, we can see areas of abrasion on the right nostril region and what is a laceration with some abrasion below the right lip.
And if we could put Exhibit 127 on the screen, please. Could you describe what's shown here?
Yes, this is a picture of the decedent's lower lip, and on that right aspect of the lower lip, you can see a laceration. This actually communicated with the abraded-looking lesion on the prior image.
And how would you characterize these injuries to the face that you saw in Exhibits 125 and 127 on the lip and the nose?
I would call these superficial blunt force injuries.
And when you say superficial, what does that mean?
I would say that these injuries are non-life threatening, particularly in with respect to comparison with the gunshot wound.
Are they consistent with the circumstances that you were aware of surrounding the time of death, including a potential vehicle collision?
Yes.
Were these injuries significant in any way with respect to your finding of cause and manner of death?
No, the blunt force injuries that we identified on the body did not contribute to the cause of death.
And did you also examine the rest of the body for other injuries as well?
Yes.
Did you find some other superficial injuries?
Yes, there were other superficial abrasions and some bruises or contusions.
Bruises and contusions, were those on things like the arms and legs?
Yes.
Could you just provide sort of a general overview of the types of things that you saw?
Yes, so small abrasions were found on the arm and forearm on the left side. For instance, these appeared much like rug burns in terms of their degree of depth. So again, superficial injuries. There were some minor abrasions on the right and left sides of the back, very much like simple scratches. And there were some contusions or bruises on the lower extremities as well, around the knees and the thigh on the left side.
Were any of those injuries that you observed that you described as superficial, were any of them significant with respect to your findings of cause and manner of death in this case?
No.
Would they all be consistent with the circumstances surrounding death, including a vehicle collision?
Certainly the collision or the process of extrication and resuscitation.
And when you discuss extrication, did you also observe some dirt or grass on the body as well before it was cleaned?
Yes, there were a few streaks, linear marks as if someone had been pulled across dirt, yes.
And again, were those consistent with what you understood to be the circumstances surrounding the collision and the extrication from the car?
Yes.
All right, getting back to, what was the most significant injury with respect to your exam?
Far and away, the gunshot wound to the chest was the most significant injury.
Now, getting back to that gunshot wound, you told the jury a little bit about your external exam and your observations there. Was the trajectory in that bullet path further evidenced by the internal exam that you conducted?
Yes.
And then, with respect to that internal exam, did you follow that same protocol, that same procedure that you described earlier?
Yes.
And did that include examining the inside of the body and the organs as well?
Yes.
And conducting that part of the exam, were you also able to determine what organs had been struck by the projectile inside Dante Wright's body?
Yes.
And then did you ultimately recover a projectile as well?
I did, yes.
And where was that projectile recovered from, approximately?
Yes, so that projectile was recovered from the skin, or below the skin on the right side of the chest wall near the fourth intercostal muscle, and that's between the level of the fourth and fifth ribs approximately.
If we could put Exhibit 141 on the screen, please. Could you describe what's shown there, please?
Yes, so this is an image. We've progressed to the internal portion of the examination, and this is a view of Mr. Wright's chest with the skin reflected. So what we're looking at are the ribs and the breastbone, and you can see areas of hemorrhage on the left and right side of the body that are consistent with the points of entry and exit of the bullet through the chest wall.
And could you just indicate on the screen where those areas of hemorrhage are, please?
Yes, so these are the dark areas present here and on the right side in this vicinity.
Okay. And then was there could you indicate the approximate area where the projectile was recovered as well?
Yes, the projectile would have been recovered. So the defect in the muscle on the right side is approximately here, so the projectile was recovered near where I made an attempted asterisk.
And then if we could put, just a moment, if we could put Exhibit 143 on the screen, please. Could you describe what's shown here?
Yes, so this might be a little bit disorienting. This is a view of the chest plate that we've removed, and it's viewed from the inside. So what we're seeing here are the ribs, and we're seeing the perforations through the muscles and the bone on the left-hand side. And there's a probe that's inserted to demonstrate the approximate path of the bullet. And again, this is inside the chest, so the left side is the decedent's left side, and the right side is the decedent's right side.
And do you, through the course of your work, sometimes use rods or probes like this to help you establish trajectory or a bullet path?
We do.
And if we could put Exhibit 145 on the screen, please. Could you describe what's shown here, please?
Yes, this is a review or an the exhibit that shows the damage to the front of the heart, and there is a gap in the tissue covering the right ventricle, the left ventricle, and the muscular septum that divides the two ventricles.
And when you say gap in the tissue, maybe you could just describe what you mean by that.
Yes, there is normally, instead of being able to see inside of the heart, there's tissue and blood vessels that would span this gap, this defect that we're seeing in the heart wall. And they're missing here in this image.
And in a normal heart, a healthy heart, would that all be covered up?
Correct. It would look more like the surfaces that you're seeing at the very top of the image.
Okay. We could put Exhibit 146 on the screen, please. Now, using this image, could you please describe what organs were impacted and what you observed on the inside of the body with respect to the trajectory?
Yes, I selected this diagram, and I would point out that it is a diagram in 2 dimensions, so it doesn't capture exactly the orientation in the body, but it does show the general pattern of injury. So there is an arrow superimposed over the heart and lungs depicted in this diagram. The entrance point was somewhere near the base of the arrow, and the bullet was recovered somewhere near the tip of the arrow. So you can see, even though that the wound direction was shallow through the chest, as we saw in the previous image, it did cross areas of the left lung, the heart, and the right lung.
Again, members of the jury, remember this is demonstrative evidence. It will not go back to the jury room with you.
Dr. Jackson, I know I didn't show you photographs of the lungs, but could you describe for the jury the damage to the organs in the body that you observed consistent with this demonstrative exhibit?
Yes, both the left lung and the right lung, the anterior portions, or the portions abutting the chest wall in the front, were damaged, almost a graze wound, but very superficially injured by the bullet. The majority of the injury was to the heart.
Did you also recover a substantial amount of blood from inside Mr. Wright's body during this process?
Yes.
Approximately how much blood did you recover?
So the combined volume from both sides of the chest, so around the right and left lungs and the heart, were over 3 liters of blood.
And 3 liters, why is that significant?
That's significant because an individual of Mr. Wright's size would have approximately 4.5 to 5.5 liters of blood in his entire body, and when you lose half of that rapidly, your condition becomes critical.
And when you say critical, what does that mean?
It's a life-threatening situation.
With respect to timing, was this gunshot wound, the injuries that you observed through the heart and the lungs, was that a survivable injury?
As a forensic pathologist, I would say no.
How long does it take for someone to die after being shot through the lungs and heart like this?
Injuries like this, we refer to survival times in terms of seconds to minutes in these types of injuries.
And with respect to loss of consciousness, how long does it take for someone to lose consciousness after an injury like this?
Well, one can lose consciousness within 10 to 15 seconds after blood supply is cut off to the brain.
Now, Dr. Jackson, do you have, throughout your experience as an assistant medical examiner, experience with a variety of different types of ammunition of different calibers?
Yes, that's part of our training.
And have you observed and recovered projectiles of both large and small caliber?
Yes.
If we could put exhibits 147 and 148 on the screen next to each other, please. You indicated that you recovered a projectile. Could you just describe what's shown here, please?
Yes, so this is the image on the left and right show front and back views of the projectile that I've recovered. It's a clean view. What we're seeing here is a projectile with an expanded tip. It's a copper color jacketed projectile with a lead color core, and the image on the left shows the base view of the projectile, which had a measured diameter of 9 millimeters.
And with respect to your measurements, would that be consistent with a 9 millimeter round?
Certainly would, and those are measurements I made at the time of autopsy.
And when you describe the expansion or the condition of the bullet, maybe you could contrast that with other bullets that you've seen.
Well, I think what we're seeing here is a bullet that does show an expanded tip, and some people call this mushrooming, the appearance that we're seeing here. Others see a petal-like arrangement, and this can happen in certain types of ammunition.
And would that be consistent with a hollow point round?
Yes, hollow points often look like this.
And what, if anything, in your experience as an assistant Hennepin County medical examiner, is significant about a round of ammunition that displays this type of effect, this petaling or mushrooming?
I think the main thing is these bullets oftentimes stop within the body, which is consistent with what we found here.
And again, is the condition of this bullet and the injuries that you saw, is the condition of the bullet consistent with the injuries that you saw?
Yes.
Including the damage to the heart and the lungs?
Yes, a bullet like this could cause the injuries that we've observed.
You also described an examination of clothing. Did you examine Mr. Wright's clothing in this case? case as well?
Yes, I did.
If we could put exhibits 149 and 152 on the screen next to each other, please. Could you describe what's shown here, please?
Yes, this is Mr. Wright's shirt, the shirt that he wore presumably under his jacket. I put it in place on a mannequin so that we could photograph it, and there are defects on the left and right sides depicted here. They're small, but they're present.
And when you say defects, could you circle them or indicate them, please, on the screen?
Yes, so on the left-hand image, I'm going to circle an area on the front left side of the shirt. I put a piece of white gauze behind the hole of the defect to illustrate where that is. And on the image on the right, which is the right-hand side of the shirt, I will circle this image here. That is an area of a defect in the fabric or a hole in the fabric.
So when you say defect, does that mean hole in this case?
Yes, they're interchangeable.
And were those holes consistent with the trajectory and the injuries that you observed?
Yes, they approximately recapitulate the injuries that we saw on the body.
And then if we could put exhibits 150, or just put exhibit 155 alone on the screen, please. Did you also examine a jacket as well that Mr. Wright was wearing?
Yes, this is the jacket as placed again on the mannequin.
And with respect to the red substance on the clothing, was that consistent with blood?
Yes.
And then if we could put exhibits 157 and 158 next to each other on the screen, please. Did you also examine the jacket for defects or holes?
Yes, and holes were found near the pockets on both sides of the front of this jacket.
And if you could indicate them on the screen.
Yes, so on the left, circled here, is a hole with frayed margins that is present near the front left pocket. And on the right image is a defect that I found in the lining of the pocket, the right pocket. And again, I put white gauze behind that to make it photo worthy.
Now, obviously, Dr. Jackson, the pocket line of someone's clothing might not be typically where you would expect to find the heart. Could you describe if these defects or holes would be consistent with clothing being bunched up or raised up on the body?
Yes, certainly, depending on where the clothing was positioned, they could be consistent with the pattern. And we do have them on the left and right sides of the garment. And again, that, like we saw in the shirt, it is similar and supports the same pattern we saw on the body.
Now, during your autopsy examination, did you collect a number of samples as well?
I did.
Things like blood and hair, nail clippings, and fingerprints? Is that
Yes.
right? And you indicated that you also collected these, this projectile as well as the clothing, is that right?
Correct.
And were those items all provided to the Bureau of Criminal Apprehension?
Yes, they were.
And then with respect to the toxicology testing in this case, did you also collect femoral blood and urine for toxicology testing in the afternoon of April 12th?
Yes, during the course of the autopsy.
And then did you order testing on those samples as well?
I did.
And what screens were done on the blood?
So we did a comprehensive screen on the blood, and that includes an expanded panel and additional studies. And our aim was to potentially survey for as many possible drugs as possible in this case.
Did that include looking for hundreds of drugs?
Yes, hundreds of drugs were sought after, yes.
And what did you get the results of those tests?
We did.
And what, if any, compounds were found from the testing of the femoral blood?
Cannabinoids were the only thing found in the decedent's system.
And when you say cannabinoids, is that THC and its metabolites?
Exactly that, yes.
And are those related to marijuana?
They are.
Were those toxicology results that you received in any way significant with respect to your determination of cause and manner of death?
No, they were not.
And then on exam, did you find any natural disease or natural defect that would have caused Mr. Wright's death?
No, the only thing we found were injury-related changes associated with the gunshot wound.
And now, Dr. Jackson, based on your training and experience, did you ultimately determine a cause of death for Dante Wright in this case?
Yes.
And what was the cause of death?
The cause of death in this case was gunshot wound of the chest.
And did you also determine a manner of death for Dante Wright?
Yes, this is certified as a homicide.
And what is the definition of homicide with respect to your work?
Homicide is death at the hands of another.
And how did you make the determination that Dante Wright died by homicide?
The examination of the wound and the history provided supported that he was shot by another individual and succumbed to those injuries.
And if we could put Exhibit 160 on the screen, please. Dr. Jackson, is this a copy of your office's final ME report for Dante Wright?
Yes.
And that's based on your findings, but signed by the chief medical examiner in your office?
That's correct. That's routine policy. Yeah.
And with respect to manner of death, focusing on this area here, what is indicated as the manner of death?
Manner of death is homicide.
And what's the immediate cause that's indicated?
Judge, I object to this. She's gone over this 3 times now. The cause and manner of death.
The objection is overruled. You may answer.
You may answer, Dr. Jackson.
Immediate cause of death is gunshot wound of the chest.
And then did you also indicate how the injury occurred?
Yes.
And how was that?
And we've listed here, decedent was shot by another person, and in parentheses, law enforcement officer.
Nothing further, Your Honor.
Counsel, you may cross. You may cross.
Okay. Good morning, Doctor.
Good morning.
With respect to the homicide and cause and manner of death, that has nothing to do with criminal statutes, is that right?
That is correct. Our manner is a medical opinion.
Okay, and it's quite obvious that the cause of death in this case was a gunshot wound to the chest, correct?
Agreed.
And I notice in your autopsy, your final autopsy, excuse me, you wrote 20-year-old man who was shot by a police officer after a traffic stop and subsequently drove his car a short distance before colliding with another vehicle. Is that the information you received when you came on the scene?
That's correct.
And the marijuana found in the system, did you send that to a lab or some other place to determine how much marijuana was in the system?
Well, as a part of the normal toxicology studies, they do quantify those numbers, the numbers of marijuana or anything they do find, yes.
And do you know what the quantify what the result was?
They're in my report.
Okay, and what are they?
If I may refer to my report.
Sure.
So in the femoral blood, we found 11-hydroxy delta-9 THC, which is a metabolite. The level present was 6.9 nanograms per milliliter. There was delta-9 carboxy THC, which is an inactive metabolite. This was present at a concentration of 120 nanograms per milliliter. And delta-9 THC, which is the active ingredient in marijuana, the level was 43 nanograms per milliliter.
And the active ingredient, what you mean by that is that's what affects you when you take the marijuana?
Yes.
And is 43 a high reading?
43 is a number within the normal range of individuals reported that use marijuana.
Okay. Use marijuana regularly or right before the death?
That's difficult to ascertain based on just the numbers alone.
I don't know if you answered my question. Is that a high reading based on your experience, toxicology-wise?
It's on the high end of numbers that I see, yes.
Thanks. And you testified that Mr. Wright was conscious for seconds after he was shot. Fair statement?
Does he have children? Are there children that he has of his own?
He does. He has a 1-year-old son.
Okay. And what's his son's name?
Dante Jr.
How old is Dante Jr.?
He just turned 2 in July.
He turned 2 in July. When was he born?
He was born July 12th
Okay.
of 2019.
And who is Junior's mother?
Her name is China Whitaker.
Your Honor, at this point, I would plan to offer some Spark of Life photographs. I understand that there's no objection to foundation, but we would offer exhibits 3 and 4 at this time.
Is there any objection to 3 and 4 other than? Okay.
Exhibits 3 and 4 will be admitted over defense objections.
Thank you, Your Honor. And I would ask for permission to publish Exhibit 3, please. May we publish?
Yes, you may. Excuse me.
Ms. Bryant, there should be an image that you can see on your screen, and there, now it's published for the jury. Can you describe to me what's pictured, and describe for the jury what's pictured here?
This picture was last July, and it was Dante Jr.'s first birthday. We had a barbecue at China's house.
And is this a picture of your son Dante with his son Dante Jr.?
Yes.
Did your son Dante have a close relationship with his son?
He did. Dante Jr. was at our house often, at least 3 or 4 times a week, if not more.
And if we could publish Exhibit 4, please. Exhibit 4 is now on the screen. Could you describe for the jury the photo here, please?
This is when we took him out to eat at Teppanyaki Grill after Dante Jr. was born. When Dante Jr. was born, he was only 28 weeks. China was only 28 weeks along, and he was very premature. And he had to stay in the hospital for about 3 or 4 months. So that's when we took Dante out for dinner to congratulate him on his son.
And did your son Dante spend time at the hospital with Dante Jr. while he was there?
He did. The bracelet that's on his hand is actually the hospital band to be able to get into the ICU unit, to be able to see Dante Jr.
And you said that Dante Jr. was in the hospital for 3 or 4 months. Was your son Dante regularly at the hospital during that time period?
He was. He actually was able to feed him his first time with you'd have to feed him with a Q-tip. You would dip it in milk. So he was able to do that for his first feeding, and he visited often.
After Dante Jr., was Dante Jr. eventually released from the hospital?
He was.
Did your son Dante continue his relationship with Dante Jr.?
He did.
Tell the jury about that relationship, how you would see him and what they would do together.
He was very proud to be a father. He was also a worried dad just because he was premature about him sleeping, and because he did sleep a lot as a premature baby, and he was really worried about that. He would play with him. He would do everything that a father needs to do for his child. He was an amazing dad.
So, Ms. Bryant, and take your time, please, but I'm going to ask you some questions about April 11th of this year, okay? Could you tell the jury what you were doing that day?
I had Dante Jr. He stayed the night, and it was just an average day. We woke up, he ate, he liked his favorite is the mini chocolate chip pancakes, and he was eating breakfast, watching Coco Melon, and it was time for his nap. That was around 12 something that afternoon.
And did you end up were you watching Dante Jr. By yourself for part of that day?
Yes.
And then did you end up seeing your son Dante later on in the day?
I did.
Could you describe that interaction for the jury, please?
Dante came home in the afternoon, and I was laying Dante Jr. down at the time. He knocked on the bedroom door, and he asked for $50 because he wanted to go get a car wash, and he said he needed gas. And I told him to be really quiet, take it out of my purse. So he took it out of the purse, he leaned over the bed, he gave Dante Jr. a kiss goodbye, and I yelled at him again and told him, please don't wake him up, like I just got him to sleep. And then he left. I told him to make sure he locks the door on his way out.
So you indicated that your son Dante Wright was on his way to get a car wash and had gotten some money from you for that. What was the car that your son Dante Wright was driving?
A white 2011 Buick LaCrosse.
And was that Dante's car?
Yes.
And how did that come to be?
It was one of our older vehicles. It was in my other son's name, but we ended up giving it to him as his first car, like 2 weeks before he was killed.
And when you say giving it to him, was he the only one who was driving the car in that 2-week period?
Yeah, he was the only one that had access, that he had a key to the car. It was his.
But was the car still registered to your other son?
It was still registered to my son Dallas. Yes, it was still registered to Dallas.
And what about the insurance on that car?
We did not transfer over insurance yet, so we were going to add it to our current insurance policy.
But that hadn't been done yet?
No.
On April 11th, did you go into that car, have any interaction with Dante in that car?
No, I did not.
And had you been in that car or driven that car, used that car in that 2-week period prior?
No, I have not.
Okay. So getting back to April 11th, after Dante, your son Dante Wright, took the money to get a car wash, what happened after that?
He called probably about 10 minutes after he left the house, and he asked me what car wash we usually go to, because we have a specific car wash that we go to in Fridley off of University. And I told him that, and he was like, well, isn't there one in Brooklyn Park? And I said, well, yeah, I think it's Mr. Car Wash. And he said he was going to go to that car wash. And I said, okay, don't call back again, because I was really adamant about Junior not waking up.
And is Junior what you call Dante's son, Dante Jr.?
Yes, Dante Jr.
And was your concern just not waking up Junior?
Yes, not waking Junior up.
So after that call where you discussed which car wash to go to, was there a second call after that?
There was.
And about how much later was that?
Oh my gosh, maybe 10, 15 minutes later.
And what was the nature of that second call?
He called me to tell me that he has been pulled over. And I asked him, I said, for what? and he said that the police officer said that he had an air freshener hanging from his rearview mirror. So at that time I told him, I said, well, you should take it down. And he said he already did. And then he said that they were also asking about insurance information. And I told him to, when the police officer gets back to the window, to please hand him the phone so I could explain the insurance and give him my insurance policy that we haven't added it yet.
When you talked to your son, Dante, how did he sound to you during that call?
He sounded nervous, scared. He asked, if he was in trouble. I said, no, you haven't done anything wrong. And he just sounded really nervous. But I reassured him that it would be okay.
Take your time. When he placed these calls to you, how were you receiving these calls? Was it through a cell phone network or some other way?
It was through Facebook Messenger. It was voice calls. He didn't have phone service at the time, so he was calling through Facebook Messenger.
And so after you had this initial conversation with your son, Dante, about wanting to talk to the officers, what happened after that?
I heard the police officer come back up to the window and he asked Dante to step out of the vehicle. And Dante asked, for what? Am I in trouble? And I heard the officer say, I need you to just put the phone down, step out of the vehicle, and I'll let you know as soon as you step out of the vehicle. And then at that time, I heard the phone either being placed on an object, whether it was dropped on the floor or placed on the dash, I'm not sure, but I could hear the phone being put down. And then I heard the officer telling Dante, no. And I heard Dante say, no, I'm not. Don't. It sounded like he said, don't run. Dante said, no, I'm not. And then I heard them say, somebody tell somebody to hang up the phone. And then that's all I heard.
Did the phone disconnect?
It did.
After the phone disconnected, then you heard what you described. What happened next?
I was panicked. I called back. It seemed like 100 times, but I believe it was probably maybe 4 or 5 times, and I kept calling. So finally, I FaceTimed. I would say I don't know how much time lapsed, maybe a minute or two. And then a female answered the phone because it was FaceTime. She was screaming. And I was like, what's wrong? And she said that they shot him. And she faced the phone towards the driver's seat. And my son was laying there. He was unresponsive, and he looked dead. And then I heard somebody say, hang up the phone again. And it disconnected again.
So after that phone call disconnected, or you said it was a video call at that point, so you got to see your son Dante. What did you do after that video call?
I grabbed my grandson and I called my husband because he wasn't home. I said they just shot Dante. And he said, what? And he said that they just shot him. And I said they just shot him. The police officer just shot Dante. They have no clue where they are. And I hung up with him. And then I called 911 because I needed to find out where my son was.
And did you, in fact, make that call to 911?
I did.
What did you learn when you made that call?
they transferred me to a few different police stations. I said my son was just shot by a police officer and I need to know where he is. And they transferred me to, I think it was Brooklyn Park or Brooklyn Center. I don't remember which police station or which 911 operator answered, but they gave me an address of 63rd and Catherine. And I put it in my GPS, and I grabbed my grandson, and I got into my vehicle, and my neighbors heard me screaming because I like fell to the ground because I didn't know what to do. So she helped me up. She put us into the vehicle, and then she drove us to 63rd and Catherine in Brooklyn Center.
A neighbor who drove you and Dante Jr.?
Yes.
And about how long did it take for you to get to that location?
Oh, it seemed like forever. I felt like we weren't getting there fast enough, but probably 7-8 minutes, maybe a little bit longer.
And is that where you went to that location at 63rd and Catherine?
Yes.
And what did you see when you got there?
So we were driving down Brooklyn Boulevard, coming up to 63rd, and there was a lot of traffic, a lot. So I got out of the car because I could see, when we were waiting to turn, I could see all the police lights, probably about 6 blocks down. And I got out of the car and I started running towards Catherine because the traffic wasn't moving fast enough. And then the car that I was in ended up catching up with me, and I got back in for another 2 blocks. And then I got out again and ran the last 2 blocks to where all the yellow tape was. And then I went under the yellow tape because I seen a car crash, and I noticed it was my son's car. And then in the front of his car is where he was laying.
Did you see your son's body on the ground?
I did.
So what did you do when you got to that area?
I was so distraught. I didn't know what was happening. I just got off the phone and they said he shot him, but I seen a car crash. I was asking questions. I didn't want to believe that was my son laying there on the ground, but I could tell it was him because of his tennis shoes.
And when you say you could tell it was him because of his tennis shoes, was it only part of his body that was visible to you?
They had a white sheet over him.
But you recognized his shoes?
Yeah.
Your Honor, at this time I would offer Exhibit 6. Again, I understand that there's no foundational objection to that exhibit.
And what is Exhibit 6?
It's a video of Ms. Bryant arriving on scene.
Okay. Is there no objection? Exhibit 6 will be admitted into evidence, and you may publish, counsel.
Thank you.
Hi. Touch me, I swear, fuck you. I can't. My father. I don't know anything. Who are you? I am Katie Bryant, his mom. I gotta see you now. Please. Wait, you got my 20.
I don't know what's going on.
I know what's going on.
What happened?
He FaceTime live. Ma'am, I'm gonna get you somebody to talk to. I'm gonna get you someone to talk to. Okay? But I just can't have you going over there right now, okay?
Ma'am, my name is Mark. What is your name? Can I have you sit on the ledge here?
You guys shot him. Why?
I don't know. I wasn't here.
Why? Because he had a warrant. Are you fucking serious? I was here. I watched it.
Can you sit down? Tell me what's going on, because I wasn't here.
No. so you can kill my son. That's pretty pathetic.
What is your name?
We got
What is your name?
My name is Katie Bryant. My son's name is Dante Wright. You guys already know that.
I don't. Katie Brian.
It was a high-speed chase.
Brian?
How?
And then what's your son's name?
Dante Wright. It was not a high-speed chase. You guys shot him in a pullover traffic.
I didn't know anything, ma'am.
Yeah, you did. He was laying in his front seat dead. His girlfriend Facebooked me. How did his car get smashed?
What's his name again?
Dante Wright.
Right? Is it W-R-I-G-H?
W-I-G-H-T.
Okay. Is it Katie?
Yeah.
Brian.
Yeah.
All right. Just wait a second here, ma'am.
I need you to just sit down, please.
Ma'am?
Please sit down. Okay, so I wasn't here. You said there was a traffic stop and they shot
They
him?
pulled him over, and he said non-verbal warrant. I said, oh no. They asked him to get out of the car. He got out of the car, and they said, wait, stop. They said, stop. And then she goes, and then they shot him, and he fell back in the seat. And he was in the driver's seat. And she said, they shot him. And I said, what do you mean they shot him? She said, yeah. And then they told her to hang up, and that was it. I don't know nothing else. So I had to call you guys to find out where this happened.
I really don't know more because I just came because I heard there was trouble.
Why is my car smashed up?
I don't know.
I don't know.
This deputy here wasn't, we weren't here, but...
I'm
Is he alive?
I do not know the condition. I don't
Are you
know
guys serious? What are you talking to me for then?
I'm going to find out.
We're going to find out, but we have to wait and find out who's involved and who's in charge and get you in contact with the people that know what's
Tell me
going
your name
on.
so I can tell them who I'm talking to.
I'm going to start exchanging.
We are also trying to figure out what's going on.
Stop. Thank you. Ms. Bryant, I know that was tough to watch. Can you just describe for the jury what you were feeling when you arrived on scene?
I was praying that it was him laying on the ground, that it was the person in the other car, and that he was in the...
Do you know Dante Wright?
I do.
And how did you come to know Dante Wright?
Through social media, through Facebook.
Did you have a relation? Do you know Dante Wright?
I do.
And how did you come to know Dante Wright?
Through social media, through Facebook.
Did you have a relationship with Dante Wright?
Yes.
And what type of relationship was that?
It was just like a beginning, like of a boyfriend and girlfriend relationship.
And you said it was the beginning of a boyfriend-girlfriend relationship. Had you just gotten to know him or meet him recently?
Yeah.
And when I say recently, that was shortly before April 11th of this year?
Yes.
About how long before that had you met him?
We've talked for about like 2-3 weeks.
So you were just beginning this relationship?
Yes.
So you didn't have an order for protection or any court order against him, did you?
No.
You were just meeting him and just getting to know him, is that right?
Exactly.
So I'm going to direct your attention to April 11th of this year, all right? And I'm going to ask you some questions about that day. Had Dante Wright stayed at your place the night before April 11th?
I believe so, yeah.
And at some point on April 11th, did you go with him to his parents' house?
Yes, I did.
Did you wait in the car when he went inside?
Yes, I did.
And was there anyone else in the car with you at that time?
No, there was not.
And what car was it that you were in with him?
It was a white car. I'm not familiar with like car brands or names.
Was it Dante's car?
It was Dante's car.
And then after you waited in the car, did you leave with him in that car from his parents' house?
Yes.
And who was driving?
Dante was driving.
And where were you sitting?
I was in the passenger seat.
And that's the front passenger seat?
Yes.
Now, at some point while you were driving in that white car with Dante Wright, did you get pulled over by the police?
Yes, we did.
Did you learn why you were pulled over?
Like, it was multiple reasons. Like, it was the air fresheners and the tabs and the warrant.
And did you hear Dante Wright interact with the police when you guys were pulled over?
Yeah, like, kind of. I remember mostly him just talking on the phone with his mom and them just telling me to hang up.
Okay. So was there a point in time where the officer who had pulled you over stepped away from the white car that you were in?
Yes.
And then did the officers come back at some point?
Yes.
Now, in that car that you were in, this white car, was there a gun in that car or any weapon of any kind?
No.
I'll rephrase, Your Honor.
Yes, please.
Do you know if there was a gun or a weapon of any kind in that car?
No.
So there was no weapon in that car?
No, there was not.
Do you know if Dante had a gun or a weapon on his body or that he was carrying a gun that day?
He was not.
Okay. So at some point you said the officer left, walked away, and then came back to that white car that you were in. What happened when the officers came back to that white car?
When they came back, from what I can remember, he just kept asking them, like, they would ask him to step out the car, and he kept asking them, like, why? Like, why do you want me to step out the car? He kept asking what he did, and they the car.
And how were you feeling while this was going on?
I'm really nervous and scared. I don't really have a good past with police, so every time I encounter, I just get nervous.
So you were nervous and scared. How was Dante behaving? How did he appear to be feeling during that interaction?
He was really scared. Like, I've never seen him like that before. Because, you know, Dante, like, he's just really happy, he's positive, and you can't really be, like, sad or depressed or angry or mad around him. And, like, he was just, like, just so nervous and flustered, and I could tell he was just scared, and he just...
Okay.
I don't know.
I'm going to stop you right there for just 1 sec. Take your time. If you need a tissue, go ahead. So it sounds like you're describing Dante as being nervous and scared. And take a deep breath and take it slow. But I'm going to ask you to describe for the jury when you said that the police asked Dante to step out of the car, what happened next?
When he stepped out of the car, I don't remember too much of the scuffling. I mean, I've seen the video footage, you know, when it first came out, like months ago, but like memory-wise, I don't remember the scuffling. I just remember after.
So you said you remember after, and you had described just before this that you said that they asked him to put down the phone, something like that. What do you remember about that?
Because his mom, he was trying to ask her if like he had any warrants or if he was in trouble, and she kept telling him no.
All right, 1 second. I'm just going to stop you right there. When he was stepping out of the car, what do you remember happening with that phone? Did he have a phone in his hand?
Oh, no. They kept telling him to put it down, and he dropped it, so he can get out. And
so he put down the phone to get out of the car?
Yeah.
Did he then get out of the car?
Yes.
And then you said you didn't remember much of the scuffling. What do you remember happening next?
I just remember, like, hearing, like, just, like, the boom, the bang of the gun, and then I remember just looking up and seeing, like, another white car just like, coming directly towards us. Like, I remember lifting up my head real quick and just
boom, and I can't tell if it was before or after, but I just remember like trying to just get him up. Like I was the only one who.
And we'll just take it piece by piece, okay?
Okay.
So it sounds like you said you remember seeing a car, another car. Is that what you were describing? That you saw another car? And then you said you were pressing on his chest. Is that what you
Like
said?
his like stomach area, like probably like right here.
Okay.
I didn't know exactly where he got shot, so.
Okay, so let's just take that part step by step.
Okay.
So you said you remember hearing a bang or something like that. And then after that, you saw another car. Is that right?
Mm-hmm.
Were you looking at Dante at that point?
Yeah.
And so what did you see when you looked at Dante Wright?
It just really happened like fast. Like I remember just looking at, it wasn't really him, but like it was kind of like him, but like the floor, like I could see like his hands were on the wheel, and that's why I was confused. And then I looked up at the car.
And you looked up and you saw a car. What happened at that point when you saw the car?
We hit the car.
So the car crashed. Is that right?
Yes.
And then what did you do? You were describing you were putting your hands on Dante, on Mr. Wright. Can you describe that part, please?
I took my belt off and I grabbed like whatever was in the car. I don't remember if it was a sweater, a towel, or a blanket or something. I just grabbed whatever it was and put it on his chest. Like you see in movies and TV shows. I didn't know what to do, so I just put my hands over his chest and I just tried to hold it, and I was just trying to scream his name, and I was just trying to have him talk to me, and just kept saying Dante, like just say something, please, like just talk to me. And he just couldn't. Like I know he tried, like I know he wanted to, because I replay that image in my head daily.
Okay, I'm going to stop you right there for just 1 second. Take a breath. If you need a tissue, feel free. And if you need a break, you just let me know. All right?
Okay.
You said that you were pushing on his chest because you had seen something like that on TV. Were you trying to stop the bleeding?
Yeah.
And you were trying to talk to him at that point. Is that right? What was he doing? Was he?
He was just like, I don't want to like demonstrate like how he was, but he just had his arms folded, kind of, and he's just like gasping, just like he just wasn't saying anything.
So
I was trying to get him to like say a word at least or something, so I knew he had a chance of being okay, but he just wasn't saying anything.
So
but he was alive, so I didn't think he was still alive.
Okay, so you're describing that he was gasping. You were trying to get him to respond to you.
Yeah.
But he couldn't say any words. Is that right?
Yeah.
And you were trying to put pressure on him. Is that right?
Yes.
At some point, did that stop? The gasping stop and the moving stop?
I don't remember. I think I was pulled out of the car. I don't recall.
Okay. But the car that you were in came to a stop at some point. Is that right?
Yes.
And how was Dante Mr. Wright? How was he positioned in the car? Was he leaning back or leaning forward? Do you remember?
He was leaning back. It was like this. That's what I remember.
Okay.
He was leaning back.
And at no point, at any point, were you able to get him to respond to you or move or get up?
Unfortunately, no, I was not.
Okay. Now, while you were in that car with Dante, with Mr. Wright, was there another call? Was there a video call that came through?
Yeah.
Tell the jury about that.
It was his mom.
And what happened during that call?
Yeah, it was a video call. She was asking what happened. I know I was delirious. I was just screaming like they shot him. They shot him. And then I pointed the camera on him. And I was so sorry. And I did that because I was sorry.
It's okay. We'll take a minute. We'll take a minute.
Yeah, I just pointed the camera at him. I was in shock and I apologize, but yeah.
Okay. Hang on right there just so I make sure that I'm clear about what you're saying.
Yeah, sorry.
It's okay. Take a deep breath. You said that you pointed the camera at him.
Yeah.
And it was his mom on the phone.
Yes.
And you were saying you were just sorry that you did that?
Yes.
And why are you sorry that you did that?
Because no, mom should have to see that your son dead on her phone, on a video call. Just out of nowhere, like, I know how my mom felt when she couldn't find me for hours afterwards. So I just know that I hurt her by doing that. And I apologize, Katie.
Okay. So I hear you saying that no mom should see her son dead on the phone, and you know that that hurt her, and you apologize for that?
Yeah, just that period, but yeah.
All right. Take a moment. After that call, was that when you got out of the car?
I don't recall. I do remember getting out of the car at some point, though.
Okay. Your Honor, at this point, I would offer Exhibits 166 and 167. I don't believe there's any objection.
Could you identify the exhibits?
Those are
please?
photographs of the white Buick.
Is there an objection to those exhibits? Those exhibits will be admitted into evidence and you may publish.
Thank you. We'll start with 160. Actually, could we put 166 and 167 next to each other on the screen, please? All right, I'm putting on this screen Exhibits 166 and 167. Is that the white car that you were in?
Yes.
And in Exhibit 167, there's a close-up of some damage to the windshield that I just circled. Is that the side of the car that you were on?
Yes.
And did you sustain some injuries as a result of all this?
I did.
And we'll get into those a little bit later, but do you believe that the injuries that you sustained were related to this crash?
I do.
Okay. You said that you got out of the car. At this point, Your Honor, I would offer Exhibit 29, which is the video of Ms. Albrecht Payton walking out of the car.
Any objection to Exhibit 29?
Previous objection is noted.
Okay. Exhibit 29 will be admitted over defense objection, which I overrule.
All right, and we will publish that now, please.
Watching me! Okay. Just keep your hands out of your pockets. Okay. Come back here. Come back here. Okay. Come over here. Come over here. Just don't worry about that. Don't worry about that. Who else is in the car? Huh? Nobody? Okay, just drop it. Just let it go. Just let it go. Let it go. Let it go. I got it. I got it, ma'am. I will give it to you. Okay, put your hands behind your back. You're not under arrest. Just put your hands behind your back. Okay? You're not under arrest. Just put your hands behind your back. Okay, I'm just going to cover this. I don't know what's going on. Okay, who else is in the car now? Nobody? There's nobody else in the car, it's just you? Who? Him? Who's him? Dante? Does he have a gun or anything? No? It's just you and Dante. Okay. Just one other person inside. All right, you want to search her and stuff? Okay. Huh? Just...
Were you explaining to the officer at that point that there was no one else in the car other than you and Dante?
Yes.
And we talked a little bit about your injuries. How were you feeling at this point when you were coming out of that car?
I couldn't really feel anything. I just remember my jaw, I just remember walking and my blood was just spilling from my mouth.
And did paramedics take you to the hospital after that?
Yes. I was told not right away, but yes.
And what were the injuries that you learned about that you had? You learned after the fact what your injuries were. What were those injuries?
I had a lacerated lip, so I have a scar. I had stitches. It went all the way through. I don't know what happened, but the hole all the way through my lip. Stitches in my ear and a fractured jaw. I had wires on my jaw for about 6 weeks, maybe a little more. And I sustained like a concussion, and yeah.
So you said you had a laceration, a concussion, a broken jaw, and that your broken jaw was wired shut for some period of time. Is that right?
Yeah.
Did you have to have surgery as well?
I did.
At this point, Your Honor, I would offer Exhibits 30 and 31. Those are the photos of the injuries.
Okay. 30 and 31 will be admitted over defense objection.
And we would publish Exhibit 30 at this time. All right, I've put on the screen Exhibit 30. Can you just describe what's shown here?
That is my left ear.
Sorry, you said that you had to have something done to your left ear. Can you explain that?
Yeah, that is my left lacerated ear. So they had to stitch. So.
Okay, please be seated. Okay, Okay, members of the jury, I apologize for getting your lunches late, so it won't happen again, okay? All right, Mr. Frank, you may continue.
Thank you, Your Honor. Professor Stoughton, I think when we took the lunch break, you were telling the jury something about the incident, and I think you actually just used the wrong name. I think you used Ms. Potter's name instead of Sergeant Johnson's name. But can you then just tell us what you were telling the jury just before we broke?
Yes, and I apologize for that error. My point was that there are situations where a reasonable officer on the scene will not know what another officer is doing. And in this case, Sergeant Johnson testified, for example, that he did not know what Officer Lucky was doing at one point.
And how does that inform your opinion about what a reasonable person in Officer Potter's position would have known at the time of firing the fatal shot?
Sure. So back to the determination of whether a reasonable officer in Officer Potter's position would have identified an imminent threat of death or great bodily harm if the reasonable officer was not aware of Sergeant Johnson's actions, for example, was not aware that he had entered the vehicle, then there would be no imminent threat. If a reasonable officer in Officer Johnson's position was aware of that, and was also aware that Sergeant Johnson was preventing the vehicle from moving, or was aware that Sergeant Johnson had exited the vehicle prior to the shot being fired, then there would be no conclusion that there was an imminent threat of death or great bodily harm.
If a reasonable officer in Officer Potter's position had been aware that Sergeant Johnson was in the vehicle at the time she used deadly force, would it have been reasonable for an officer in that position to use deadly force?
Assuming that the reasonable officer would have been aware that Sergeant Johnson had entered the vehicle and would not have been aware that he had prevented the vehicle from moving and that he had exited the vehicle, the use of deadly force would have been proportional. That is, it would not have been excessive based on the imminent threat of death or great bodily harm. It still would have been inappropriate because of the proximity of two other officers and the passenger.
And what if, you've reviewed the body-worn camera videos in this case?
Yes.
And you saw during these moments leading up to the fatal shooting where Mr. Wright was positioned.
Yes.
And does it inform your opinion regarding the use of deadly force, the fact of Mr. Wright's position during these moments?
Yes, it does. If he's not in a position to get the car moving, for example, then there wouldn't be any particular imminent threat of someone getting dragged by a car that couldn't move. So the fact that Mr. Wright was fully in the driver's seat, the fact that his hands were in the area of the wheel or the shifter, the fact that his feet were on or in the area of the pedals, all suggests that he is in a position to make that vehicle move without a whole lot of trouble. That's relevant because of a great deal of guidance to officers to not use deadly force against vehicle operators. Vehicle operators here being someone who is either driving a vehicle in motion, or is in the immediate position of being able to put that vehicle into motion. The reason for that guidance is because shooting someone in that position is highly unlikely to actually address the threat presented by the vehicle. So generally accepted police guidance now is to not shoot at a vehicle when the vehicle itself is the weapon. You might return fire if someone in the vehicle is shooting at you, but when the vehicle itself is being used as the weapon, you generally don't want to shoot at it, because if the use of deadly force is effective, that is, if it kills somebody, At best, what you've created is a potential unguided hazard, and it's highly likely that someone's going to stomp on the accelerator or lose control of a moving vehicle or a vehicle that they set into motion.
Would it be consistent or inconsistent for a reasonable officer in Officer Potter's position at the time of using deadly force to believe that there is an imminent threat of death or great bodily harm to others, and yet and also believe that the person was not operating the vehicle?
No, those are contradictory and inconsistent with each other. If you believe that the vehicle is not in a position to be put into motion, then there is no imminent threat. If you believe that the vehicle is going to be put into motion, then you really don't want to use deadly force against that individual because you're liable to make the situation worse, not better.
Now, I want to ask you to assume another fact for purposes of your testimony today. I would ask you to assume that Officer Potter, or that a reasonable officer in Officer Potter's position at some point during this episode had seen what she described as a scared look on Sergeant Johnson's face. Would that affect your opinions today?
No.
Why not?
Use of force situations are scary. There's, I suppose, one, the inherent difficulty of accurately reading in a high-stress environment someone else's facial expression. That is, an officer could misread frustrated or stressed as scared. And two, just because someone else looks scared really doesn't help inform whether they are scared, whether they are reasonably scared, whether that, even if they are scared, whether they are scared of an imminent threat of death or great bodily harm. It's not particularly communicative of anything relevant to the analysis.
Now I'm going to go to put up Exhibit 13, please. And I'm going to ask you to please go to 20201. Would you agree, for our purposes today, that this is at or right after the moment the shot was fired?
Yes.
And do you see anything in here indicating that Sergeant Johnson was visible to Officer Potter?
No.
And so then, based on all this, do you have an opinion to a reasonable degree of professional certainty as to whether Officer Potter's use of deadly force in shooting Mr. Wright with a gun was justified?
I do, yes.
And what is that opinion?
That the available evidence leads me to conclude that a reasonable officer in Officer Potter's position would not have concluded that there was an imminent threat of death or great bodily harm, and thus that the use of deadly force was excessive, that is, disproportionate to the threat presented. And regardless of whether the reasonable officer would have perceived an imminent threat of death or great bodily harm, the use of deadly force under the circumstances was inappropriate because of the danger that it created to the other two officers and the passenger in Mr. Wright's vehicle.
Now, I want to turn to the decision to use a taser.
Yes.
And have you also formulated an opinion about then Officer Potter's apparent decision to use a taser?
Yes, although she did not actually use a taser, as I said earlier, I believe the evidence indicates that she intended to use a taser. So yes, I've come to a conclusion about the apparent decision to deploy and discharge a taser.
Now, is this would this be considered the use of force, regular force, or deadly force? How would you characterize it?
The use of a taser is, under most circumstances, properly considered a less lethal use of force. There are situations where it can carry a substantial likelihood of death or great bodily harm, but under most situations, the use of a taser is considered an intermediate or less lethal weapon.
And what is the standard for the type of force or amount of force that an officer can use when it's less than lethal force?
So again, adopting that same framework or perspective of the reasonable officer on the scene, the question is whether the use of less lethal force is objectively reasonable. That is, reasonable to the reasonable officer on the scene. I apologize for double reasonabling you, but that's the standard.
And so in reaching an opinion, did you attempt to determine whether there was a threat at the time of using attempting to use the taser?
Yes, I did.
And what did you conclude in that regard?
I concluded that Mr. Wright did present a threat of escape. That is, there was an ability, opportunity, and apparent intention to flee the arrest. That the officers had the legal authority to detain or arrest Mr. Wright, detain him for purposes of dealing with the traffic violations as well as the investigation into potential marijuana possession, and arrest him for the outstanding warrant. So by attempting to flee the way he did, he was presenting a threat of escape.
And what about the possibility of apprehending him later? Are you factoring that into your decision today, your opinion today?
Yes. So when the threat being presented is the threat of escape, it is important to note that we're talking about the threat of escaping custody right now. There are a number of situations where there are tactical benefits or officer safety benefits to not arresting someone immediately, to arresting them later. Of course, you have to know who they are and have some idea of where to find them. In this case, the officers had information about who Mr. Wright was, who his brother was, their various addresses and contact information. So although he did present an imminent threat of escape, it certainly factors into the analysis that he was unlikely to avoid future apprehension. In a situation like that, officers typically either go and get him on the outstanding warrant or have new warrants written up and go and find him later.
And did you all also, in coming to this opinion, consider whether there was a threat of harm presented by the situation at all?
Yes, I did.
And just briefly describe for us what your opinion is in that regard for this situation, the apparent attempt to use a taser.
Yes, so rather mirroring the opinion with regard to the use of deadly force, the reasonable officer in Officer Potter's position would not have identified an imminent threat of physical harm from Mr. Wright. The evidence is that he was not assaultive, it's merely that he was trying to flee. And again, we've already talked about the positioning of Sergeant Johnson and a reasonable officer's awareness of that.
So you've just addressed any potential threat from Mr. Wright, correct?
Yes.
Threat of harm, I should say.
A threat of physical harm, yes.
And then you did also consider whether there was a threat of harm to the other officers at the scene?
Yes, that's correct.
And we've already gone through that. With regard to the deadly harm, is your opinion about the threat of harm essentially the same?
It is substantially the same, yes.
And did you also consider the appropriateness of the actual decision to try and use the taser?
Yes, I did, using that same framework of trying to identify foreseeable effects and weigh them against the foreseeable threat, or the effects of the threatened behavior, the threatened escape in this case.
And what is your opinion, do you have an opinion to a reasonable degree of professional certainty about the decision to attempt to use a taser at that point in time?
Yes, I do.
And what is that opinion?
Taser use is inappropriate under those circumstances for very similar reasons as why using deadly force against the operator of a motor vehicle is inappropriate. It's really dangerous to incapacitate the way that a taser can incapacitate someone who is in a position to get a vehicle moving. You can create an unguided hazard. If the taser was effective in achieving what the manufacturer refers to as neuromuscular incapacitation, and if the taser was ineffective, if it did not achieve neuromuscular incapacitation, if it just caused pain, what we call pain compliance, then you're providing an incentive for someone to flee in that circumstance. So you're likely to actually incentivize someone to effect their flight.
Are you familiar with taser training?
I am, yes.
And how a taser operates?
Yes, I wouldn't identify myself as a technical expert in all of the electrical components, but as a use of force tool, yes, I'm very familiar with it.
You're familiar with some of the reasons why there might not be a successful taser discharge, as you referenced earlier?
Yes, absolutely.
And in this situation, based on your review of all of the evidence, what have you identified as the potential problems achieving a successful taser discharge?
The single biggest problem is a lack of probe spread. So to be effective, the taser has to send little micro pulses of electricity from one spot on the body to another. Neuromuscular incapacitation is effectively involuntary contraction of the muscles that really occurs between where the two prongs hit, or maybe in the area immediately around where the two prongs are. Essentially, electricity flows from one into the other, and while it's passing through the muscles in between, it causes contractions. So when the taser spread is big enough, which Axon's, the manufacturer's general guidance is in the 7 to 15 feet range, and what some guidance says is in the 10 to 12 foot minimum range, the prongs are more likely to spread out and hit the body in a way that they're distant enough that they cause neuromuscular incapacitation. When the taser is too close to the person when it's discharged, the prongs don't spread out sufficiently. They hit too close together. So the area of involuntary muscle contraction is very, very limited. It's very painful, but it doesn't cause the type of incapacitation that results in the dysfunction of the body. That's why it's pain compliance, that is, using pain to try and obtain someone's compliance, as opposed to what's often referred to as motor dysfunction, where you're preventing the body from working the way that the person wants it to.
And so, based on your review of all the evidence, information provided to you in the case, was Mr. Wright's position relative to Officer Potter at the time a factor in whether the use of the taser was appropriate at the time?
Absolutely it is. That's part of the determination about whether you are likely to achieve neuromuscular incapacitation. In other words, it's about the foreseeable effects of the force option of the weapon.
In your review, was Mr. Wright in a position to operate the vehicle?
He was in a position to operate the vehicle immediately before and at the time of the taser, we'll say the intended taser discharge. Yes.
So do you have an opinion to a reasonable degree of professional certainty on whether it was reasonable for an officer in Officer Potter's position to decide to use a taser when she grabbed her gun instead and shot Mr. Wright?
Yes, I do.
And what is that opinion?
The use of a taser under the circumstances was unreasonable and inconsistent with generally accepted practices. If the taser had not been successful in achieving neuromuscular incapacitation, if it had just resulted in pain, it's highly likely to just incentivize Mr. Wright to flee, the exact opposite of what it was apparently intended to address. If it was successful in achieving neuromuscular incapacitation, it created the potential to turn the vehicle into an unguided hazard. Even if the probe spread locks the muscles, involuntarily causes muscle contraction between where they hit, does not mean that the person's extremities are affected. It's entirely possible for someone to stomp down on the gas, for example. So either way, in that situation, whether the taser was successful or unsuccessful in achieving neuromuscular incapacitation, the results are not good for the police.
Are you familiar, based on your training, your experience in this field, with the topic of weapons confusion, confusing a gun?
I am, yes.
And have you done some research into that history?
Yes.
And is this something that is known?
It's very well known in policing, yes.
And are you familiar, have you learned approximately how often this has happened?
Yes, I have.
And approximately how often has it happened?
So tasers, as we now know them, were introduced in 1993. Since 2001, which is the first taser weapons confusion case that I'm aware of, there have been less than 20 incidents of weapons confusion, where an individual officer uses their firearm thinking that it was a taser.
And have there been things done to try and avoid those things from happening?
Yes, the manufacturer, policing, individual officers, there are a range of steps that seek to avoid the cases of weapons confusion.
Can you describe those for the jury, please?
Sure. So I think we can probably break them into three buckets. The first bucket is how the weapon is actually carried. The early taser confusion cases, actually almost all of the taser confusion cases, involve what's called a strong side draw or a dominant side draw. This is when the taser is holstered on the same side of the officer's body that the firearm is holstered on. The first, actually, I forget the exact number. It's at least the first 9 or 10 or 12 weapons confusion cases involved this same side or strong side draw issue. After the first couple of taser confusion cases, Axon, then Taser International, the manufacturer has since changed names, and other commentators began to suggest, recommend, and in many cases now require that officers carry the taser on a non-dominant side, what's sometimes called a reaction side, on the opposite hip than the officer carries their firearm. Going a little bit further, there have been a couple of taser confusion cases involving non-dominant side cross draw or reaction side cross draw. That's when an officer who is right-handed would carry the taser on the left hip, but in a way that they have to reach across themselves to draw it. So it's often recommended today, and many agencies require or strongly suggest that officers carry the taser holstered in a non-dominant side or reaction side straight draw. That's where the officer uses their non-dominant hand, whatever hand is the opposite one that they use for their firearm, to actually draw the taser. If you picture the way that a weapon is holstered on an officer's belt, if we're talking about a right-handed officer, the taser would be on the left hip, handle facing backwards, to be drawn with the officer's left hand. That's the first category.
And what's the second?
The second category is the training and education that officers get about weapons confusion. The potential for weapons confusion is a real issue in policing. It's very well known in policing. It is part of taser training and the warnings and the written documentation, the PowerPoints, the training materials that officers get. Be aware that this is an issue. And then officers are required to take a series of steps like practicing draws or doing...
I objected this is no foundation as far as this case goes. Talking about officers. No foundation.
Okay, counsel, I am going to sustain the objection. Do you want to lay additional foundation?
Yes. In your experience and training in your current profession, have you looked into how taser training is done?
Yes. Axon Enterprises, the manufacturer of taser, has some pretty clear requirements about the training that they require officers to go through to become certified as taser users.
And does that training talk about weapons confusion?
Yes, it does.
Does it also talk about carrying the taser on the non-dominant side?
Yes, it does. Or
So-
at least I should say many iterations of it do. I think they're on version 22 or version 23 of the training, but many iterations of it do, yes.
And so this second bucket, I think you were saying, involves educating and training officers, correct?
That's correct.
Is there more that you wanted to add for that bucket, or is that the bucket?
Object to that question, it's vague in general.
You may answer objection overruled.
No, I think the second category can be classified as training officers to be aware of and to mitigate the risks of weapon confusion.
And what is the third bucket then?
The third bucket is really the taser itself and the differences between the taser weapon and the firearm that an officer might carry.
And like what kinds of differences?
Depending on which model, there can be a number of them, but the differences that persist between models, or that have persisted between all of the recent models of the taser, tasers have a manual thumb safety. That is, in order to activate the taser device, in order to pull the trigger and have it do anything.
Your Honor, I object to this lack of foundation.
The objection is overruled.
May we be heard in this?
Yes. My original ruling stands. You may
Okay, so-
continue.
Thank you, Your Honor. I think you were just describing the basic differences, or the basic makeup of a taser to try and differentiate it from a firearm, correct?
Yes, that's correct.
And I don't know if you were done, but if you could just finish, please.
Yeah, so the first is the manual thumb safety that the taser weapon has, and a great number of police firearms, including the one in this case, does not have any sort of manual thumb safety. The activation of the thumb safety, that is disengaging the safety so the taser is ready to discharge. It'll,
All right. You may have a continuing objection, but Mr. Frank, remember what we talked about.
Yep.
Got to move on quickly.
Want to briefly describe for us the changes that you're talking about? or referring
Yeah,
to?
sure. The second would be the laser point. When a taser safety is disengaged, sends out a little red targeting laser that is roughly aligned with the top prong when the taser discharges. Firearms not equipped with laser sights obviously don't have that visual indicator. Tasers are typically pretty brightly colored now. Bright yellow is the most common for the taser models in a way that the firearm is not. And although I can't really describe this very well, they feel different in the hand. They're at a tactile level. A taser does not feel like a firearm except in the most superficial sense, where anything with a handle on it and a trigger does.
And are you aware of approximately how many law enforcement officers are out there with tasers working?
I don't have a good...
I object to this also, lack of foundation.
The objection is overruled. You may answer.
I don't have a precise number. The information from Axon and the last agency surveys that I'm aware of suggests that most police agencies have tasers now. I don't have a good percentage of exactly how many officers have tasers, but they are pretty ubiquitous, if not universal, in policing.
And the fact that there have only been, let's say, approximately 20 weapons confusion cases, based on your training and experience, what does that tell you about the three buckets that you talked about earlier?
The vast...
I object to this improper opinion of the witness based on something he doesn't know anything about.
All right. Counsel, do you want to conclude? Okay, I can't, the objection is sustained.
I have no further questions, Your Honor. Thank you.
Okay.
Your Honor, could we have one more sidebar before we start?
Sure. We're going to take a 10-minute break, okay? Thank you. Okay, you may step down. Okay, Mr. Ng, you cited 702. First of all, the question is whether or not the state opened up the door to evidence concerning Dante Wright's prior fleeing incidents when the expert opined that a reasonable officer in Officer Potter's position could have concluded that Mr. Wright presented an imminent threat of escape but was unlikely to avoid later apprehension in justifying his decision that the taser was inappropriate. So, go ahead. 702 that you're relying on? Or 703? Was 703?
703B, the last
Right.
sentence of 703B is what we're relying on.
Okay, and that does state that the court may admit the data under this rule. Excuse me, I can't read this. Well, if the expert is relying on certain facts in rendering his opinion, I think that we're entitled to get that out. So, Mr. Frank, I'm going to give you an opportunity to tell me why the door hasn't been opened. A limited instruction is always possible.
Yes, thank you, Your Honor. Rule 703 deals with the evidence underlying an expert opinion. And it's basically 703A indicates that all of the facts and data relied on by the expert may be provided to the expert at or before the hearing. If a type reasonably relied upon by experts in the field, the facts and data need not be admissible in evidence. Right? So that's what paragraph A is about. Paragraph B is about the underlying expert data must be independently admissible in order to be received upon direct examination, provided that, so the first part of paragraph B is about direct examination and how it's restricted there. That last sentence then refers to that underlying data. It doesn't say, but on cross-examination they can do whatever they want. It's related to the previous sentence's discussion of the underlying data. So 703B is not a freestanding rule of admissibility and cross-examination. Evidence still has to be admissible and relevant. And you have ruled that any prior conduct of Mr. Wright that is not known to Officer Potter is inadmissible and irrelevant, because the issues in this case are what a reasonable officer knew in Officer Potter's position. That's exactly what this witness testified to. A reasonable officer in Officer Potter's position would have known that he had been identified and could be potentially apprehended later. He didn't guarantee it was going to happen. He said that a reasonable officer would have known that. Now, that might have been wrong. That's not what he's saying. What he's saying is a reasonable officer at that moment would have understood that. It doesn't change anything that there is the unknown incidents unknown to Officer Potter because a reasonable officer in that position wouldn't have had that information. So no door has been opened to put in what is essentially character evidence under 404B. That's what they're trying to do here, is to make it look like Mr. Wright wanted to flee. That's not the issue. Right? The issue is what Officer Potter knew to apply that reasonable officer standard.
And there isn't any evidence that, obviously right now, that Officer Potter was aware that he had fled in the past and done whatever acts to evade warrants or whatever. If Officer Potter wasn't aware of that, I believe it's covered under my prior ruling that any prior bad acts, alleged bad acts on the part of Dante Wright would not be admissible.
Yeah, may I speak to that?
Yes.
Well, the expert has testified he's reviewed thousands of pages. We don't believe he's reviewed an inch-thick file on Dante Wright on every time he gets arrested, he tries to escape. Every court appearance he misses. Every time he can get away, he can get away. And so now we have an expert who's articulated that this really shouldn't have been a lethal force matter. You know, no taser should have been shot because eventually we'll find this kid. I mean, that's his opinion. And it's false. We'll find him, he'll be easily arrested, no big deal. And so they've got an articulated opinion they put forth to these jurors. They're writing it down like crazy on their notes. A few of them are anyway. And we need to rebut the falsehood of that opinion. And, you know, I realize your ruling was that since you didn't know about certain things about Dante Wright, you know, we're limited. But I briefed the 703 issue, and you didn't rule on that yet. Mm-hmm. And I was waiting for this issue to either not be brought up or to be introduced into evidence. And now they've introduced a false predicate into the trial. And a false inference and false facts denies us due process. NAPU versus Illinois. We either have to correct it, or if your ruling is that we can't ask about it, I have to move for a mistrial, and we will come in after the break with a thick packet, and I'll make an offer of proof of every time this kid has run away and not been found.
Okay. All right. Mr. Frank, I'll let you just briefly.
Yes, Karen, please, thank you. And I will not pound on the table because I don't think I need to. You can see clearly what the real purpose of trying to offer this evidence is 404B. It's character evidence. But nonetheless, there has been no false impression given to the jury because the witness's entire testimony was couched in terms of what a reasonable officer would have done or known, or what would have been, what they would have done based on what that officer knew at the time. That's been the entire context of his testimony. He never misrepresented that to the jury. He never said, you know, that he was guaranteeing they would have caught him later. That's not his opinion. So his opinion was carefully stated, appropriately stated, and did not open the door to any of this stuff. Whether it's an inch thick or not, none of it was known to Officer Potter, and it's not relevant to the issues in the case.
Okay. I'm going to take a break and think about that. So I'll be back in 5 minutes, and I'm just going to read his expert opinions again. And I am concerned about this because I do think that the jury has gotten the impression that he could have easily been apprehended later. And there is a basis for believing that he wouldn't have. So I'll take a break. I'll be back in 5.
Put your hands up! Put your hands up!
Put your hands up! Put them up! Put your hands up! 3.
Officer Salvosa, I'd like to now play for the jury a third video. Do you recall that your body-worn camera continues on past that point, beyond the point, and actually captures your interaction with the vehicle and ultimately the response by the group of officers?
Yes, sir.
And you've had an opportunity to review that prior to trial, correct?
Yes, sir.
At this time, the state offers Exhibit 39. That's a portion of Officer Salvosa's body-worn camera.
Any objection? 39. There being no objection, 39 will be admitted and you may publish.
Thank you, Your Honor. This video is a bit longer, Officer Salvosa, correct? It's about 16 minutes long?
Yes, sir.
Okay. You will be given an opportunity to discuss issues if they come up. Could we please play that, Mr. Miller?
Saying that she's tired of being a Democrat because of the actions.
3219, PI accident, 63rd and Catherine Drive, fled from 38 stop, start north on the Reds.
Did you recognize the voice on this video?
Yes, sir.
And whose voice was that?
My voice, sir.
Did you hear yourself say, start north on the Reds?
Yes, sir.
Could you tell the jury what that means?
North Memorial Ambulance is the ambulance company that provides services to Brooklyn Center. So when we refer to them as North, so that would basically refer to an ambulance. On the Reds means the fastest response possible.
Okay. Lights and sirens.
Yes, sir.
Put your hands up! 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 Put them up! Put your hands up!
3219, several at gunpoint, 63rd and Catherine Drive. Start north on the Reds and start 2 rigs. We've got a civilian car injured as well. As soon as we get additional cars, I'll check for injuries. Suspects are not compliant. They're moving around.
Put your hands up!
Hey, sir, stay there. Stay there.
You had directed someone to stay there. Do you know who you were talking to at that time?
I believe it was the person in the injured vehicle.
Which injured vehicle?
The Subaru that was hit head-on in front of me, sir.
Okay, and can you actually see the other vehicle on your screen now?
It's just in the corner by my door frame. You can kind of see it right outside my door frame.
Okay. Right outside your door frame in the way left side of this image?
Yes, sir.
Okay. You can continue, Mr. Miller.
Put your hands up! Lower the window! Lower the window!
Ma'am, are you okay? Stay there. Stay there. 3219, we'll take 2 rigs, stage them a couple blocks out. What's that? 3219, the driver is not breathing. I'll take an additional squad and we'll yank him out. But get him here on the Reds. I'm by myself, holding him at gunpoint. Three 219, make it 3 rigs. I got 1 male not breathing, 1 female with facial lacerations, and then I've got another civilian car that I have not been able to check on yet. Incoming squad, come to me at 63rd and Catherine so we can get the driver out and the passenger, and then we'll have to check on anyone else after, but the driver is not breathing according to the passenger.
Attempts to flee.
Well, later in the trial, I'll make an offer.
Okay. All right, can we bring the... Yes, I know you object. Really. Okay, can we bring the jury in? Thank you. Okay, please be seated. All right. Is there a cross?
Mr. Stoughton, I'm going to ask you some questions pertaining to your report and your testimony today. Let me get this right. What your last piece of testimony was that when the officers attempted to handcuff Mr. Wright because they had his address and name, and it was a minor violation, that they should have just let him go. Is that what you're saying?
No, that mischaracterizes my testimony and opinions.
Saying? What are you saying about it? I thought you said that they should let him go because they had his name and address. Is that what you said?
No, that's not what I said.
Okay, well then I misheard you. What did you say they should let him go?
No, I did not say they should let him go.
What did you say?
I said that the fact they had identified him and had his address is a relevant consideration in balancing the threat of escape or evasion.
Of what? I'm sorry.
The threat of escape or evasion.
Okay, and if he attempted to escape, what should the officers have done?
Use reasonable force to prevent the escape.
And they do that when they were trying to stop him from escaping?
Are you asking me in this case? No.
They didn't. And
at an early point, I would say yes, although we didn't talk about that. But at the point of using deadly force, no. As I testified, that was excessive and unreasonable, inappropriate, and inconsistent with generally accepted police practices.
Yes. But I thought I was not talking about deadly force. I was talking about your first opinion in your report about using the taser. And your report seemed to reflect that because they would find him some other time or somebody else would get him, that they should not have tried to stop him. Is that what your report says?
It's not, no.
Okay. Well, let's go back. You started working as a police officer in what year, 2001?
Yes, sir.
Is that right? And you worked as a police officer for 4 years and 7 months after that? Is that right?
Something like that, full-time, an additional 6 months as a reservist. The plaque on my wall says 5 years, but I'd have to calculate the exact number of months.
All right, well, let's assume it's 5 years, and it doesn't matter.
Sure.
That was 15 years ago, I believe, right? About that?
Yes. I left
And
about...
have you worked as a patrol officer since 15 years ago?
No.
And during the time you were a patrol officer, and we did some history here, how many critical, first of all, do you know what a critical incident is?
Yes.
How many critical incidents did you have in the 5 years that you were a law enforcement officer?
Oh, I was involved in maybe a dozen.
Okay, name one. I'm talking about a critical incident where a gun was used.
Sure. So my first one was in field training. I was not a shooting officer. My field training officer.
Maybe you misunderstood me. I'm not talking field training. I'm talking out in the area, being a patrol officer and having a real life incident. Did you have any of those?
Your Honor, I hate to be the third person talking at a time, but could the court please remind Mr. Gray that only one person can talk at a time? They should let the witness.
Right, and if he could answer my question, Your Honor.
All right, okay. You may continue, but yet for the benefit of the court reporter, please remember not to talk over each other.
Okay.
All right.
So what I'm talking about is when real life, when you're out on a patrol alone and you have a critical incident situation, how many of those did you have?
I was involved in, although not the shooting officer, I was involved in perhaps a dozen or so.
Of an officer shooting?
Either an officer shooting, an officer potentially being shot at, a significant use of force that we would classify as a critical incident.
Were you ever the one that shot the gun?
No.
Were you ever the one that was shot at?
No.
Were you ever in a situation such as the one that you saw in this video, the chaotic incident of this sort?
Someone attempting to flee an arrest and traffic stop? Sure, a number of times.
Okay, well, did they have a bench warrant for a weapons violation?
I don't remember specifically. I know certainly there were people who fled who had outstanding warrants of different types.
Well, I'm talking about an incident. Did you ever chase somebody that had a weapons warrant?
I'm sorry, that had a weapons...
Well, okay. I'm talking about a critical incident where you were involved yourself personally and a man broke away from you, didn't want to be handcuffed, and either drove off or ran off. Did you have any incidents like that?
I had a number of incidents where people who did not want to be arrested either drove off or ran off. They did not result in an officer-involved shooting, if that's what you're asking.
Okay, so the person that drove off, if you can remember one specifically, did you have a person that drove off or that fought the handcuffs and jumped in the vehicle? That person had a warrant for a weapons violation, had a no driver's license, no insurance, and a temporary restraining order against him against a female, and the officers did not know who the female was in the vehicle. Did you ever have an incident like that?
I can't say that I had that particular collection of facts as an officer, no.
Did your heart ever race, and did you ever get real excited when somebody left your custody and ran off?
Of course.
Okay. So you're aware that's what happens. Your adrenaline starts pumping. Is that right?
Colloquially, sure.
Okay. And you had that police officers patrol for about 5 years, give or take, and during the 5 years, you never was a trainer. You were a trainee except in computer training, correct?
I taught report writing to officers, the policies that we used. I got a number of different training.
You answered the question. And just answer my question, okay?
I'm sorry, I guess I don't understand your question.
I guess you don't. Okay, so during the time you were a police officer, you never was a trainer for use of force, for shooting a gun, or any kind of conflict with a citizen, correct? You weren't a trainer.
No, I earned a number of instructor certifications, including several in use of force disciplines.
You were a trainer for the officers back there in 2001, 2005. You trained other officers on the use of force. Are you testifying to that today?
No, I'm testifying that I earned several instructor certifications.
Did you hear my question? Did you ever train any officers back there when you were a patrol officer? Did you ever train any officers on the use of force at the police department you were in?
At the police department, no, I was not what we consider to be a defensive tactics instructor.
And you were actually a trainee, correct?
At the beginning of my career, sure.
And as far as, do you remember what a spear drill is?
A spear, as in Tony Blauer's spear system?
I don't know, but in your records you didn't choose to participate in a spear drill. You remember that?
No, I don't. If that's the spear system drill, no,
do you remember not participating in it?
I remember.
I can refresh your memory if you want.
Sure. I remember at one point getting a fever in the middle of defensive tactics training and getting pulled out.
Thank you.
And I'm going to check your honor on relevance grounds.
Your objection is overruled.
Read it to yourself.
Sure.
Sure what?
I've read it.
Okay. And what does it refresh your memory?
Looks like my entire squad at the time is listed.
I asked you if it refreshes your memory or not. That's a yes or no, sir.
Not of this particular. I suppose it refreshes my memory as to what?
As to whether or not you wouldn't participate in the spear drill.
No, not particularly.
You don't remember? It did happen though, didn't it?
I don't know. I don't remember.
Okay. Too long ago? Is that right? Is it too long ago to remember?
Perhaps some combination of too long ago and simply not memorable.
Then you probably don't remember a lot of things that you did as a patrol officer, is that right?
Oh, I'm sure there are all kinds of things that I've forgotten.
15 years ago?
Sure.
And when you were approached to work in this case, you signed a contract, correct?
Yes.
And the contract calls for, what was the hourly rate?
I believe it was $2.90 an hour with 10 hours on days of expected testimony.
Okay, and up till now you've billed them about $10,000, would that be fair?
Something in that range, about 35 hours worth.
And since November, let's strike that. The cap on your contract is $50,000, correct?
I don't remember.
Oh, I'll show it to you.
you mean approach.
Yeah, thank you. I'm sorry. Actually, totally, I believe it might be 95,000. Take a read on that paragraph and see what you can figure out.
Oh, I'm sorry, I've misstated my rate. It's 295, not 290.
What else does that say?
It says quite a bit. What are you referring to?
The cap. How much is the cap?
The cap, I suppose if that's the total obligation clause, it will not exceed $95,000.
Thank you.
Yes. Mr. Bailey, did you remember to ask your questions at the podium for the benefit of the court reporter?
Now,
Was that Speardrill late June?
I'm sorry, I didn't ask you a question. The stop on this case last April 11th, you looked at that. That was illegal, wasn't it?
The traffic stop itself? Yes.
And the arrest was legal, correct?
Yes, officers had probable cause to arrest for the bench warrant.
Well, besides the bench warrant, you knew that Wright did not have a license, correct? You learned that from this case, did you not?
Yes.
You learned that he didn't have car insurance, correct?
Yes, that's correct.
And you learned that the registration of the tabs on the car were old, outdated.
Expired, yes.
Yes. And you learned that there was a lady in the car also, and when they pulled up his record, he had a temporary restraining order in order for protection for some lady, correct?
Yes.
And the officers did not know at that time who the lady was in the car, correct?
Yes, that's correct.
And then when they went up to arrest Mr. Wright, they had a special awareness, did they not, based on what you read, about a firearm being in that car, correct?
No, there were no specific and articulable facts that there was a firearm in the car.
Okay. But you as a patrol officer 15 years now, from 15 years ago, you would agree with me that there are many more weapons and firearms and cars and on person than there were 15 years ago. Do you agree with that?
I don't think there's any valid statistical evidence to support that.
And you as a patrol officer, now, 15 years later, it would not bother you a bit about a weapon and being in that car or being on his person, knowing that he had a weapons warrant against him. That wouldn't raise your suspicions or concern at all when you went back up to that car. Is that right?
That's not my testimony.
Well, would it raise your concern when you went back up to the car to arrest Mr. Wright that he had a weapons warrant outstanding, a bench warrant? He didn't show up, a judge ordered it. Would that raise your concerns about a weapon being in the car?
There is always...
That calls for a yes or no, by the way. Yes, it would raise my concerns, or no, it wouldn't.
I can't fairly answer the question with a yes or no.
Okay, well then don't answer it. So you can't answer that question because you don't know?
No, sir. I can't fairly answer the question with a yes or no.
All right. And the arrest of Mr. Wright at the car, when they got him out of the car, they said, "You're under arrest." All three said it, correct?
I know at least two of them said it.
Two said it, and Officer Lucky was trying to handcuff him, correct?
Yes.
And before Mr. Wright broke away from Officer Lucky, everything was according to protocol. They did everything correct, the officers. Am I right on that?
I would not describe it as the best tactical approach, no.
Okay. But there wasn't any unreasonable force involved, was there?
No, not at that point.
And you wouldn't describe it that way, but you haven't been a police officer for 15 years, have you?
That's about correct, yes.
Yes. So the arrest, the handcuffing of him was legal, correct? The attempt to handcuff him?
Yes.
Okay. And Wright's break away from that handcuffing, trying to get back in his car and actually getting back in it, that would be illegal, correct?
Yes.
The objection is overruled. The answer will stand.
And only as a result of what Mr. Wright did by doing that was what happened, and was chaos after that, correct? Would you agree chaos as far as the video that you saw?
I don't think it was only because of that, but certainly that was a predicate factor.
Well, Mr. Wright, he's the one that started it, correct? Nothing would have happened except for the fact that he broke away once he learned there was a warrant. Is that a fair statement?
Sure.
Okay. And do you agree that the video of the incident showed chaos? That it was very fast acting? I think it lasted, I can't remember here. Let's see, 5:19. About 30 seconds total from when he got out of the car. Is that correct?
The objection is overruled. You may answer.
So, do you remember that? Or I'll ask you specifically. When Wright stepped out of the vehicle, it was 5 seconds between that time and the time he was told he was under arrest. Do you remember that?
That sounds about right.
And once he was told under arrest, 14 seconds later, and you remember in the video, that's when Officer Lucky was attempting to handcuff him. 14 seconds later, Wright pulled away and gets back in the driver's seat. Is that accurate about?
That sounds about right, yes.
And then 3 seconds after that, and if he tried to get back in the driver's seat, was trying to, 3 seconds after that, if you remember the video, Ms. Potter went around to the left side and said, "I'll tase you." Remember that?
Yes.
And let me ask you a question. When somebody says, "I'll tase you," that's a warning to the person being arrested to stop or you'll get tased. Is that a fair statement?
Yes, the purpose of the warning is to generate compliance.
Yes, and in addition to that, when two officers, Johnson and Lucky, are wrestling with the guy, that's telling Mr. Wright that, hey, we don't want you to leave, we want you to be arrested. Is that a fair statement?
Yes, I think it would have been abundantly clear to someone in Mr. Wright's position that the officers were attempting to arrest him.
And would that raise your suspicion at all as to why in the world would this man, Mr. Wright, attempt to get away from 3 law enforcement officers?
As to the reasons for it?
Yes, besides the warrant. Objection, speculation. He's the expert, Judge.
The objection is overruled. You may answer.
Would that go in your mind at all that this guy with 3 officers there, the one officer say, "I'll tase you," the other officer, Lucky, at first is wrestling with him and he doesn't stop? Would that cause you to be concerned that maybe he's wanted for something else?
Not unless
Wouldn't that be good
warrant
police
would-
work? I'm sorry.
Without the warrant showing up on a system, I would not be concerned that he was wanted for something else, no.
That wouldn't concern you, that a young guy is trying to get away from 3 officers, 2 officers, or at least one, Officer Lucky, who you might remember if you saw the video, is a rather tall fellow, and Officer Potter are trying to stop him. He's wrestling with them, and Potter's saying, "I'll tase you." And nothing would enter your mind, I suppose because you haven't been a police officer in 15 years.
Objection, Your Honor.
But would it enter your mind at all?
Mr. Gray, if an objection is made, can you stop talking, please, so I
sorry.
can rule on it? All right. The objection is overruled.
Thank you. So you've heard my description, and you're the use of force expert, the police procedure expert, correct?
Yes.
And would that raise any suspicion in your mind that maybe this kid's got some other issues? No?
The question you had asked originally was, would it raise a suspicion that he was wanted on something else? And without another outstanding warrant for him to be wanted on would appear in the system, the answer is no. Would it raise some speculative risk that there might be other things going on? Without specific and articulable facts, you have at best a risk. You have some speculation of possibility, but you don't have the sufficient basis for legal action. There's no threat, if you will.
I understand that, but it also causes the officers to have that suspicion. We got to stop this fellow. Maybe there's something else there that we don't know about. Another investigation, not a warrant, but he's being investigated for another serious felony.
I'm going to sustain the objection, and the jury is to disregard that last question, and you are not permitted to answer.
Now, when you wrote your report, you assumed that Officer Johnson was not in the car at the time of the gunshot, correct?
I would say I concluded that rather than assumed it.
Okay, and you concluded it because you said that you couldn't see him in the car?
That on synchronized versions of the video, it was pretty clear that he was no longer in the car at the time of the gunshot.
Okay, so the car, the reason he got out of the car was because when Miss Potter said taser, 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 that would be a warning to the other two officers to release him, correct?
I can't speculate as to his motivation, but it's possible.
Well, is that the signal? If you're the taser man here, the expert, isn't that the signal? Taser, 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 to tell the officers to back off? We're going to shoot this electricity at them?
The warning of tasers has a couple of meanings, a couple of purposes.
Well, one of the purposes is taser, taser, taser tells the officers to get away from him because I'm going to tase him, correct?
I would say it tells officers to remove themselves from the taser target area.
Okay. Well, Your Honor, if you would answer the questions yes or no, which I'm asking them like that, instead of giving me a statement afterwards, I would appreciate that he be instructed not to do that.
Still, again, one person at a time, okay? You're going to have a really messy record if you don't comply with it.
Judge, I can't hear what you're saying.
I said one person talking at a time, okay? So don't talk over him, and wait until the question's finished before you answer.
Yes, sir.
All right.
Thank you, Judge.
Yes.
Okay, so after Wright's told he's under arrest, my watching and reading of the reports and watching the video, 14 seconds later, Wright pulls away and gets back in the driver's side. Do you agree with that?
I apologize. Did you want me to answer the previous question about the taser, taser, taser?
I thought you did. I thought you agreed that it was a warning to the other officers to back off. You didn't say that?
No, not exactly.
Okay. Well, what did you say? Go ahead.
It's a warning for officers to remove themselves from the target area. Officers are trained to apprehend someone who's under the influence of a taser. You can grab, for example, someone's arms even while they're being tased in the torso. So it's not a warning to absent themselves and move 5 feet away or something like that. It is a warning that the taser is going to be used. The other significant reason for that taser warning is so that officers don't confuse the pop of the compressed nitrogen for gunfire, so they don't mistake the taser discharge for gunfire.
Okay. And one of the reasons is that to back off the individual, if they've got their arms on him, when he's tased, to take their hands off of him because they might get a shock too, correct? Is that one of the reasons?
No, I would not say to take their hands off of someone because you often want to apprehend someone while they're being tased.
Okay.
So it's to warn them that a taser is about to be used. if their hands are on someone's torso, which is the typical target area, you certainly don't want to be in that area of effect, but it's not to back off of them entirely now.
All right. 3 seconds after Potter says, "I'll tase you," Kimberly Potter, first 5 seconds, Wright pulls away and Potter says, "I'll tase you," after 5 seconds. Now, on the video, after she said that at 2:01:55, did you see Mr. Wright at all say, "I give up," or "I won't fight anymore," or anything of that nature?
No, he was never compliant.
And that would be a warning that she was going to tase him, correct? If he didn't stop.
Her statement, "I'll tase you," is certainly a warning of an impending taser discharge, yes.
And if he would have stopped, you're assuming that the police officer wouldn't have tased him, correct?
Yes, that is a fair assumption.
And then at 3 seconds later, Mr. Wright, according to the video, is still fighting with the officers, and Potter says again, "I'll tase you." And did that affect Mr. Wright at all? Did he stop fighting at all when Miss Potter said for the second time, "I'll tase you"?
No, he was never fully compliant.
He wasn't
after
compliant at
pulling-
all, was he? What do you mean fully compliant? He was fighting, wasn't he?
After pulling away from Officer Lucky, he was never compliant.
Before that? Okay.
Before that, he was compliant. Yes,
Yeah.
he was not fully compliant throughout the interaction. He was not compliant after the pulling away.
I'm asking you about during the time he wasn't compliant, sir. Can you understand that? You know what I'm talking about?
He was, I think so. He was not compliant in the time where he was not compliant.
And the warning, "I'll tase you," the second warning, for 4 seconds he continued to fight with the officers, and the taser was pointed at him, according to the video, correct?
No.
No?
No taser was pointed at him.
You're right. The gun was pointed at him.
Yes.
Thank you. And by the way, the new taser, the 7, did you know that that taser and the one that Miss Potter got a month before, a month before this, she got the new taser, Taser 7. Prior to that, she had a different taser. And the different taser had a yellow handle and a yellow top, where the new taser, the 7, had a black handle and a black top. Did you know that?
I believe there was...
Did you know that? That calls for a yes or no. Answer the question, yes or no, please.
I don't think that's an accurate description of the taser.
The taser that she had?
The X7.
I'm talking about, okay, the Taser 7, the top was black and the handle was black, correct? The rest of it was yellow. Fair statement?
There was... can you clarify what you mean by the top of the
well,
taser?
Where you put you got your handle here, and right here was black from where the handle is over here.
Yeah, there's yellow on the sides of the part that protrudes from the thumb side of the hand in a grip, yes.
Yes, but the handle is black and the top is black, correct?
I believe that's correct.
And, well, you're the taser expert, wouldn't you know that?
There are a number of different models of tasers still in use.
Did you know that the taser that she had before this, 3 weeks before this, was all yellow? Did you know that?
That was the X26P, as I recall, and I believe the model, I don't remember the coloration of the model she had.
Okay, so you didn't know that. That's your answer, right?
I don't recall offhand. I can see if it's in my report if you'd like.
You also had in your report that Potter was not aware of Johnson being in the car. You remember that, writing that in the report?
That's a slightly inaccurate description of my report.
Well, you said that you couldn't... Well, what did you say?
I said the available evidence indicates that she was not aware of that.
Okay, and now the available evidence is that he was in the car, he testified he was in the car, and he was fighting with Mr. Wright before the shot. Did you read that testimony, or did you hear about it?
I heard the testimony, and that is consistent with the body camera video. He was in the car and struggling with Mr. Wright prior to the gunshot.
Okay. And it was a second prior to the gunshot, correct? The taser, and then the Potter fires a gun? 1 second or less.
Between
taser, and the gun being fired.
Yes, by the end of that warning, it was a relatively short period of time, within a second.
The answer is yes. Would you answer my questions if you can with a yes or no? It'd be a lot easier.
Well, taser takes some time to say. By the time at the end of that warning, I agree, it was less than a second before the gunshot.
And that's when the officers took their hands off him, correct?
I'm sorry? No, the officers had their hands on him well before the gunshot.
Yes, but when did they take their hands off him? It was before the gunshot, wasn't it?
Sergeant Johnson took his hands off of Mr. Wright and backed out of the vehicle prior to the gunshot. Officer Lucky had hands at least in the direction of Mr. Wright. I don't remember offhand if they were making contact at the time of the gunshot.
Okay.
It was immediately after the gunshot that Officer Lucky backed away.
Is your testimony that Mr. Johnson's part of his body was not still in the car?
I testified earlier that his hands were still in the car. He had backed his torso out of the vehicle. His hands were still in contact with either the passenger or perhaps Mr. Wright's right hand.
So he was in the passenger's doorway, and he's leaning over with his hands on Mr. Wright. Is that what you're saying?
No, I'm saying he was backed out of the open front passenger door. His hands were either on the passenger or on Mr. Wright's right hand that was in front of the passenger.
Okay. Oh, that's what I thought I said. That's all right.
Members of the jury, I think we're overdue for a break, so we're going to take our afternoon break right now, and it'll be 20 minutes, okay?
Thank you.
Sorry. Okay, counsel, we're taking a break.
Put your hands up! Put your hands up! Put your hands up! Put them up! Put your hands up! 3.
Officer Salvosa, I'd like to now play for the jury a third video. Do you recall that your body-worn camera continues on past that point, beyond the point, and actually captures your interaction with the vehicle and ultimately the response by the group of officers?
Yes, sir.
And you've had an opportunity to review that prior to trial, correct?
Yes, sir.
At this time, the state offers Exhibit 39. That's a portion of Officer Salvosa's body-worn camera.
Any objection? Denied. There being no objection, 39 will be admitted and you may publish.
Thank you, Your Honor. This video is a bit longer, Officer Salvosa, correct? It's about 16 minutes long?
Yes, sir.
Okay. You will be given an opportunity to discuss issues if they come up. Could we please play that, Mr. Miller?
He's saying that she's tired of being a Democrat because of the anti-Semitism that she's
3219, PI accident, 63rd and Catherine Drive, fled from 38 start north on the Reds.
Did you recognize the voice on this video?
Yes, sir.
And whose voice was that?
My voice, sir.
Did you hear yourself say, start north on the Reds?
Yes, sir.
Could you tell the jury what that means?
North Memorial Ambulance is the ambulance company that provides services to Brooklyn Center. So when we refer to them as North, so that would basically refer to an ambulance. On the Reds means the fastest response possible.
Okay. Lights and sirens?
Yes, sir.
Put your hands up! 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 Put them up! Put your hands up!
3219, several at gunpoint, 63rd and Catherine Drive. Start north on the Reds and start 2 rigs. We've got a civilian car injured as well. As soon as we get additional cars, I'll check for injuries. Suspects are not compliant. They're moving around.
Put your hands up!
Hey, sir, stay there. Stay there.
You had directed someone to stay there. Do you know who you were talking to at that time?
I believe it was the person in the injured vehicle.
Which injured vehicle?
The Subaru that was hit head-on in front of me, sir.
Okay, and can you actually see the other vehicle on your screen now?
It's just in the corner by my door frame. You can kind of see it right outside my door frame.
Okay. Right outside your door frame in the way left side of this image?
Yes, sir.
Okay. You can continue, Mr. Miller.
Put your hands up! Lower the window! Lower the window!
Ma'am, are you okay? Stay there. Stay there. 3219. We'll take 2 rigs, stage them a couple blocks out. What's that? 3219. The driver is not breathing. I'll take an additional squad and we'll yank him out. But get him here on the Reds. I'm by myself holding him at gunpoint. $3,219, make it 3 rigs. I got 1 male not breathing, 1 female with facial lacerations, and then I've got another civilian car that I have not been able to check on yet.
But anybody that's available.
Incoming squad, come to me at 63rd and Catherine so we can get the driver out and the passenger, and then we'll have to check on anyone else after, but the driver is not breathing according to the passenger. Passenger's moving around. I can't see him, but we're going to need to extricate him if he's not breathing. So I'll wait for additional. Let's come up with the plan. Okay, so female passenger, driver.
I just wanted to pause quickly. 2:06 and right on the dot. Would you agree that that's the timestamp that the video is paused at this time?
Yes, sir.
And in your leftmost view on this screen, do you see the number 1683?
Yes, sir.
Could you tell the jury what you're seeing at this time?
I'm seeing one of the first officers to arrive, which would be a Brooklyn Park squad.
Okay. And I won't interrupt at this time. You're going to begin to explain the situation to him, I assume?
Yes, sir.
Okay.
He's not breathing. 3 from the traffic stop, and then they crashed. 3-2-19. The suspect I'm a gunpoint at is a flea from 38 stop. Ma'am, get out of the car! Passenger, get out of the car! Get out of the car! Get out of the car so we can take care of him! Get out of the car! Yes, you! Get out of the car so we can help him! Get out of the car!
Let's grab a bunker if you got one. You got a bunker?
Copy that. Ma'am, put your hands up.
I'm behind you.
Okay, he's not. Yep, I see him. He's not breathing.
Okay.
Hey,
How
Jeff.
many other people are in it?
Just 2.
2 more in
That-
it. One in the back. You got a 40? All right. Let's have you guys come up from behind then. There's one still.
He's not breathing.
Well, we'll deal with that when we deal with it.
Copy that. I can't see the back seat.
So the back seat possibly has a passenger still moving around. Do we have anybody who has a bunker? My sergeant's coming over. Okay. Let's wait till we have one then.
Yep. I'm in no rush. Someone go check on that car, see if they're okay. So he hit that car and crashed too.
3207, if we can still get a bunker to 63rd and Catherine.
300, we've got a bunker.
Besides the guy laying out in front?
If that's one in the squad here, it's clear bunker.
In bad shape? 63, oh, that's too far down.
Okay.
I copy. We got one out of the car, still got 2 in there. Can't see what the one in the back seat's doing.
I'll be arriving.
You want to bring your 40 up here? Oh, you got it there? No, that's fine. That'll work.
Take back! Washington and Robbie.
63rd and Catherine with the, if you have the bunker. Okay. That's it? Okay. Oh, we see one in the front passenger seat.
Can you guys make sure no one else is in that vehicle?
You guys want to come up from behind? Would it? You think so? All right, bring it around then. We can do it. We can bring it around. You stay here. I'm gonna
Copy that.
step back.
White, Buick, plate status, expired, 1. State records hit.
Hey, Al.
No.
It's just the driver right now.
Yeah, that's all I can see.
She didn't say there's anyone else?
She doesn't say there's anyone else. I couldn't really see because she was moving around so much.
Your incident is going to take
Yeah, so you, whoever's hater, you're going to cover through that front window. Okay? And then whoever's on my left, whoever needs to leave on my left,
2011
I want you to clear
plate
that back.
viewing. Plate status expired.
Ready? So block that window. We're coming up. We're moving up.
Copy that.
Block that window.
Officer Savosa, in the last 2 seconds of this video, first of all, can you identify the timestamp on this video at this time?
It says 2:10 and 55 seconds, sir.
Okay, and some individuals just walked across the screen, correct?
Yes, sir.
Who are those individuals?
Officers from other agencies.
Okay. And what is going on at this time in the video?
They have stacked up and looks like they had a bunker and a rifle, and they're approaching the vehicle to clear it.
Okay.
Jesus fucking Christ. Yeah, he's probably not going to make it. What's it? Not shots fired. What's that? Oh, he did? Oh, I didn't yell shots fired.
I got your keys.
Back.
We don't have exits.
Where's he got the shots?
Chest. Does anybody have? Do you have your?
I got nothing on the back.
Well,
Those tips that we just got?
Okay. I got nothing right there, Mel. No, that's in, that's out.
you want to start putting some tape up there?
Yep. Hey, folks, you're going to have to back up. Back up. Back up, folks. Back up to the end of the block, please. By the white car. What's that? No, I'm okay. Thank you. Yep.
Could you pause at this time? Officer Salvosa, at this time, 2:14 to 21 seconds, would you agree that the audio cut out?
Yes, sir.
And why did the audio cut out?
Me and Officer Fricke had a private conversation.
And in that private conversation, you're able to mute your camera?
Yes, sir.
Okay.
Okay.
Who can I talk to about more patients? I don't know. Nobody knows anything.
So, female patient in here, that's the...
Do you recognize the individual you're addressing at this time?
That's a North paramedic.
Okay. So is this the first time that you've encountered the paramedics on the scene?
No, an ambulance drew by earlier in the video, and a bunch of them were walking around.
Okay.
Female patient, there was someone in this car. $219. Does anyone know the patient, where the patient of the Subaru is? Is she okay? We have North here.
I'm not going to tell him to say yes or no if he can't answer with a yes or a no. But I think we got it. Our poor court reporter has a really hard job, and let's not make it harder for her. Okay? All right. You ready for the... Thank you. You can have a seat. All right, thanks, Jackie. Okay, please be seated. Mr. Gray, you may continue.
Thank you.
Please be seated. Okay.
Thank you, Ron. Mr. Stoughton, I'm going to ask you a couple of questions about your CV, your curriculum vitae, and you have one on page 6. You have it titled Selected Expert Consulting Reports, Depositions, and Trials. And most of the listed selected expert consulting matters are civil. Is that a fair statement?
Yes.
And these civil cases that you are a consultant on, or sometimes testify and sometimes give a deposition, the civil cases are 1983 actions, correct? Most of them?
1983 or state tort suits, yes. Or a combination of the two.
Okay, and the 1983 action is an action where the law enforcement officer, or maybe the city that he works for also, are sued for an unreasonable force. Fair statement?
Some of them are alleged excessive force cases. Some of them are other Fourth Amendment violations like unlawful search, unlawful arrest. Some of them are, it's a range, but they are allegations of constitutional violations generally.
And what happens in those cases is an individual, a plaintiff, sues the police officer and maybe the city under Bivens versus United States, correct?
Not under Bivens. Bivens is a federal action, so it would be under Monell.
Okay, but federal actions would be under Bivens.
A lawsuit against a federal agent or federal officer would be a Bivens action. A 1983 suit is against a state or local officer.
All right, I'm not going to take issue with you on that. The fact is that you've assisted on, I counted here about 30 cases involving plaintiffs suing law enforcement officers. Is that about accurate?
It's
on the CV.
I'm sorry. Are you asking me whether it's accurate on the CV or accurate as to what I've done?
The CV that I received, I'm asking you.
Yeah, that sounds about right as far as listings on the CV. Sure.
And it is true, is it not, that of these 30 cases you cite, I counted 27, but take my miscount off and call it 25. That of the 30, 25 of those were either you testifying as an expert for the plaintiff, which would be the person suing the cops or the city, or taking a deposition or assisting the plaintiff in suing law enforcement. Fair statement?
I would not describe that what I'm doing is assisting the plaintiff. I am reviewing a case file and rendering an opinion.
And you're doing that for the plaintiff, right?
I am hired by plaintiff's counsel to review the case and render an opinion.
And once you render that opinion, if you believe that there's a violation of the individual's constitutional rights, you tell the lawyer, right?
So my opinions in those cases still apply the professional standard. I'm not testifying that there was a Fourth Amendment violation in most cases. What I'm saying is an officer's actions are or are not consistent with generally accepted practices.
Okay. And you're hired by the plaintiff in 27 of those 30. Is that right?
The CV has maybe half of my total retentions. So of the ones on my CV, I would have to count them up. I haven't done so, but that could be right.
Would you say that you're hired by the plaintiff in more cases than are in here, in the CV?
Numerically or proportionally?
By the number, are there more than 27?
Yes.
Okay. You also have written about police body-worn cameras. Actually, you wrote a North Carolina law review, and I believe it was in 2018, about body-worn cameras, correct?
Yes.
And I quote you in this body-worn camera article, Limits of Human Interpretation, page 1405.
The objection?
Proper form of cross-examination.
The objection is overruled.
You write in the law review, the potential for body-worn cameras to have informational benefits assumes that viewers will be able to accurately interpret the recorded videos, but just as digital cameras have inherent limitations, so too do their users. We all suffer from a range of cognitive limitations that can affect our ability to interpret evidence, including video footage. Is that what you wrote?
I don't recall the exact wording, but it certainly sounds like what I wrote.
Would you take issue? I can show it to you.
No, I accept it. It is definitely the point that I was making, and I will accept your representation that that is accurate.
Then on
The
the
wording
next
I used.
page, you write, one such cognitive bias is motivated reasoning, defined as a tendency of people to conform their assessments of information to some goal or end other than accuracy. Did you write that?
Same point, yes, or at least certainly words to that effect, and I accept your representation that that's what I wrote.
Relatedly, the tendency to interpret information in a way that confirms one's pre-existing worldview or beliefs that Kahan calls identity affirmation or identity protective cognition also affects the way we see the world. Did you write that?
Yes, Kahan, yes.
So what you're saying here is that the body-worn camera's informational benefits assumes that viewers will be able to accurately interpret the recorded videos. But just as digital cameras have inherent limitations, so do their users, correct?
Yes, absolutely. A great deal of the body-worn camera training that I do is on interpreting body-worn camera footage for exactly those reasons.
And what you did in this case is interpret body-worn cameras, correct?
I would say I interpreted body-worn camera footage in the compilation of an entire set of evidence. Certainly,
Okay.
body-worn camera footage is included in the body of evidence, but it's not.
You interpreted body-worn cameras, and you also read the police reports in this case?
Police reports, about 6,000 or so pages of documentation, interviews, dash cam or squad cam footage, yes.
And you also, did you know about Sergeant Johnson's testimony in this case?
Yes, I also reviewed some of the testimony in the case, including most of Sergeant Johnson's.
And the opinions you wrote were prior to Sergeant Johnson's testimony. Fair statement?
Oh, absolutely. Yes, I wrote the report prior to his testimony.
Thank you, sir.
Thank you.
Thank you, Your Honor. Professor Stoughton, I think I'll be brief. You were asked about this article you wrote in 2018 about body-worn cameras. You recall that testimony?
Yes.
And
excuse me.
And during direct examination, I asked you about some of your work with body-worn cameras. You talked a little bit about that. Was that paper you wrote part of your answer, what you were telling us that you have done with regard to body-worn cameras?
Yes, that's part of the body of work. I focused on body-worn camera footage and its interpretation.
And Mr. Gray read to you a couple of quotes from your article about the potential for body-worn cameras to have benefits and limitations.
Yes, that's correct.
That was, I think, the essence of the first part you read?
Yes, the idea that that getting the most information out of body-worn cameras is limited by the first clause. There was some of the limitations of the technology itself, which I talk about in a previous section of the article, and then that section is about human interpretation of camera footage.
And the second part that he read to you was about, my understanding, some kind of cognitive bias, correct?
Yes, a particular type of cognitive bias that affects human ability to interpret information.
And so you are aware of that, have studied that?
Yes.
Did you, when you were creating your opinions in this case, were you careful to avoid any cognitive biases regarding the body-worn camera video?
To the maximum extent possible, absolutely.
You were asked about the different versions of the taser from the X26P to the Taser 7. Do you recall that being asked about that?
I do, yes.
Your Honor, may I approach to retrieve Exhibit 203?
Yes, you may.
And Professor Stoughton, I will represent to you that Exhibit 203 has been previously received in evidence as the taser that Ms. Potter wore on the day of this incident. And, Your Honor, if I may approach, I'd like to have the witness explain what he understands the difference in the coloring of the two models.
You may approach.
Thank you.
And I'd like to first, for the record and for everybody in the courtroom, the battery has been removed from that taser, correct?
It has, yes.
So it's incapable of firing?
Yes, and yes, that's correct.
So, and if you could just point out to the jury the differences in the two, just trying to remember to stay close enough to the microphone to be heard.
Sure. So the Taser X26P, as I recall, has two different coloration patterns. It has an all-black model, and there is, I believe, an all-yellow model where the entire top is yellow. This is the X7 where, except for this strip, the handle is black, and then the top of the taser is half yellow, half black. The sides, as you can see, are predominantly yellow, but for the release switches there.
And then I would like to show you Exhibit 13, and I would ask that it go, that's the body-worn camera of Ms. Potter, and ask you to go to 20156, please. And while Mr. Miller is doing that, Your Honor, may I approach the witness to retrieve the exhibit?
Yes, you may.
You see that portion of Exhibit 13 on the screen in front of you?
I do, yes.
And for the record, it does, the timestamp reflects 20156. Would the yellow markings on Exhibit 203, Officer Potter's taser, have been visible if it had been in Ms. Potter's hand rather than her Glock?
Yes, had the firearm been a taser, the yellow markings would have been very clearly distinguishable on this picture.
You were asked about the interaction between Mr. Wright and the officers, Lucky and Johnson, and the word I believe that Mr. Gray used was fighting. Do you recall him asking you those questions?
Yes.
Was there a time when Mr. Wright was compliant?
There was a time when Mr. Wright was compliant prior to pulling away from Officer Lucky's attempt to handcuff him, yes.
And then after that, did you see any evidence that Mr. Wright was assaulting the officers?
No, the evidence, both in the material I reviewed as well as the testimony, suggests he was not aggressive or assaultive in the sense of, for example, trying to strike the officers or retrieve a weapon or the like.
But he was trying to get away?
Yes.
So is the word fighting one that you would use to characterize Mr. Wright's behavior?
I can understand how that word would be used casually. It's not the word that I would use.
What word would you use?
You could use resisting, actively resisting, even struggling. Fighting, I think, for me at least, connotes a degree of aggression or assaultive behavior that is lacking in this case.
Mr. Gray asked you if you would agree that if Mr. Wright hadn't decided to be non-compliant and pull away from the officers, none of this would have happened. Do you recall that question?
I do.
When, well, based on your training and experience in this field, once an individual attempts to pull away from the officers, are the officers still required to use reasonable force?
They are. The idea that merely because someone resists an officer sort of allows officers to do anything at all is one of the points that we talk about in the book. Should be a two-staged question. First, did the individual resist in a way that justified some use of force? And then if so, how much, what type of force, how severe is the force that officers could use in that particular circumstances? So the fact that someone is resisting can certainly justify some force, but does not allow officers to use any amount of force in response.
And you were asked about your incidents when you were working as a police officer. Do you recall being questioned about that?
I do.
And you were asked if, when you got into incidents, whether your adrenaline started pumping.
Yes.
And I think you said that, colloquially or casually, or one way of saying it?
Sure, yes. Yes.
Based on your training and experience in the field that you currently work in, Professor Stoughton, when an officer gets into those situations and, to use the phrase, the adrenaline starts pumping, are they still required to use reasonable force?
Absolutely.
When you were working as a police officer, did you have to, when you started a shift or went to work, have to think about being able to act reasonably as a police officer?
Object, Your Honor, it's outside the scope of my cross-examination.
The objection is overruled. You may answer.
Yes. Prior to every shift that I worked, it was my habit, as I was putting on my vest, as I was strapping on my gun belt, to review my equipment to make sure that I was emotionally, I suppose we would say now, emotionally in a position to do my job.
That's all I have, Your Honor, and if I may approach the bench to return the exhibit.
Yes. Okay, Mr. Gray?
Yes, just a couple. Mr. Stoughton, you do agree on that video, you do agree that when Mr. Wright broke away from attempting to be handcuffed, that he tried to get into the car, got in the car, and if the officers had let him go, he would have taken off in that car. Is that right?
Yeah.
I'll let the answer stand.
I think that's the logical conclusion of what he was trying to do, yes.
Yes. And if he had taken off in that car because the officers were there, not in their car, they were standing out in the street, you would logically conclude that he'd take off quite fast, correct?
I don't think there's enough information to say their low-speed flight is not uncommon in vehicles.
Usually when somebody takes off from 3 officers in 2 squad cars, you drive slowly.
I'd say it's not uncommon for someone to flee a traffic stop at low rates of speed or high rates of speed.
They're both the same. Is that what you're saying?
No, they're different rates of speed.
Okay. Well, so wouldn't it be reasonable for a person fleeing from the law enforcement officers, 3 of them, 2 squads, to leave in a fast manner?
I don't think it's particularly reasonable to flee from an arrest.
Would it be reasonable to flee if you're stoned on marijuana?
The objection is overruled.
You may answer.
You were aware, were you not, based on you knew the testimony here, that the autopsy witness said that he had a high rate of marijuana. Were you aware of that?
I am aware of that. It didn't factor into my analysis because it wasn't information available to the reasonable officer at the time.
But you would agree, would you not, that it would be a danger to the public to have somebody driving a vehicle high on marijuana? Fair statement.
Objection to relevance.
Yes, the objection is sustained.
Okay. Sure. That's all I have. Thank you.
Mr. Frank, any redirect?
Nothing further, Your Honor. Thank you.
Okay. You may step down.
Thank you.
The state may call its next witness.
Thank you, Your Honor. The state calls Aubrey Wright.
Do we have a standing objection?
Yes. Okay, Mr. Wright, please come forward and stand behind the witness chair right next to me. And will you please raise your right hand? Do you swear under penalty of perjury that you will truthfully testify in connection with this trial? All right, you may take a seat. And could you please remove your mask? State your full name and spell it.
Aubrey Wright, A-R-B-U-E-Y. Last name is Wright, W-R-I-G-H-T.
Okay, Mr. Wright, a couple things to keep in mind when you're testifying. The court reporter is taking down everything that's being said, so you have to answer orally instead of shaking your head. And please don't say uh-huh and uh-huh and uh-uh, because that doesn't come out on the record. Also, if you don't understand a question, please let the questioning lawyer know and it will be clarified. If an objection is made, you need to stop talking immediately and not answer the question unless I tell you to do so. All right?
Yes, ma'am.
And only one person can talk at a time because the court reporter can't take down two people talking at the same time. Wait until the question is finished before you start answering.
Okay.
All right. Counsel?
Thank you, Your Honor. Good afternoon, Mr. Wright.
Good afternoon.
I'm going to ask you some questions just about who you are and have you introduce yourself so the jury can learn a little bit about you, okay?
Okay.
How old are you, sir?
42.
And what city do you live in?
Minneapolis.
How far did you go in school?
12th grade.
And are you working now?
Currently not.
And are you married?
Yes.
Who are you married to?
Katie Wright.
And does Katie Wright also go by her legal name, Katie Bryant?
Yes.
Do you and Katie have any children together?
We have 3.
And could you tell the jury their names, please?
Dante Wright, Destiny Wright, and Diamond Wright.
And is Dante, your son Dante, is he no longer with us?
No.
Was Dante the oldest of the 3 children?
Yes, he was our firstborn.
What was Dante's role as the older brother to 2 younger girls?
His role to the younger girls was the big brother, to look after them, watch after them.
And what was his relationship like with his younger sisters growing up?
The relationship with the younger sisters was like a big brother. Joked a lot, always constantly following behind them, making sure they were okay.
And did you and your wife, Katie, and your children, Dante and Diamond and Destiny, all live together up until Dante's death?
Yes, we did.
Do you also have some other children from a previous relationship?
I do.
And how many other children do you have?
I have 2 other kids prior to our relationship, Marcus Wright and Monica Wright.
And where do Marcus and Monica live?
They live in North Carolina.
So between you and your wife, Katie, how many children do you have altogether?
She had 2 kids prior to our relationship, so we had 7 altogether.
So getting back to your life with Dante growing up and his younger sisters, what kinds of things did you and your family do together for fun to pass the time?
Well, we got together every Sunday we would have cookouts and stuff like that. Family days, we would do movies and stuff like that. We did a lot of things as a family, as a group, because we're like all we have. So
cookouts, you said?
Cookouts constantly every Sunday, every weekend, pretty much.
Did Dante have any favorite foods?
Well, yeah, he did. He liked chicken, I guess. We all did. So.
Was that a family favorite at the cookouts?
Excuse me?
Was chicken a family favorite at the cookouts?
Oh, yeah. Yes.
Did he like sports?
He loved basketball. He played pretty well. He was a left-hander, so he was pretty good.
And as he grew older, into his teenage years and beyond, did he have a variety of different jobs that he worked?
Had a lot of different jobs. I even got him a job with me before.
And when you say you got him a job, was there a time where you and Dante worked together?
Yeah, it was the time we worked together. I was his boss, and I was happy, you know, to have my son coming on to work with me.
Where was it that you two were working together?
I was a manager at Famous Footwear.
And about how long did you two work together at Famous Footwear?
About a year. He worked there about a year with me.
About how long was that before he died that you two worked together?
Well, it was his last day was when the COVID hit. So his last day working with me was right in the beginning of the COVID.
So about a year ago is when you guys stopped working together. How was it for you working with your son, Dante?
It was great. It was challenging, you know, to work with my son. You know, I tried to let him understand the difference between where at work I'm your boss and at home I'm your dad. It's a difference. So, but it was funny. Like it was this one time where I had sent him home because he was on his phone at work and he wasn't supposed to be on the phone at work. You know, like yo, we gotta go home. And so he went and asked my boss, "Is it okay if my dad sends me home?" And I'm like, my boss like, "Yeah, he's your boss." And I'm like, "Well, you need to go home and come out in the hallway." And he's still there. And I'm like, "Well, why are you still here?" And he's like, "Well, Dad, I rode with you. I couldn't go home because you're my ride." I think it's funny, but yeah, that was a funny thing that happened at work.
So not only were you working together, but you were driving to and from work together?
Yeah, every day, yeah.
You got to spend some quality time together.
Yeah, spend a lot of time together.
Your Honor, at this time I'd offer Exhibit 240.
Any objection to 240?
Okay, I previously ruled on it over defense objection, and 240 will be admitted into evidence.
Thank you. If we could publish it, please, and put it on the screen. All right, there's a picture on the screen now. It's Exhibit 240. Could you just explain to the jury what's shown in this picture? Take a minute if you need one.
Picture of me and Dante. You see how, you know, I was holding him. See how his arm, we had a close relationship. He was me and my wife's first child.
And was this picture at your home?
Yes.
Was this not long before he passed away?
This was right before he passed away.
And if we could put on the screen Exhibit 3, please. That's already been admitted. Did your son Dante also have a son of his own?
Yes.
And
First and only child. That's my grandson, Dante Jr.
And your grandson's name you said is Dante Jr.?
Yes.
How was it seeing your son Dante as a father?
Excuse me.
How was it to see your son as a father?
Man, to see him as a father, it was like I was so happy for him because he was so happy. He was so happy about Junior. And this was my chance to be a grandfather.
Did they have a close relationship?
Yes.
And did Dante Jr. spend a lot of time with your family as well?
Yeah. Dante Jr., you know, Dante lived with us. Junior was pretty much there every day. And he loved his son.
And do you love your son, Dante, a lot as well?
A lot. I love Dante. He was loved.
Do you miss him?
I miss him a lot every day.
Thank you, Your Honor. Nothing further.
Is there any cross? All right. Thank you, Mr. Wright. You may step down. Does the state have any further witnesses? All right, members of the jury, we're going to stop right now, and I'm going to let you go home, but I want to remind you, and I've told you this before, I don't mean to insult you, but it's very, very important that you not listen to any news reports about this case. Don't read any articles, don't, any podcasts. Don't do any research on the case, and stay off social media about this case, okay? Now, I heard that we might be having some bad weather tonight, and tomorrow the roads may be a little icy, so I do want to start on time tomorrow at 9 o'clock. So please take that into consideration, the fact that it might take you longer to get places tomorrow morning, okay? All right. Have a nice night, and we'll see you, and drive safely tomorrow morning, okay? Okay. Counsel, does anyone want to put anything on the record right now?
Yes, Your Honor, there are a couple of issues we would like to raise.
Okay.
Your Honor, in the anticipation that the state is going to rest tomorrow, we have noticed that the defense is going to call some witnesses. The defense has provided a somewhat lengthy list of witnesses that I believe would be characterized as 404A1 witnesses or character witnesses. I got note of at least probably 12 witnesses. I just wanted to note this is essentially a prospective motion to prohibit needless cumulative evidence of 404A character evidence. So far, we've heard from Johnson, who's elicited a character opinion, Fleslin, who's issued a character opinion supportive of the officer, Sergeant Peterson, who's also been offered a character opinion. I, based on the discovery, anticipate that Colleen Fricke will share one, and then also former Chief Gannon. That would be 5 to date. That would be notwithstanding, I think, the 10 pending based on their witness order. The court has heard the needlessly cumulative objection raised by the defense, I guess repeatedly since the trial began, and the court has sustained some of those objections. Here the shoe is on the other foot. At this time, the state is objecting to the defendant's apparent intention to present additional character evidence beyond that of Fricke and Gannon's. At some point, Your Honor, and we think it would be after Gannon's testimony, that would constitute the needless presentation of cumulative evidence. We're bringing this up prospectively now because, given the abundance of witnesses, I think that if the court properly guides the defense, they can have their choice as to who among them they would want to call if they chose to go a different direction. You have not seen and will not see the state attempt to contradict these opinions shared. Repeated testimony along the same lines illuminates nothing further, and it's an improper effort to bring a chorus on these issues where I think soloists have already done the job. At some point, such testimony has no probative value. It's duplicative, and the state's position obviously is, after Gannon testifies, 5 is enough. When we have addressed these issues of cumulative evidence so far, the state has referenced to State v. Amos. That would be at 347 Northwest 2nd, 498. That's a Minnesota Supreme Court case of 1984. Essentially, in that case, a party decided they wanted to parade a bunch of witnesses into court to testify that a particular location was notorious for drug dealing and gambling. The court allowed 3 witnesses to provide such testimony, but after that did exclude further testimony as being needlessly cumulative. Here we have the same point. We have heard from these witnesses. The state is not even objecting to the defense calling Fricke and Gannon for those purposes, but at that point it seems like the point has been made and that the court is certainly within its discretion to exclude further character evidence. There isn't perhaps a 404A1 case directly on point, Your Honor, but there is a case within the Spriegel realm. I'd reference State v. Washington. That's 693 Northwest 2nd, 195 at page 203. In that case, the Supreme Court noted that it was proper to limit Spriegel evidence at a certain point to reduce the risk that juries will become fixed on it and will blur the lines between evaluating the elements of the offenses charged and simply the evidence of the defendant's character. I think that it's right for the court to consider that, and I do believe that it's timely, although a bit prospective, for the court, for the state to raise that motion at this time. That's the state's first motion with regard to this. I believe the state has 2 other 404A1 motions. We could hear this first, or I could give it to you all now. Which would you prefer?
Okay, I would like the defense to respond at the podium. Mr. Ng, how many character witnesses are you intending on
Well,
calling?
we're not going to call 12. We had 5 scheduled for tomorrow. Sam Smith, Lisa Thies, Ann Curtis, Frank Roth, and Tom Hall. We were going to evaluate when they got in how many we were going to use. I'm somewhat sensitive to their claim, although I'm somewhat insensitive to the idea that the state has been efficient in their presentation. I find their presentation to be entirely redundant, and so the claim here that we can't spend 15 minutes on some testimony doesn't resonate with the defense.
Well, it's good to hear that you're not going to be calling 12.
No, of course not. And the police officers were fact witnesses.
Mm-hmm.
They happen to know
I'm
her.
talking pure character witnesses.
For pure character witnesses,
Okay.
we have 5. I may not call all 5. Those are the pure ones. That's the only reason they're here.
Okay. Are they all 5 of them going to say the same thing?
Well, I'm constrained by your ruling as to peacefulness and law-abidingness. Yes, I know her. We met her. I've known her since childhood. I've known her for 5 years, 10 years. That sort of
Okay,
thing.
pick 3.
Pick 3. We will do.
All right. Okay, anything else? Oh, I think you had another motion. Okay.
I would note, Your Honor, depending on which 3 the defense calls, we may have no discovery from any summaries of any statements made, so I wouldn't make any demands of any statements made by those witnesses, respectfully. At this time, this, I guess, motion pertains strictly to Officer Fricke and Tim Gannon, who are apparently prepared to provide character opinions. So I don't know whether they are included in this group of 3 that
They
the
are
court
not
talked
included.
about. Because Tim Gannon is not a fact witness, Your Honor. But at this time, the state moves to limit the opinions of Officer Fricke and Tim Gannon to those specifically permitted by the court. And I know that we just went over, Mr. Eng went over what he believes the court's ruling was with regard to what pertinent traits are relevant in this case. That would be law-abidingness and peacefulness. In the defense interview with Officer Fricke, though, additional opinions were laid out that I think are beyond the scope of the court's ruling, and I'll just list things such as patient with suspects, unfailingly polite, treated everyone with respect, devoted to victims of abuse, had a reputation for honesty. For admissible 404 opinions, I believe Officer Fricke has opined that there is a willingness to follow the law and something about being a good police officer. The state is asking the court to limit her opinion to those only which are admissible. The others seem obviously outside the scope of the court's prior ruling.
Well, Officer Fricke works for Brooklyn Park now and was an officer for Brooklyn Center for almost 15 years and worked with Officer Potter. Officer Potter was her mentor and partner in many shifts, and the witness summary discussed what it was like to work with her. What would she like as a police officer? And so I certainly will respect your ruling on law-abidingness and peacefulness. I'm not going beyond that, but she can describe what it was like to work with her. In fact, she was asked to stay with her after the incident because she had worked with her, and she was specifically asked to stay with her for the duration. So that's the context for that.
Okay. Could I get the witness summary for
I
her?
think they gave you the summary.
All right. I don't know if I still have it. Could I get another copy?
Sure, Your Honor, we can probably get that back to you.
Okay. All right.
I do appreciate Mr. Eng's comments, and I guess I wasn't expecting bad faith, but I certainly thought it was worth making a record of this. General background information that would form the foundation for her to elicit that opinion is certainly sufficient. Where I think that there can become issues is when someone preparing to elicit a 404A1 opinion goes extremely specific in describing the background, which essentially accomplishes the prohibited goal of talking about specific instances. So I'm going to take Mr. Ng at his word, and we'll just act accordingly. Lastly, Your Honor, obviously Ms. Potter's under no obligation to testify, but there were some of these individuals who opined with regard to truthfulness. Truthfulness is obviously not a 404 opinion. That would only come in pertinence after she testifies, after her credibility is attacked, and it would come in under 608A. That's all with regard to 404 issues, I believe. But, pardon me.
There was one other issue that was not a 404 issue with respect to character witnesses that we'd like to address, Your Honor.
Okay, please go to the podium. First of all, let me just say that specific instances of good conduct is not going to be admissible under 404, okay? Character traits only.
I appreciate that, Your Honor. I think just to dovetail off that, obviously, Commander Flesland was asked some questions about whether Ms. Potter was a good cop, and he said she was a good cop and a good person. We objected. That was on the record at sidebar, but whether someone is a good person is also improper character evidence, so we would continue to object to that.
Yes.
Stemming from that as well, when it came to Commander Flesland's testimony, raises another issue. Obviously, the state had briefed a motion with respect to potential bias, union membership. We argued that motion to the court. That was yesterday, I believe. After we argued that motion to the court, however, was when Commander Flesland was called. Commander Flesland was called, and then on cross-examination, defense counsel elicited testimony directly from him about the scope of union work that Ms. Potter did, her role as a union steward. I had pulled some of the testimony, but the questions were essentially about negotiating a contract, but then there was follow-up questioning about additional duties beyond negotiating contracts. Mr. Gray asked, what else would that be? That included representing officers and detectives in the bargaining unit, helping negotiate if they've been wronged, and potentially go down the grievance route for something like that. The union stewards help them navigate that process. It's our position, given the testimony elicited by defense counsel in this case, that they have opened the door clearly to any potential cross-examination on our behalf of their witnesses when it comes to bias, union membership, and union affiliation.
Would the defense like to respond?
Well, Your Honor, I'm not quite certain being a member of a union shows bias. I didn't expect the answer that I got when I asked Commodore the question about the union. I believe that our client, just negotiated contracts. She didn't do much else. She will testify to that. I have a hard time believing that in this day and age, the state of Minnesota is accusing a union member of bias because she belongs to a union. It's hard to believe. But if they want to attack our client, because she's a union member, it seems way out there. It doesn't seem relevant at all. I mean, how many on the jury, how many people in our nation are union members? I think the public defenders are, county attorneys are. All kinds of people are union members. What does that mean? I mean, so you're the union steward. Would that mean you're going to take the stand and lie? I don't think so. And I think that's why it's improper to impeach somebody by, oh, you're a member of the union. Oh, she's the head of the union. That's not proper impeachment nowadays. Thank you.
Okay, I think the state's point was that with respect to defense witnesses, they want to be able to cross-examine and show that defense witnesses may be biased because of Officer Potter's former position as union president, I think it was.
That's correct, Your Honor. The state is in no way criticizing anybody for being a member or not being a member of a union. The issue goes directly to the heart of whether or not bias exists, and that relationship between each of these witnesses, each of these officers who may have used or relied upon the the defendant to help them through a grievance process, who looked up to her as president of the union, who went to her for advice, who, you know, she may have shepherded them through this process of addressing grievances, and she was essentially their advocate. That goes to bias between bias of each of the witnesses who testifies, not only to her character, but also whatever testimony is elicited through the defense direct. So not only is it bias with respect to anything that may come out if the defendant should choose to testify, but each witness who testifies about a relationship with Ms. Potter, there's a connection there that is deep-rooted, deep-seated. There is an established relationship, and clearly it's probative of bias for us to be able to ask questions about that relationship.
Well, it would only be probative of bias if Officer Potter actually represented any of these witnesses and had a close relationship with them because of her former position.
And Your Honor, just getting brief highlights of the testimony from Commander Flesland. His testimony was that they're there to represent the officers and detectives, or whoever is in that bargaining unit. They can help that officer negotiate if they've been wronged and potentially go down the grievance route for something like that. The union stewards can help them navigate that process. So that testimony was elicited by the defense. That shows that relationship and the assistance that Ms. Potter would have given them.
Okay. Anything further on that?
No. But what am I, one of the three character witnesses maybe a police officer, rather than a lay witness, so I've got it down to 3.
Okay. All right.
Judge, she wasn't the union member for most of these folks that are going to be testifying. She wasn't the union advocate in the first place.
Okay, you can bring that out on cross.
Yes.
All right.
I don't.
Okay. Mr. Frank or Mr. Larson? Okay.
You've already argued something in chambers, Your Honor. I was just going to ask whether the court has made a ruling on Exhibit 1002.
What's 1002?
Can you refresh the court's recollection?
Yeah, please.
I believe it was yesterday, defense counsel shared with us a short video from a time frame when Officer Potter and Officer Fricke were at the Brooklyn Center Police Department. Need I say more?
Yeah, I remember. I did review that video, and I'm not going to allow it. She can testify as to what her interaction with Officer Potter was, and I'm doing that because it really isn't relevant to the issues in this case. So, but I'm not going to restrict her from testifying about it. Okay. All right. Mr. Frank?
Your Honor, I think this is the last thing we have, and we just thought we should raise this with the court now so it doesn't come up tomorrow as we're trying to move through the testimony. And Your Honor, we, I think, have provided the expert reports to the court for your review. I believe I heard Mr. Eng in opening say that Mr. Imes will testify, their use of force expert, about deadly force. And if I misheard him, I apologize, but because I'm not certain about it, I wanted to raise it. Now, there is nothing in Mr. Imes' report about the use of deadly force, and so we would object. The disclosures were required months ago. Nothing in that report about the use of deadly force, as our witness testified about. So we believe that that is not proper testimony from him. We just wanted to raise that with the court now so the court's aware of it.
Okay, Mr. Eng.
It's permissible for the expert witness to review evidence as it comes into the case. I've asked him to review the testimony of, in particular, Sergeant Johnson and Officer Lucky. I've also asked him to review the testimony of Mr. Stoughton today, particularly as to the reasonableness of the force and his analysis of the dangers inherent in the setting, and to agree or disagree with Mr. Stoughton. So this is new evidence that was not available. The testimony certainly wasn't available. I've asked him to review that for the purposes of either agreeing or disagreeing, and that's what an expert does. So that's what I'm going to ask him to do.
Okay. Why wasn't that his opinions disclosed earlier?
Well, the initial opinion was that the taser was appropriate to be used, and then as the evidence developed, we've asked him to keep an open mind about it, and our assumption is that there would be new evidence at the trial because, first of all, we don't know exactly what they're going to say. And the Johnson testimony was extremely significant, and he didn't have that. And, one of the cross-examinations of Stoughton was he didn't have the Johnson testimony in his original report either. So the newness of the evidence is what we're going to ask him to look at.
Okay.
Yeah.
But of course, Your Honor, is this microphone going to be okay, or do you want me to?
I think the court reporter can hear, yeah.
We have absolutely nothing from Mr. Iams about the use of deadly force. So to say this is new evidence means he's creating a new opinion that wasn't disclosed as it was required to be. The Iams report is, I'm sorry, I don't have it right here in front of me, 4 or 5 pages long. It's very scant on its support for its opinion anyway, but now to add a completely separate opinion about the use of deadly force is just, we just had no notice about it as the court ordered. So we maintain our objection to any testimony about that.
Well, I'm duty bound to talk to my expert. I plan to do that in about a half hour if I can get out of here. And he's downtown right now. And I will disclose the nature of the conversation that I have with him immediately. But I'm a duty bound to ask him what his analysis is of the testimony that he's seen. So, that's my obligation as a lawyer for Officer Potter to see what he says now, particularly about the Stoughton testimony and the analysis of it. He's certainly free to disagree with another expert's testimony. And they know that.
Okay.
It's a discovery violation, Your Honor.
Let me think about that one, okay, and I'll let you know immediately. In the meantime, you'll make an immediate disclosure as to his additional opinions on deadly force. Okay, so I'll take that under advisement. And anything else before we...
Well, if I could go on for private matters.
Okay. Okay, is there anything else, counsel? Okay, counsel, have a good night, okay? And drive safely tomorrow morning. I think it's going to be really icy.